Roger, when are you leaving the court? Hmm? No.
ನಮಗೆ ಗೊತ್ತಿದೆ ಅಂದ್ರೆ ನಿಮ್ಮೊಂದು ತಕ್ಷಣ ಯಾಕೆ ಮಾಡಿ ಬಿಟ್ಬಿಡು ಹೋಗ್ತದೆ ಸುಮ್ಮನೆ ಹೋಗ್ತಾ ಇಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಸೋ ಸಾಕು ಈ ಗ್ರೂಪ್ ತಗೋತಾರ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ
ಸಬ್ಮಿಷನ್ ಮಾಡೋಂಗಿಲ್ಲ.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು ಲೀಸ್ಟ್ ಆಗಿದೆ
ಕ್ಲಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂತಾರೆ.
ಸರ್ 2010 ಮ್ಯಾಟರ್
ಹೇಳಿ ನೀವು ಕ್ಲಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅವರು ಫೈಲ್ ಹಿಯರಿಂಗಿಗೆ ಮೆಮೊ ಮೂವ್ ಮಾಡೋಲ್ಲ.
ಫ್ರೆಶ್ ನಾಳೆ ಅವ್ರು ಕೇಳಿದ ಡೇಟು ನಾನ್ ಕೇಳಿದ್ದು ನಾವ್ ಹೇಳಿದ್ದಲ್ಲ. ಅಯ್ಯೋ ಯಾವ್ದೋ ಕಾಂಪ್ರಮೈಸ್ ಹಿಂಗೆ
ಬಂದ್ಯಾರ
But vacating application within 3-4 days we'll give a date for vacating. Fresh matters you give tomorrow. Fresh matter will
fresh matter. The suit is filed for
fresh matter
permanent. The case is posted for judgment on 10th.
fresh matter. If it is not posted before the court first time, you give it any date if you want, except 2:30 we'll post it.
My lord, this fresh matter, my lord, it may be taken up tomorrow.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದೀನಲ್ರಿ.
Tomorrow. Fresh second.
For partition, application for interim for non-alienation pending. The respondents they have also appeared before the court, your lordship. Court is not willing to pass any orders on the application. That's the end of the list. They intend to alienate all the properties tomorrow, your lordships.
Tomorrow, end of the list.
My lords, this matter, my lords, are posted on Monday. This is that matter was covered by the full bench judgment, my lords, Succession Act.
Yes.
My lords had asked me to get the full bench judgment.
Yes.
The other side had asked for yesterday, my lords. Yesterday the matter, my lords had indicated it will be listed in fresh matters. Yesterday it came up in B group. Matter has not been taken up. Today the matter is before the trial court, my lords. I was pressing for stay, my lords. I'm requesting if my lords can, I already informed the other side. Can it be had at 2:30, my lords?
No, tomorrow. Yes.
My lord, only one request. Can it be taken in fresh matters list? Because B group reach Aktala. That is the only request. Because my lords were inclined to grant stay. My lords, he said, give me 2 days time, I'll come back. Because it's covered by the full judgment. The difficulty.
Let us see tomorrow. Yes, tomorrow. Yes. That if it not reached at the end of.
I'll mention it. 4 o'clock.
The petition is a degree holder. The petition is filing an application in 151 for police protection. Said application was rejected. But the decree was in compromise suit. Suit for specific performance. Some urgency in this matter, they have DHR, they have trouble to the petitioners.
Tuesday.
My lord,
Filed an IA, my lord, for consideration of interim prayer. Yesterday matter was listed, my lord, it reached, my lord. There is urgency, my lord, strength is for defendant evidence, my lord. Condemnation of delay of 6 years, my lord, has been condoned, my lord, without any reasons, my lord. And some speaking, my lord, 10th is the next date for defendant evidence. Lord, yesterday the matter was listed, it reached, my lord.
10th, yes.
my lord, for final hearing, my lord. This matter was posted for final hearing on last year, February, my lord. And 4 weeks time was given finally at the request of the petitioner, my lord. Thereafter, the matter was not listed, my lord. Kindly have it for
I thought next week alone date.
on date.
Tomorrow, 7th.
What is that urgency?
The adjournment application was rejected.
Yes, next week alone.
My lordship,
14. Yes.
my lordship, serial number 79. Last week, your lordship has mentioned no adjournment would be given because they had taken the adjournment for IA for vacating stay. Kindly take it up 2:30, my lordship. 79. Your lordship has mentioned no adjournment would be given last week. The opposite counsel, petitioner counsel had taken adjournment at 1:30. Your lordship knows that.
Yes, it is posted today.
Yes, my lordship.
Wait, when the list.
79, my lordship.
Page wise adjournment, list number 1, page number 1, serial number 1 to 4. Page number 2, serial number 5 to 15. Page number 3, serial number 16 to 26.
Serial number?
Sir, mic use ಮಾಡಿ ಮುಂದೆ ಬರ್ರಿ.
Serial number 20 melon.
Yes.
Senior counsel engaged in Dharwad melon.
Counsel for
11th melon. 11th.
Please this matter next week.
11th melon. Kindly melon. 11th or 12th melon.
Let us see, let us see.
Page number 4, serial number 27 to 34.
Serial number 30, my lord.
Serial number
30, my lord.
30.
We are yet to get the information regarding the construction of the site, my lord. So matter may be posted next week, lord.
You are appearing for respondent.
Respondent.
Have you informed petitioner?
I'll inform them.
First you inform and mention. Yes. 30? You are appearing for petitioner at the request of counsel. 14th. Yes. ಅದು ಒಂದು ಬೆಳೆ 14th ಹಾಕಿ ಇನ್ನೊಂದು ಕೇಳಿದ್ರು.
ಇನ್ನೊಂದು 4. Page number 5, serial number 35 to 46. Page number 6, serial number 47 to 49. Page number 7, serial number 50 to 54. Page number 8, serial number 55 to 60. Page number 9. ಹೇಳಿ ಎಷ್ಟು?
Lordship, serial number 30, it has been informed to the petitioner.
Serial number
30.
30.
Yes, lord. It has been informed to the petitioner.
You are appearing for respondent
Yes, lord.
at the request of respondent. Is this matter? 2 weeks, yes.
Obliged.
Page number 7, serial number 50 to 54. Page number 8, serial number 55 to 60. Page number 9, serial number 61 to 64. Page number 10, serial number 65 to 69. Page number 11, serial number 70 to 74. Page number 12, serial number 75 to 79. Page number 13, serial number 80 to 83. Page number 14, serial number 84 to 89.
84, my lords. Other side is also present. 84, my lords. I am for the petitioner. 2 weeks time may be granted, my lords.
Yes, at the request of parties, leave this matter. 27th.
Please, my lord. Interim order may be extended.
Interim order granted earlier is extended till next date. Huh?
My lords.
Yes, 2 weeks are granted, yes. 21st ಆಗಲ್ಲ, 26th or 25th, yes.
Page number 15, serial number 90 to 96. ಹೇಳಿ.
Serial number 46, 2 weeks time maybe.
46, wait, Mr.
Page
Serial number 93, your lordship. I appear for the petitioner. We have informed the other side. I seek
Yes,
for
at
a
the
week's
request
adjournment.
of petitioner, leave this matter. 2 weeks.
90. 90.
Yes.
90,
ಎಷ್ಟು? 93.
93,
90,
93, yeah.
yes, 92.
Lords, in serial number 88, my lords. For petitioner, my lord. Counsel is unwell, my lord. 1 week's time may be granted, my lord. Serial number 88.
To inform other side,
Yes, my lords. Other side is informed.
informed at the request of petitioner, leave this matter next week.
Interim order may be extended. my lord.
Interim order granted earlier is
88.
extended till next date of hearing.
Page number 16, serial number 97 to 104. Page number 17, serial number 105 to 111. Page number 18, serial number 112 to 118. Page number 19, serial number 119 to 121. List number 1 for preliminary hearing, serial number 1, Ravi Shankar R for petitioner.
Petitioner. Ex parte interim order granted, my lord, without any reasons whatsoever. Please see. And Lord, one statement which is made is also wrong. One statement made by the learned judge.
Yes.
Please see page 29, Lord, which is the
Good for,
suit for declaration of title.
yes.
Also, my lord, to declare that some grant made in favor of my erstwhile vendors is not binding on the plaintiff.
Yes.
It can't be not binding on him. If there's a grant, there is a grant. And the grant not on the basis on which various sales have been
You
executed.
file an vacating there.
No, my lord, but I'll tell you what the problem is. Please see the order, my lord.
Yes.
Page 29. First line, Lord, after heard,
Yes.
it says revenue documents are standing in the name of the plaintiff, which gives an inference as per section 133 of Karnataka Land Revenue Act. On going through the plaint, so and so, the reason of apprehension of suit schedule property being sold in favor of third person, there is also instant threat of changing the nature of the suit property, interference by defendants in the possession of the plaintiff of the suit property, If temporary injunction is not granted as sought for, there's possibility of rights and therefore injunction is granted. Now, please see, note this first sentence is revenue records are standing in his name. There's not a single revenue record standing in his name.
No, that's okay. You go and file
No,
an
but-
application for
But
vacating.
your lordships have held not consistently that if no reasons are given while exercising power under Order 39 Rule 3, that order has to be set aside.
No, that can be vacated also.
No, it can be vacated.
Yes,
But
that is,
but may I just point out one judgment, your lordship must have already seen it, in Vedant fashion, which also is subsequently up. Last page. Ink page 130. Last
Yes.
judgment.
yes.
Page 132. My lord may kindly come to the bottom of the page.
Yes.
132, after extracting 39(3)(a,
Yes.
a bare reading of the said rule makes it clear that normally the court, before granting an injunction, direct notice of the application to be given to the opposite party. Exception is where it appears that the object of granting injunction will be defeated by delay. In such an event, the proviso which has been inserted with effect from 1-77 comes into operation, where the court is empowered to grant an ad interim injunction dispensing with notice, provided reasons are recorded for its opinion, to the effect that the object of granting the injunction will be defeated by delay if notice is served on the respondent. Impugn order is extracted supra in order to ascertain as to whether the trial court had complied with the requirements of the proviso while dispensing with the notice to the defendant while granting an ex parte or temporary injunction. From a reading of the impugn order, it is clear that nowhere reasons have been recorded as to why the trial court was of the opinion that injunction had to be granted by dispensing notice to the respondents, or that non-grant of an injunction would be defeated by delay if notice is to be ordered on respondents. Impugn order is bald, laconic, and bereft of any reason. Trial judge has not even made a brief reference to the facts of the case to arrive at a conclusion that there's a prima facie case of consideration and about balance of convenience being in favor of the plaintiff, and whether she would suffer any irreparable loss in case of refusal of ex parte injunction. Mechanically, the impugn order has been passed. In that view of the matter, impugn order has to be quashed on the short ground of there being non-compliance with Rule 3 or Order 39. It is noted from the impugn order the next so and so. Keeping in mind, we direct the trial court to dispose of this judgment. My lord, then placed before a division bench of this honorable court.
Yes.
In my lord, if my lord kindly comes to page number 34, I'm sorry, 39. And the relevant portion, my lord, is at page 63. Well, considering the question of reasons,
Yes.
please see para 34, my lord.
Yes.
The position is no more res integra. This court in a judgment authored by Ladyship Mrs. So-and-so in the case of Vedant fashion has categorically observed and held as follows. At para 9 and 12, the same paragraphs have been extracted.
That is true. That language is very clear under that provision.
No,
They
no,
have to
but,
given a
but this
finding.
court has held consistently, I have at least 10 judgments with me
Yes.
where reasons are not recorded in writing, and Lord, there's a challenge to it. You know, lordships will interfere with that order.
Even vacating also can be done.
Not
that.
vacating your lordships, no, my lord. Now we have to go back to that court and.
Otherwise, in all suits where temporary injunction has been granted, in courts as passing in single order or single line saying that maintain status quo, injunction.
They are
and all.
supposed to do
Then
it.
all
My lord,
will be rushed
in
to
some
here.
cases, my lord, we may not come to court. But in
Yes.
some cases like this, my lord,
No, no,
because-
what is that ex parte injunction order has been granted?
yes,
It's
but all
like by
applications have been allowed. All applications have been allowed.
putting that should property, changing the nature of the same, interfere with the peaceful possession.
Possession.
nature.
And we are in possession of the property from the year.
But you should not alienate. That will
Okay.
clarify.
Alienate will not.
Yes, it will create third party interest.
Okay.
Yes. Heard.
You don't
You
even
notice
two things to do.
stay of order dated 4/2/2025 passed by which court, Mister? First additional senior civil judge JMFC Devnalli in OS number 163 of 2025 on IA number 2 of
2 to 4.
2 to 4 of 2025, subject to condition. Petitioner shall not create third party interest in respect of suit scheduled property till next date of hearing.
Well,
Yes.
great.
Serial, serial number 2, Jayant V.
Business counsel. But here the grievance, my lord, is that
Yes,
in a suit for partition, my lord, of my mother's property,
yes,
it is the suit is not between the children.
yes.
Mother died intestate in 2022.
Hmm.
There is a threat of alienation, my lord. The trial court, my lord, without reason just says issue notice. But the whole object of the suit of partition, my lord, would be defeated.
In fact, my lord, I have pointed,
By temporary injunction order you sought,
not that, not to alienate, my lord. Your lordship would have a look at, not,
cancelled.
yes, my lord. Page 32, my lord, is my application which I had filed.
Yes. Parties are directed to not to create third party interest in respect of petition scheduled property till next date of it.
Great.
Yes.
Serial number, serial number 3, Prashant L. Kanal.
Yes.
Permit me to appear for the petitioner. But suit is not filed for declaration, not done to challenging not certain sale deeds.
Yes.
Not one, not Venkatramanappa, not claiming to be not the owner. He gets a mutation done in his name.
Yes.
There is no order for mutation, etc. Lord. However, Lord, his name is entered in the RTC.
Yes.
But this enters into Lord the revenue dispute.
Yes.
But can I just request, Lord, please turn to Lord Annexure D, page Lord, relevant page is page 89. But what he does is, Lord, I am the owner of the property. Now, Lord, he Lord makes an entry from Lord some other mutation. But RTC entry is done in respect to my survey number.
Yes.
Please turn to page 89, not second paragraph.
Yes.
Thus, before arriving at a specific decision in the matter, as rightly pointed out by the learned civil judge, it is necessary to find out the genuineness or otherwise of the entries made in the name of Thayappa. Thayappa not is his father. In the revenue records as per MR number 7 of 8586,
Yes.
as per INA numbers, when under RTI, the endorsements have been issued that no such records are available.
Yes.
In these circumstances, the order of the Assistant Commissioner, Bangalore North Division is set aside. In furtherance, mutation effected as per MR number 7 so and so, name of Sri Thayappa as well as the name of the respondent so and so are set aside.
Yes.
In furtherance, it is ordered to restore the kata of the land in survey number so and so in the name of Sri C. Narasimha Iyengar. That is not my family.
Yes.
Further, keeping in view of the observation made by civil judge in so and so matter remitted to special Tahsildar, Bangalore North Taluk, Bangalore with a specific direction to issue notice to all parties, procure the records pertaining to conferment of occupancy rights in name of Thayappa as per so and so. Endorsement date to examine the genuineness otherwise of the same, as well as examine the records to be produced by the petitioners with regard to the respective claims of the land. But this order was challenged not by them before this Honorable Court. Page 90 is the order.
Yes.
Now, this Honorable Court not declines to interfere. Page 95 not is the operative portion. Court
Yes.
says it's a matter of remand. I am not going to interfere.
Yes.
Now, Lord, after which, Lord, he approaches not the Tahsildar, Lord, challenges not the order. There again, Lord, he loses. That order is attained finality.
Yes.
Now, Lord, I also approach Lord the Assistant Commissioner.
Yes.
Lord, at page 208, Lord, is the order.
Yes.
Where, Lord, the at page 213 is the operative portion.
Yes.
Lord, where the court, the Assistant Commissioner directs Lord mutation in my name.
Yes.
Now, Lord, this order, Lord, has been challenged by them and there is a stay order. Be that as it may, Lord, I have filed a suit from Lord for declaration and Lord for Lord declaration that the sale deeds are null and void. What Lord this man does is,
Yes.
despite having no title, Lord, he sells the land in favor of third parties. But I filed the suit seeking for declaration.
Yes.
I am not for permanent injunction, etc. Lord, located at page Lord 114, Lord, is the plaint. Lord, the prayer, Lord, should get it at page 150. Lord, various third party rights he creates at page 150 is not the prayer.
Yes.
But earlier I filed suit for injunction. Thereafter, Lord, this Venkatramanappa, Lord, son of Thayappa, he says, Lord, I have no right now. I have sold the properties.
Yes.
So I withdraw the suit with liberty to file a fresh suit. Not fresh suit is filed. But this is not the prayer in the plaint. But I also seek for an order of temporary injunction, page not 154, not is my application. The prayer note is at page 172. But saying that not they should not put up any construction in the property.
Yes.
Otherwise, less third party rights are created.
Yes.
But however, not the trial court not only not issues emergent notice, not does not grant me an order of injunction. Now, Lord, what has happened is not I have to point out to the court, Lord, that sometime I waited with the fond hope that Lord notice will be served. I'll argue, but not because there are several people. Notice is not being served. No, I am not made to suffer because no, they started putting up construction in the
What
property.
is your apprehension? They are going to alienate.
No, Lord, they're putting up construction, Lord, and Lord, of course, some of them are already alienated. Lord, I do not want Lord further alienation. But here, Lord, now, as of now, Lord, they should not put up further construction.
Construction is subject to the result. If the
Lord, what
construction, they will
happens
lose
is,
it.
Lord, no, Lord,
If
what
they
is,
succeed, you will get it back.
no, Lord,
But
what happens
alienation
is,
will stay that should not create third party interest because it will affect. Any construction is subject to the result. See, suppose if you fail,
Please, my lord.
then you will compensate that loss which is occurred for non-construction and all.
My lord, what happened?
Can we construct?
But can I make one suggestion, my lord? Can I request my lord to direct parties to maintain status quo?
No, status quo, again, he cannot construct.
Then again, I'm not allowed now to enter upon my own property because total extent about 3 odd acres. But some of them have purchased the land. Nan jaga hogoku bidta illa.
No,
The
that is what
difficulty is that.
will, after hearing, the parties will say that. Now, they should not create third-party interest. Construction and all, we can't stop. Tomorrow, if that writ petition is fails,
Please, Lord.
then they will cause a loss if there is a middle of the construction and all, unless we hearing that other side. Presently, we'll protect you not to create third-party interest.
My instructions are not even the appeal that they had filed, not other side had filed, not against the order of single judge. That has also been dismissed.
No, that is true.
Ultimately, not
At present, only apprehension is that they are constructing and they are alienating. Constructing, by construction, they will not get anything. If they unsuccessful, they have to give up that. Creating a third party, again, you have to implement and all. That will stop it.
injunction. That's what, sir. Please, Lord, may say so. Injunction could the status quo,
Yes.
not to alienate.
For the position where you are there, we are not to obstruct.
And they did not allowing me to enter the place.
How can they?
That is
If
what.
you are there, they cannot be. When you have filed in a suit, they can't say that. Then it shows
Very
that your position is doubtful.
No, no, Lord, my position, respect of rest of the portion, there is no difficulty.
They don't have any injunction order. At least you
But they don't
filed
have
in a
any
suit.
injunction.
Yes. Or issue notice.
Not to.
Respondents are directed not to create any third party interest in respect of suit scheduled property. Till next date of hearing. Yes.
Lord, any construction that they put up, Lord.
Yes, any construction. They don't make it that. It shows that their admission in that position. Tomorrow they will take that advantage. Then we are in the position, don't grant injunction. Don't take that. Anyhow that if there is any construction, they can't claim any equity. That's there. Yes.
Very well.
For Rama Bhatt K.
Petitioner is the plaintiff. Before the trial court, filed application order 6274 amendment of the plaint only in respect of survey number. The
Yes.
plaint schedule survey number 30/1B instead of 35/1B.
Hmm.
That has been noticed only at the time of argument, reached up to that stage.
Hmm.
In the plaint arguments, evidence, documents, everything is 35/1B.
Hmm.
This is a typographical error not noticed by the plaintiff nor the advocate, not even the court or the other side also.
Hmm.
Nowhere is there a dispute. That's why I filed the application just to make a correction in the survey number that came to be rejected.
Why? Why it is rejected?
Rejected stating that it is belated and para number 13 at page number 29, my lord.
Only want to
Only survey number, no further evidence, nothing.
or issue notice. Stay of further proceedings in OS number 45 of 2018. Pending in the file of Principal Senior Civil Judge JMFC, Durga. Till next date of hearing.
Please, my lord.
Serial number 5, Govindaraya Kamath K.
Your lordships will see page number 10 where my prayer is found. Sought for a direction to the trial court.
Yes.
To release the judgment which was reserved on 12/8/2024. Lord, it's been 206 days since the judgment has been reserved. Lord, in Anil Kumar Rai, the Supreme Court had set out guidelines for pronouncement of judgments to constitutional courts. There, the Supreme Court had said that 3 months is the deadline for pronouncement of judgment.
Yes.
If the constitutional courts do not pronounce within 3 months, then you file an application for your early hearing.
Yes.
If it's not pronounced within 6 months, then move the Chief Justice's court and seek for change of bench. The Supreme Court has said this in 2001.
Now, why that bench is not sitting?
Lord, it's sitting. Lord, please see the order sheet. Lord,
Yes.
please see the order sheet. Your lordships will find it at page 61.
Yes.
Please see 12/8/24 is when
Page
61, Lord.
Yes.
Please see page 61, 12/8/24. On the previous date, extensive arguments were made, Lord.
Yes.
12/8, only some memo was given. On that day, judgments are reserved. Please see the order. Heard further arguments of both sides for judgment.
Yes.
From 12/8/24, at least 13 times this matter has come. The petitioner is an 87-year-old lady, my lord. fighting a partition suit against her sons. She just wants to see the outcome of this litigation. On all dates, she goes before the court, waits for the pronouncement, waits till the end of the day. There is no pronouncement.
Yes,
13 dates, my lord. This matter has come up.
yes.
Lord, there is some background facts that I have to give your lordships.
Now we will see that this is an administrative side.
Lord, there's one more judgment, Lord. Some direction has to be given to the courts, Lord. Please see.
Yes.
But please see this judgment. I have one. Do you have Anil?
Which is the court?
Lord, this is court hall number 70. Lord. Lord, suit is of the year 2018.
When it is resolved?
Lord, it was reserved on 12/8/2024. 206 days have passed since judgment has been reserved.
Yes. 12/8/2020.
12/8/2024
Yes.
is when judgment was reserved. Lord, there are two orders.
Yes.
One order is when in the very same suit, plaintiff had obtained an ex parte ad interim injunction. Court had said,
Yes, we'll get that in.
Lord,
Madhyana 1:30. Yes, pass on.
matter may be disposed. Yes.
Yes, let us see. We'll get that in.
Lord, there's some background facts which is
Yes.
why I have to tell your lordship.
No, it is not necessary, Mr. We'll see that what is that happening that we'll get it that instruction from them.
No, Lord, what they will respond is there is another injunction suit. That's the background I have to give your lordships.
Yes.
So this partition suit, I am the defendant in the partition suit. Partition suit was filed seeking partition of 6 properties. I am the defendant, Lord. One of the property, suit schedule property 1, was also subject matter of an injunction suit, which
Yes.
was filed 2 months before this suit. So there is commonality of properties in the injunction suit and the partition suit. Injunction suit and partition suit were consolidated by an order of the principal city civil judge on a transfer petition. He said because they both the suits, the injunction suit and the partition suits, were being tried by 2 different courts, there is risk of conflict of judgment. So an order is passed transferring both the suits to one same court in 2019. From 2019 to 2024, both the suits, my lord, have come before the same court on the same date. Matter was argued together. Both the suits, injunction suit and partition suit, judgments was reserved on 12/8/2024.
Both has been resolved.
Yes, my lord. Now please see what happens after that. Injunction suit, partition suit, both are reserved on 12/8/2024. Lord, there it was argued, since title is an issue in the partition suit, and in the injunction suit, it was a bare injunction suit. Whatever happens in the partition suit will determine the outcome in the injunction suit. If you hold that the property is joint family ancestral, then injunction suit will be decreed in favor of the plaintiff. If my defense that it's my self-acquired property is accepted, his injunction suit will also be dismissed. So injunction suit was to be decided consequential to what happens in the partition suit. Shockingly, my lord, 2 months later, the trial court decrees the injunction suit. First, it holds that the plaintiff is in possession. Title is an issue in the partition suit.
No, now there is no bar for pronouncing the judgment.
There is no bar at all.
Yes, we'll get that. Yes.
Please, my lord. I'm so grateful.
Yes.
Serial number 6, M.N. Satyaraj.
For the petition, my lord.
Yes.
First respondent claims that he has purchased the property, scheduled property from one Chikegowda, who claims the title from Dasegowda,
Yes.
the uncle of the first petition, my lord.
Yes.
The dispute is between the sons of 2 wives of 1 person. Marigowda had married 2 persons.
Yes.
The respondents 2 to 4 are the children of first wife, and
Yes.
petitioner number 1 and 2 are the sons and children of the second wife, and she is the third respondent, the third petition, the second wife, my lord. The thing is, the first respondent files a suit stating that he has purchased the property from so and so, and he files suit for possession and declaration. And in that suit, the second, in that suit, all the 6 persons are made as parties to the suit. Your lordship gets the copy of the judgment at annexure B, my lord,
Yes.
page 18.
Yes.
The second respondent is Jayalakshmi.
Yes.
She is examined as PW1 in the suit filed by him. She supports the plaintiff there. She is not a defendant. She cannot get herself examined as DW1.
Yes.
She supports the plaintiff and got examined as PW2.
Yes.
And she supports the averments made in the plaint. And
Now
so
what
far
has
as
happened?
these
The
two,
suit is decreed.
a suit is declared.
And now it has been challenged in appeal, my lord, RA 12 of, there is a delay, therefore notices have been ordered. Now the execution petition has been filed. And now I have challenged that execution. And now the decree holder has filed an application for police help. Thereafter, now he has filed a suit, application for breaking open the lock. The case is posted to tomorrow, my lord. If they,
See, when the decree is against you, you have to challenge immediately, mister.
No,
Even after limitation, you are filing that. That means to say that you have no case at all, then what you have?
my lord, my submission was, since there was some talks of settlement between the parties, the local villagers were talking, therefore, there was some delay. Moreover, we are in personal property as the children of the Mari Gowda.
No, that is not the thing. They are obtaining the degree, but they can't enjoy that fruits of the degree. Then what is the
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಬ್ಬರು ಸವತಿಯರ ಮಕ್ಕಳ ಜಗಳದಲ್ಲಿ ಅವ್ರಿಗೇನು ಅಂದ್ರೆ ಇವ್ರಿಗೆ ಏನಾದ್ರೂ ಪ್ರಾಪರ್ಟಿ ಹೋಗ್ಬಾರ್ದು ಅನ್ನೋದು ಅಷ್ಟೇ ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ. ಅದಕ್ಕೆ ಅವರು ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇವ್ರು ಮೊದಲಿಂದ ಇದ್ದಾರೆ. ವೆರಿ ಪಾರ್ಟಿಷನ್ ಇಸ್ ಬಿಟ್ವೀನ್ has been disputed. Written statement file ಮಾಡಿರೋದು that has been stated in the judgment itself, my lord. Your lordship may get that page.
No, I am not hearing on RA.
Yes, ma'am.
It is only execution petition.
ಅದಕ್ಕೆ ಏನಾಗ ಒಂದ್ಸತಿ ಪೊಸಿಷನ್ ಹೊಟ್ಟಾಗ್ತು ಅಂದ್ರೆ ತಿರ್ಗಾ again we will be in trouble, we will be in soup, my lord.
You should have been diligent when you are challenging that degree. You could have approached early.
ಅಲ್ಲ ಅದೇನಾಗಿದೆ, since there is a delay, ಅವರು ಬರೀ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್
Delay ಇದ್ದಾಗ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ? Why you
ಅಲ್ಲ,
have?
of course it is a rule.
Now, what is that order passed in that execution?
Yes, my, I have produced the exhibit annexed D, my lord.
What is that order?
Page number 45, my lord.
40?
Page, your lordship. Typed copy note. 51, your lordship. Page 51.
ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
Reissue delivery warrant to JDR with police help if PF paid ಅಂತ. ಆಮೇಲೆ next counsel for DHR filed IA under section 151 CPC. The JDR pressed time for objections and to hear on 7/3. ಇದ್ರ ಮೇಲೆ annexed RC ಮೇಲೆ.
Yes. Heard. Issue notice. They have further proceedings in execution number 124 of 2024. Pending on the file of principal civil judge JMFC. Madhu till next date of it.
stay ಇದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಟ್ಟ ಅಂತ, ಯಾಕಂದ್ರೆ ನಾಳೆನೇ ಇದೆ.
Yes.
Serial number 7, Rama Bhatke.
Counter suit serial number 4, connected to serial number 4, my lord. Here I am the defendant. There is a counter claim. In schedule, there is a mistake of the serial number. Same connected with serial number 4.
Here you have filed a counter claim.
Please, I am the defendant here.
Yes.
ಅದೊಂದು serial number 30 ಹೋಗಿ 35 ಆಗಿದೆ. ಅದನ್ನ amendment application ಹಾಕಿ that has been rejected.
No, yes, ಇದ್ರಲ್ಲಿ suit for?
Suit for declaration. Both suits are for declaration injunction.
Both of them has filed.
ಹೌದು. They are in possession, some portion, according to me, according to them, they are absolute owners.
Both cases has been clubbed together.
Clubbed, please, madam. ಆಗ ಇದೆರಡು ಕ್ಲಬ್ ಆಗಬೇಕು, 7 and 4.
Yes, heard. Issue notice. They have further proceedings in OS number 207 of 17, pending in the file of principal civil judge JMFC Vasturga.
Call along with, maybe called along with
Yes.
serial
call
number
this
4,
matter
madam.
along with the serial number 4. Yes.
Interior model.
Serial number 8.
handle will be done.
Yes.
Serial number 4 and 7, ಎರಡು ಕೂಡ. Please.
Handle.
With the petition.
Yes.
Serial number 8, Wagisha N for petitioner, BS Sachi.
Yes.
The respondent number 1, respondent number 3,
Yes.
and other 2 sisters are the children of one Sita Lakshma. Sita Lakshma had one property and respondent number 3 purchased another property next to the property of his mother. Both the properties were clubbed together. Later on, Sita Lakshma, she executed a will in favor of the petitioners who are the grandchildren of respondent number 3.
Yes.
Later on, for family necessities, the said 2 properties situated in Ramanuja Road, Mysore were sold for to a purchaser. and through the proceeds, another property was purchased.
Hmm.
And later on, by taking a bank loan, that property was also developed.
Hmm.
Respondent number 3, without the consent of the petitioners, he sells the property in favor of respondent number 1 and 2.
Hmm.
Respondent number 1 is none other than the sister of respondent number 3.
Hmm.
Then later on, respondent number 1 and 3, they file a suit for ejectment, terming the respondent number 3 as a tenant.
Hmm.
And also made the petitioners as parties because they are in possession of the property. Subsequently, when the suit was progressed,
Hmm.
the respondent number 1 set up other 2 sisters and filed a partition suit subsequently in relation to the alienated properties, terming it as joint family properties. That is
where you got through will.
got through will.
Yes.
Then subsequently, we thought that both the suits have to be clubbed because will is there. In the earlier suit, the witnesses were examined.
Yes.
Then subsequently, we filed an application for clubbing and for transfer of the petition, transfer of the suits. That petition came to be dismissed, and a writ petition came to be filed before this honorable court.
Hmm.
Kindly, they say in the that is at page 139. And that petition came to be partly allowed by transferring the suit for partition to the court of suit for ejectment. But the suits were not clubbed, stating that since the issue raised in partition suit, that has got to be decided. If it is held that it is a joint family property, it has got a relevance on the ejectment suit. So this honorable court transferred both the suits and directed the trial court to proceed further by adjudicating the matter side by side by both the suits.
Yes.
Now, your lordship may kindly see this honorable court at page 145, para 5. In that view of the matter, this petition is disposed of, directing transfer of OS number, etc., which is pending consideration before the court of, etc. The learned second additional civil judge Mysore is directed to take both the suits together, and he shall first decide the suit in OS 551 based on the evidence already adduced. The findings recorded in 551 shall also be considered while disposing of 199.
Yes.
Now, your lordship may kindly turn to para 4, which is important. Why this honorable court came to that conclusion? After hearing the learned counsel for the petitioners as well as the learned counsel for the respondents, one thing is certain, namely the adjudication regarding valid execution of the will in favor of the petitioners herein is the subject matter in OS 551 of 2013 and 199 of 2017. However, the property involved in both the suits are different. Therefore, the petitioners are bound to first establish that they had undivided right in the properties which are subject matter in OS number 199 of 2017, and next to establish that the property in OS number 199 was disposed of to acquire the property in OS number 551 of 2013. In that view of the matter, as rightly contended by the learned counsel for the respondents, both the suits are based on two different sets of facts and hence are not dependent on the outcome of each other. However, since the issue of lawful execution of the will is a common issue that arises in both the suits, it is appropriate to transfer both the suits to one court so as to ensure that the finding recorded in so-and-so is noted while recording the findings in OS number 199. Subsequently, because what happened, the sisters who had filed the partition suit, they abandoned the suit.
Yes.
The respondent number 1 herein, who had filed the ejectment suit, she got transposed to the rank of the plaintiff. Therefore, it is her contention, it is all subsequent events. It is her contention that it is a joint family property with a property which was sold off. Therefore, we filed an application for recall of PW1, that is respondent number 1, in OS 551 for further cross-examination in view of the subsequent developments. Therefore, now the trial court has stated that in view of the findings given by this honorable court that no evidence shall be recorded further, I cannot allow this court. That finding is not before this honorable court, but the trial court in page 161, In 160, your lordship may kindly see, 160, page 160. In that view of the matter, this petition is, because that is extracted, disposed of, directing the transfer of OS, etc., consideration before the honorable court, etc. Mysore is directed to take both the suits together, and he shall first decide the suit in OS number based on the evidence already adduced. The findings recorded in etc. shall be considered while disposing of etc. Thus, 161. Thus, there is a specific direction to this court in the said order that the present suit shall be decided first based on the evidence already adduced. Now, there is no reference by this honorable court. My right of further cross-examination is curtailed.
Senior civil judge Mysore is directed to take both the suits together and shall first decide that based upon the evidence already adduced. Finding records from OS shall be considered while disposing of the OS.
It is all subsequent events which I have stated, and I have to bring all these facts to this suit. This honorable court never stopped me or did not curtail my right.
You sought for clarification. That is the word they have used. Yeah, see, that was the situation. Nobody has thought that this will be the situation, but that is the code. See, OS 551 has to be decided only on the evidence which is available on that day. There is no other. Otherwise, court should not say it like that. First decide 551, then you decide. Court said OS 551 of 2013 based on the evidence already adduced. There is no subsequent evidence can be allowed to be adduced.
That is, that your lordship is right.
Yes.
But what
Now you
happens?
get it? No, there may be changes of this. You have to get it clarified from that. Otherwise, court is giving that you have to decide within that evidence. Trial court is interpreting something else and doing, or that this court
That is the
overcoming
predicament.
that other.
That is the predicament. I also agree with your lordship.
It's what that.
That now the right of further cross-examination is curtailed.
That you have to be make out and seek for a modification of that order.
In the meantime, the arguments are time.
File application there. Nalene haಕ್ಬಿಟ್ಟು move ಮಾಡಿ ಇಲ್ಲೇ ಇದ್ದಾರೆ ಸಾಹೇಬರು. This is the problem because of this. I can't do further evidence. They may clarify that. Otherwise, one court says that no, you have to decide only on this point. I am giving something else. I am overcoming to that judgment of that court. Yes.
Yeah, this petition may be kept pending because I will
be kept pending. You clarify that this court that clarified, then that has to be interpreted along with this order. Then we can say that trial court may be reconsidered.
They have anyways time till 26 minutes. Next date is 26th.
Yes.
For clarification.
Please this matter next week.
oblige.
Serial number 9, Subramanya Kaushik RS.
For the petitioner, my lord. Executing court has issued arrest warrants against me without even issuing arrest notice, my lord. The impugned order is at annexure A.
What is that decree, madam?
Decree in execution is one for eviction and damages, your lordship.
Where is that decree?
Decree is available at annexure B. Operative portion is available at page number 49.
Yes.
Thereafter, I challenged the decree and it came to be confirmed in appeal by order dated 18/1/2025.
Yes.
During the pendency of the appeal, the decree holder, that is the respondents, filed the execution petition, and the execution petition is filed seeking issuance of delivery warrant in respect of the petition scheduled property, arrest and detention, attachment and movables. Now, your lordship might kindly see the impugned order, page number 24 and 25.
Yes.
I have produced a type copy of annexure A at page number 26.
Yes, read.
6th line. He files a memo reporting payment
from
of
the
process.
beginning.
DHR and counsel are present and submit that the JDR has not received the rice bags as per the order data so-and-so, refuse for the same. The counsel for DHR further filed a memo along with copy of judgment in RA so-and-so, reporting that the appeal filed by JDR against the decree of this court is dismissed. He files a memo reporting payment of process fee and prays to issue arrest warrant against the judgment debtor for non-payment of damages. JDR and counsel care of they absent. No representation perused the judgment in so-and-so and found that the judgment and decree of this court in so-and-so is confirmed. It will be the duty of this court to give effect to the decree passed by it. Now, it is, the emphasis may be given to the following lines, Your Honor. Admittedly, this execution petition is filed within 2 years of decree in so and so. Hence, issue of arrest notice is not necessary. Hence, issue arrest warrant to JDR. As your lordship may be aware that section 51, the modes of it is mandatory for the executing court to issue arrest notice before an arrest warrant is issued. Your lordship may kindly peruse section 51 proviso. Section 51 powers of court to enforce execution. I'll just read the relevant portion, Your Lordship. Subject to such conditions and limitations as may be prescribed, the court may, on the application of the decree holder, order execution of decree so and so by arrest and detention in prison for such period not exceeding so and so, where arrest and detention is permissible under the Act. And please come to the proviso, Your Lordship, provided that where the decree is for the payment of money, execution by detention in prison shall not be ordered unless after giving the judgment debtor an opportunity of showing cause why he should not be committed in the prison for reasons recorded in state.
Which is the rule, which is
This is the section.
Yes.
Now, Your Lordship may kindly come to Order 21, Rule 37. Discretionary power to permit. Your Lordships have found it. Rule 37. Your Lordship
Yes.
found it. Discretionary power to permit judgment debtor to show cause against detention in prison.
Yes.
Notwithstanding anything in these rules, where an application is for the execution of a decree for the payment of money by the arrest and detention in the civil prison of a judgment debtor who is liable to be arrested in pursuance of the application, the court shall, instead of issuing a warrant for his arrest, issue a notice calling upon him to appear before the court on a day to be specified in the notice and show cause why he should not be committed to the civil prison. Provided that such notice shall not be necessary if the court is satisfied by affidavit or otherwise that with the object or effect of delaying the execution of the decree, the judgment debtor is likely to abscond, etc. 2, where appearance is not made in obedience to the notice, the court shall, if the decree holder so requires, issue a warrant for the arrest of judgment debtor. The warrant is prescribed under Rule 38. So it mandates on the executing court to issue a show cause notice under Rule 37.
No, there
As
is an
to-
exemption also.
Yes, Your Lordship, but there is nothing in the order to show that I have disobeyed or anything to show that the affidavit of the decree holder is on record.
Yes.
I have been appearing before the court and
Court is satisfied by that affidavit, otherwise that debtor delaying execution of that degree.
what is relevant to note is that
What is that affidavit they have filed?
they have not filed anything. The only thing they have filed is a memo reporting payment of arrest warrant process, Your Lordship. That is available at Annex to E, Your Lordship.
What is that amount in due? How much you have to be paid?
According to them, it is 4 lakh odd amount. But that is a disputed amount, Your Lordship. But however, my humble submission is to proceed with the execution when the relief is arrest and detention, a show cause notice mandated under 37 has to be issued.
What is the due according to you?
My due according to me is 1 lakh odd amount, Your Lordship. I shall produce a calculation, Your Lordship. I'm not disputing that. I'm ready to pay that amount.
You deposit now that amount, yes. Or you should
I have sought for interim relief to stay all further proceedings, Your Lordship.
stay off. Why do you want to all further proceedings? Let them stay that order itself.
No, Your Lordship. In fact, the Supreme
Let
Court
them-
has held that arrest
No, that
arrest
order,
warrant cannot be issued without even
No,
show
madam.
causing a notice to the judgment debtor,
order
Your
is
Lordship.
stayed is enough. Let them proceed after giving in a notice, then they can do it. Why do you want to stay?
So my humble submission is, Your Lordship, I'll just brief you as to the background facts of this case, Your Lordship.
Why do you want that stay of that further proceedings of?
They will proceed with the delivery warrant and they will take the possession of the premises.
That is
That is, I do admit, but there is one background
No,
which
that
is
is
not.
not the issue before me. Issue is that they have issued an arrest warrant without the notice. I want to stay only that order, not the further proceedings.
No, my lordship,
No, no, no.
your lordship may kindly see.
No, they have any degree, madam. They have
Yes,
any
yeah,
degree.
they do have a decree. However, they have committed an illegality. So this,
That if you challenge execution petition initiation itself is wrong, then we will verify.
yes,
not
your
here.
lordship. Yes, your
Yes.
lordship. However, my humble request is,
Of order dated 22/2/2025. Passed in execution case number 145 of 2024. Produced as annexure by first additional civil judge JMFC Bhadravati. Subject to condition. Petitioner has to deposit 50,000 rupees before executing court on or before 20th of March. Yes.
your lordship may kindly grant 2 weeks' time.
The 20th March is 2 weeks only.
The next date of hearing before the executing is 29th, your lordship. Kindly have 28th.
On or before 28th, yes.
Yes, your lordship.
Serial number 10, Girish B. Baladare.
Matter pertaining to Vandikathya temple. Yesterday, our lordship directed to file an affidavit. In this case, my lord, the complaint also lodged by the villagers as well as the deity of the temple. I produce along with the affidavit. Kindly peruse the page number 4, my lord. Ali nanu archakanagiruttene. Can I read, my lordship? Page
Yes.
number 4. ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ಒಂಟುಕತೆ ಉತ್ಸವ ಮೂರ್ತಿ ದೇವರ
ಏನಾಯ್ತು 2019 ಕಂಪ್ಲೇಂಟ್ ಏನಾಗಿದೆ ಕಂಪ್ಲೇಂಟ್?
ಅದ್ ಕಂಪ್ಲೇಂಟ್ ಮತ್ತೆ SP ಕೊಟ್ಟು ಸ್ವಾಮಿ. They have not taken any action.
ಮತ್ ನೀವು ಸುಮ್ನೆ ಇದ್ದೀರಾ?
SP ಕೊಟ್ಟು ಸರ್ಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಕೊಟ್ಟು
ಆಯ್ತು, whether FIR has been registered?
FIR ರಿಜಿಸ್ಟರ್ ಆಗಲಿಲ್ಲ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟರು. Then we will also approach the chief minister, my lordship. Page number 10 may kindly peruse, my lordship.
What is that complaint you are given?
Complaint they have theft the
ಬಂದಿರುತ್ತೆ. ನಾಳೆ ನಾನು ಅರ್ಚಕನಾಗಿದ್ದು ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ಒಟ್ಟಿಕತೆ
deity Vandikathya from the temple
ದೇವಸ್ಥಾನ ಪೂಜೆ ಎಂದಿನಂತೆ ಮುಗಿಸುವ
along with the
ದೇವರು
silver and gold ornaments.
ನೋಡಿ ಕದ್ದುಕೊಂಡು ಹೋಗಿ ಮನೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡಿರ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಪ್ರತಿ ಮಾಡಿದರೆ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಕೊಲೆ ಮಾಡಿ ಬೆದರಿಕೆ ಹಾಕುತ್ತೆ. ಅಲ್ರಿ, ದೇವಸ್ಥಾನದ ಬಂಗಾರ ಎಲ್ಲ ಕತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟು 5 ವರ್ಷ ಆದ್ರೂ ಇನ್ನು ಏನು ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ you are saying that you are an architect.
What happens, my lordship? The defendant here in the plaintiff here belongs to the SC/ST community. If they have to take any action against them, they have to threaten them to file the atrocities case. That's why they have.
See, that is not that this thing.
And villagers also lodged the complaint, which is page number 80, my lord.
You are keeping quiet.
And we also approach the deputy chief minister, my lordship, which is in
If it
page
is
number 10.
not registered, you could have filed in a private complaint also. If really that they have threatened.
And idral
Now
note
your complaint is that only gold ornaments and other things has been, not that.
ದೇವ್ರು ತಗೊಂಡೋಗಿದ್ದಾರೆ ಅಂತಾನೆ my complaint.
Read.
ಎಂದಿನಂತೆ ಮುಗಿಸಿ ದೇವ ವಿವರಣೆ ಮಾಡೋದು ಅತಿಕ್ರಮ ದೇವಸ್ಥಾನದಲ್ಲಿದ್ದ ಒಂಟುಕತೆ ದೇವರ ಉತ್ಸವ ಮೂರ್ತಿ ಕೆಂಚನಾಯ ದೇವರು ದೇವರಿಗೆ ಧರಿಸಿದ ಬೆಳ್ಳಿ ಚಿನ್ನದ ಒಡವೆಗಳನ್ನು ಕದ್ದುಕೊಂಡು ಹೋಗಿ ತಮ್ಮ ಮನೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡಿರುತ್ತಾರೆ.
Now what is that order passed by the trial court?
Trial court restraining the defendant from performing the puja.
Where is that?
Order which is in page number 35, my lords.
For
Restraining
the
by
plaintiff or a defendant?
I am for the defendant.
What
Temporary
is this relief in that suit?
suit for permanent injunction and filed the IF for seeking temporary injunction restraining.
What is that plaint? Permanent injunction.
Plaint which is in page number 17, my lords.
Page number
17.
17. What is the prayer?
ವಾದಿಯು ತನ್ನ ಮನದೇವರ ಒಂಟಿಕತ್ತೆಯ ದೇವರನ್ನು ಪೂಜೆ ಮಾಡುತ್ತಂದೆ ಹಾಗೂ ಭೂತಾಳಿ ಮರದಿಂದ ಕೆತ್ತಿರುವ ಚೋಮದ ಉತ್ಸವ ಮೂರ್ತಿಯನ್ನು ಉತ್ಸವ ಮಾಡಲು ಯಾವುದೇ ರೀತಿಯಿಂದ ಅಡ್ಡಿ ಆತಂಕ ತೊಂದರೆ ಪಡದಂತೆ ಪ್ರತಿವಾದಿ ಶಾಶ್ವತ ನಿರ್ಬಂಧದ ಕಾರ್ಯ ಆದೇಶ ಮೂಲಕ ನಿರ್ಬಂಧಿಸಬೇಕಾಗಿಯೂ ಹಾಗೂ
ಅತಿಕ್ರಮಿಸಿ ವಾದಿ ದಾವಾ ಸ್ವತ್ತಿನ ಶಾಂತಿಯುತ ದಿನಕ್ಕೆ ತೊಂದರೆ ನೀಡದಂತೆ ಮತ್ತು ದಾವಾ ಸ್ವತ್ತಿನ ವಾದಿ ತನ್ನ ಮನೆ ದೇವರನ್ನು he asking that he has to conduct a puja of that God belongs to his family. It is not.
It is not belongs to his family. That is our contention. And it is also pleaded before the court below, both the courts below.
No, that which is that God belongs to your.
Ontikatteya.
Anybody can keep that deities idle and pray that.
Allah,
Can you
yes,
say that
yes,
to
stolen
me?
the, he has stolen that deity from the temple. That's why I lodged the complaint.
No, that is then a criminal case. Stolen is different. He wants that. He wants to.
He was not
perform
keep the
this-
replica of the Vantikataya, my lordship, in his house. He's keep the original Vantikataya. For
No,
the
the finding
photograph.
is that replica. Trial court finding is that
Trial
replica.
court finding is replica. Photograph. Kindly peruse the photograph, my lordship,
Yes,
which is in page number 19,
yes,
along with my affidavit.
yes,
This is the deity kept in the temple premises.
yes.
And thereafter they have stolen the
No, that
Vantikataya. 20 page
even
number
after
20.
5 years, no action has been taken.
They
Said
have
that-
initiating, they filed the suit and they filed the civil proceedings against the plaintiff.
Who? You?
I am also filed the suit, my
No,
lord.
where is that your suit?
Suit allಕ್ಕೆ ನಡೀತಾ ಇದೆ.
No, you have not filed any application for injunction.
I have not filed any,
And then-
I have filed the injunction, my lordship, but that has not been considered.
And then your suit is there, you have not obtained that injunction order.
And also
Yes.
kindly we peruse the,
Take handsome.
my kindly peruse the
Yes, yes,
page
yes.
number 15 for a moment,
We
my lord.
have, unless it is
Hello, kindly peruse the page number 15.
court has granted. an
15,
injunction.
15, page number 15 of my affidavit, my lord.
Yes.
On the basis of the letter addressed to the chief minister.
No, I am not on that, Mr. Court has granted an injunction only. He has to perform the puja of the.
And also
replica.
conduct the utsava, perform the utsava also, the court has permitted
Replica
the
Utsava for him,
plaintiff.
whatever he want. He is not been permitted to do same what is there. You are claiming that. They said only a replica. Other than that,
That
if you are-
observe,
that is what the trial court said. See that.
Ali, he is not keeping the replica of the original
File a contempt.
Vantikataya.
You file a contempt. You file a contempt there, Mr.
Ali, he was he was not keeping the replica, he was keeping the original
Then,
deity Vantikataya in his house.
then it is in a contempt of the trial court order. You file in a contempt. Yes.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಂತ ಅಂದ್ರೆ
Yes,
ರೆಪ್ಲಿಕಾ
sir,
ಅಂಡ್ ಆಲ್ಸೋ ಆ ಬರೀ ರೆಪ್ಲಿಕಾ ಇಟ್ಕೊಂಡಿದ್ರೆ ಅವು ಈ ಕಂಡಕ್ಟ್ ದಿ ಉತ್ಸವ ಪರ್ಫಾರ್ಮ್ ದಿ ಉತ್ಸವ ಥ್ರೂ ರೆಪ್ಲಿಕಾ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ರೆಪ್ಲಿಕಾ
Why can't they do it? Why can't they do it, Mister? They can do it. Ustava and all.
ಆಲ್ಸೋ ದಿ ಪರ್ಮಿಟೆಡ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಟು ಪರ್ಫಾರ್ಮ್ ದಿ ಉತ್ಸವ ಆಫ್ ದಿ ವಂಟಿಕತೆಯ
Yes.
ಜಾತ್ರಾ ಫೆಸ್ಟಿವಲ್ ಇಸ್
Want that I
approach-
will, there is a direction only saying that he has to do it replica in his house. That nothing to do with this. I will dismiss it. That's all. Yes.
ದಟ್ ಒರಿಜಿನಲ್ ವಂಟಿಕತೆ ಲಾರ್ಡ್ಶಿಪ್
No,
They are
their
not-
court, which is not said by the court, I cannot make it something else. Court said that.
court
only
said that to that extent observation could be made, my lord.
Yes.
ಅಲ್ಲ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಏನು ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ ದಟ್ ಇಸ್ ದಿ ಥಿಂಗ್.
No, they have been allowed only due to their God, which is there in their house, Mister. Don't make that, trial court is also clearly held that he can do it replica of that. Yes.
ಅಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ ಟು ಶೋ ದಟ್
Don't
there is a
create
theft
any-
of the Vantikataya
Yes,
deity
yes.
from the temple premises. That's why several complaint came to be filed. I approached the SP. SP ಗೂ approach ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ ನಾನು. SP
If you
circle
proceed, you
inspector.
proceed in that criminal case. Yes.
and also
Where is that order? Where is that order? Which is that?
order which is in page number 35, my lord.
Page number?
35.
Yes.
ಅಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. It has been clearly observed in the
For injunction.
no doubt defendant are the Archaka and deity of the Vantikataya which is situated Agra village.
The diet, yes.
In the findings recorded by the trial court, it is clearly observed
I
that
will dismiss, I will dismiss it. That's all. This petition is filed by.
my affidavit and my records may have taken note, my lordship.
No,
because-
that is not the part of that civil court records. Yes. This petition is filed by.
Otherwise notice ಇರ್ಲಿ ಸ್ವಾಮಿ ನೋಡಿ and summons ಕೊಡಿ ಸ್ವಾಮಿ.
Don't create, this thing in that village, Mister. Yes. Or issue notice. In addition to that, petitioner is permitted to take out hand summons to that respondent. Yes.
Serial number 11.
My affidavit is taken on record, my lordship, because
File it in that counter, Mister.
ಕೊಡಿ.
Yes. Kodri adu
Ah,
ವಾಪಸ್.
sir, ಕೊಡ್ತೀನಿ.
Petitions. Not, the petitioner is not, the defendant number 2 in the trial court,
Yes.
but, the suit is filed, my lord, for specific performance of the contract.
Yes.
But, the after my lord completion of the, evidence,
Yes.
the defendant, my lord, wanted to introduce some facts, my lord, by amending the written statement,
Yes.
saying that his sisters, he is not the absolute owner of the property, that is already in the written statement.
Yes.
So further fact that his sisters have instituted suit for partition,
Yes.
and in that suit, my lord, there is an order of injunction
Yes.
against the defendants not to alienate the property. That facts, my lord, is subsequent event. And my lord, therefore, my lord, he wanted to insert that fact in the written statement.
Yes.
Therefore, he filed application under order 6th rule 17. My lord, the plaintiff has objected the application. My lord, the trial court rejected my application for amendment of written statement. Therefore, my lord,
Now that suit is for,
specific performance of the contract.
now what is that you want to amend? You want to amend that written statement?
Please, my lord, please,
What?
my lord, and insert one paragraph saying that, my lord, his sisters, my lord, his sisters have instituted a suit for partition, and in that suit, the court has issued an injunction not to alienate the property. And my lord, that fact, my lord, I wanted to insert in the
Why? Injunction court new documents can be, it is in the court documents and the order. Why it has to be inserted?
that, my lord, the present.
If it is in a documents, it is not in a public documents, it is between you two and all. It should be marked and all. Court degree, judgment ಗಳನ್ನೆಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ?
Fact, my lord, only facts, my lord. Fact, my lord, saying
What is the
that
reason for rejection? Where is that?
rejection. Please, my lord, order is at page number 61 reasons, sir. It starts, my lord, the page number 60.
Yes.
I will read from 60, my lord, because the facts also narrated.
Yes.
The instant application
Now
is
you
filed
read
by
para
the
7 reasoning.
reasoning para 7.
Yes.
The present suit is filed for specific performance of contract against the defendant number 1 to 5. The defendant number 2 and his father are stated to be executors of suit agreement of sale. The defendants have contested the suit and both parties have led their evidence. The defendant number 1 to 4 through the present application intends to insert a para in their written statement about filing of suit for partition by the sisters of defendant number 2 in the year 2024. The said fact admittedly is subsequent to the filing of the present suit. In order to adjudicate the matters at issue in the present suit, the intended to amend is not necessary. If parties to the suit are permitted to amend their pleadings on the facts or events which will take place subsequent to filing of the suit, there will be no end to the litigation. As per the proviso to order 6 rule 17 of CPC, no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. In the present case, trial has been completed. Therefore, this court is of the considered view that the amendment,
One first thing,
the fact of suit, my lord.
first thing, it is a suit for specific for partner.
Please, my lord.
Only thing is that whether you have executed an agreement of sale or not.
Please.
Second thing is that readiness and willingness. Why this partition suit will
And
be helpful for
Of
you?
course, my lord, the other parties, it is joint family property. My lord, they are not added as a defendants.
Specific performance ಗೆ ಅವ್ರು ಹಾಕ್ಬೇಕು.
Specific provisions is there, my lord.
Yeah.
If the joint owner or co-sharer has executed the agreement, if the vendor, the purchaser has right to file a suit for specific performance after divisioning his share, because he has no title on the entire share, entire property. Therefore, even if the trial court passes the order, of course, my lord, trial court has to see whether the specific performance can be ordered or the compensation can be granted.
See,
That apart, my lord.
If it is in a joint family property,
Please.
then he cannot execute against you because
is why-
he can
that is why.
execute only your portions of the property. That's all.
That to my lord, that is why in the initial stage you have taken the pleading that it is joint family property. He is not, he has no absolute right. That despite that, my lord, they have not amended the plaint or even they have not implemented the other sharers.
No, is it necessary?
Necessary, my lord.
Which is
In
that?
the specific
Show me
performance itself, my lord, it is provision is there in the specific relief act. If the partition is required, the agreement holder can himself initiate the suit for partition.
No, you show me the judgment, specific performance of the property suit.
Please.
If it is a joint family property, all joint family members has to be implemented as in a party. Show me that.
Not implementable. That prayer in the suit, my lord, can be by partitioning the property. His share can be
Show me that judgment. Yes.
judgment
So-
provision in the specific relief act.
Yeah, put ಕೊಟ್ರಿ ಅವ್ರಿಗೆ ಬುಕ್ ಕೊಟ್ರಿ, ಅವ್ರೇನ್ ಬುಕ್ ಇಲ್ಲ, ಆರಾಮಾಗಿ ಬಂದಿದ್ದಾರೆ.
ಸ್ಪೆಸಿಫಿಕ್ ಆ ವಿಷಯದಲ್ಲಿ
Yes. Yes, you take out notice, handsome astral. Then we'll, yes, or issue notice.
The suit is
In
at the
addition-
stage of argument.
ಆಯ್ತು, ಅವರು handsome ತಗಡಿ ಬರ್ಲಿ ನೋಡೋಣ. Yes. Yes, in addition, petitioner is permitted to take out handsome, yes, to respondent.
Serial number 12, Nagaratna SK.
13D ದಲ್ಲಿ.
Handsome ತಾಳಿ ಅವ್ರು ಬಂದ್ರೆ will dispose of if they are agreed.
Please.
There is no further evidence ಅಂತ ಹೇಳ್ಬಿಟ್ಟು agree ಮಾಡಿದ್ರೆ it can be.
That can be.
Let us see, let them come. Yes,
The petitioner is the first defendant in the court below.
yes.
A suit for specific performance was filed by the first respondent hearing on an alleged agreement dated 26/9/2014, my lord. And second respondent is nothing to do with the transaction according to the plaintiff.
Yes.
But he has been made a party, saying
Yes.
that there is collusion between the hearing and the second respondent.
Hmm.
Now, during the course of his written statement, my lord, the petitioner hearing has specifically pleaded that there are another agreement has been taken by the second respondent hearing from the petitioner hearing dated 11/9/2014. So that becomes the first agreement. A specific plea has been taken by the petitioner that he, by playing fraud, the second respondent has also taken a same agreement on the same property on 11/9/2014. Issues were casting burden upon the plaintiff to prove whether the alleged agreement was executed. My lord. Now, the said agreement dated 11/9/2014 was exhibited before the court below as DW1 through confrontation to the first respondent hearing. He admitted the said document and it has been responded. So during the course of argument, it was found that some of the issues were relevant for disposing of the matter, for better adjudication of the matter. my lord. So an application came to be filed under Annexure D to recast the issues to the extent that whether plaintiff is entitled for the specific performance of contract on the second agreement to sell dated 26/9/2014. Now, admittedly, my lord, when he has admitted first agreement dated 11/9/2014.
No, that who has executed an agreement of sale, you have executed first.
They say that I have executed a
What is the
state.
date?
The plaintiff's suit is on 26/9/2014.
26/9/2004.
2014. 14, sir.
2014.
Yes,
You have executed in favor of the plaintiff.
that is what they say. He alleges that.
Yes, they are alleging. Yes.
Now, another agreement comes into picture dated 11/9/2014, much prior to this 26/9/2014.
11/9/2014.
That the second respondent has in his favor from me, that is the petitioner.
You have executed that
Yes,
to in favor of that this thing.
I do say that that
Now,
is
what is your defense before the trial court
my defense is no such agreements were executed.
in favor
I
of
have given
plaintiff?
a notice, I'm coming to know of that alleged agreements, I have given a notice resulting in the contract. Subsequently, they issued a notice to me and they have come before the court seeking specific.
No, you are admitting that you have executed in favor of defendant number 2.
No, that is also a fake.
You have
but
denied
is-
that, you have denied both.
Denied, but that is their document is in existence.
Hmm.
Now that this becomes a second agreement, 26/9.
No, that is irrelevant because he has not filed any case for specific performance.
He has not filed any suit for specific performance. He will never file also, my lord.
Yes.
But for the defendant, he has specifically taken a plea in the written statement. So while framing issues, pleadings of both the parties have to be considered, my lord. While considering the written statement of the petitioner hearing, the court should have taken the consideration of that agreement, 11/9/2014.
Why? That is not the issue in the suit.
No, my lord, because,
See-
no, my lord, I would like to say this, my lord. That document is present before the court It's been marked as DW, Exhibit D1 through confrontation to the petitioner. He himself has admitted the said document. Now, when he has admitted, this becomes a second agreement. Though that is not the subject matter of the suit before the court below, still, my lord, this becomes a second agreement. So we sought for a recasting of issue saying that whether he was entitled for specific performance on respect of a second agreement.
Second agreement.
Yes, my lord, because the first agreement, he
Yes,
also
agreed. Agreed that this is,
So that has been marked as Exhibit D1 before the
Yes.
court below on confrontation.
now what is that order you are challenging here?
I have Annexure F, my lord. Lordship may kindly look into page 41.
Annexure?
Annexure F, my lord.
Hmm.
Page 41.
You have filed an application for recasting that issue.
Yes, my lord. Annexure C, my lord.
Yes. What is that order passed by the trial?
Order says from last 5 lines, my lord. That's the
Yes.
reason. When plaintiff has not stated anything about the first sale agreement dated 11/9/2014, and second defendant has not filed any written statement and sought any relief in this regard, and when first defendant has also denied the execution of first agreement, the question of framing issue on this agreement and giving findings that it is a created and concocted document does not arise. Now, the fraud that is being pleaded by the petitioner herein is
No.
regarding the
Where, what is the prior in that application?
to recast issues, my lord.
Last issue, what?
Annexure D, my lord.
Annexure
D at page 29.
29.
Whether plaintiff is entitled for specific performance of contract on second agreement to sell dated 26/9/2004.
Plaintiff and defendant polluted together create. Whether
I
plaintiff.
have pleaded the pollution and fraud. Everything has been pleaded in the written statement, my lord.
Yes.
In that situation, the court should have allowed this application.
Third, issue notice. They have further proceedings in OS number 296 of 2016. Pending in the file of senior civil judge JMFC Dodbalapura. Till next date of hearing.
Serial number 13, MS Nagaraja.
But in the previous matter, I may dispense with notice to 2 to 4 million.
2 to 4. Yes.
Lord, this repetition is filed by the plaintiffs.
Hmm.
They are the plaintiffs in OS number 155/2022. For seeking direction, my lord, because they are aged about 85 and 65 years old. Now, my lord, issues are framed and matter is now set down for evidence. Because, my lord, it is the itinerary court is handling this matter because they have a senior division situated in Haryana. My lord, the sitting is at Friday and weekly in 2 days at Vannali. My lord, the dates are begin very long date. Therefore, my lord, they sought for a direction for time limit as dispose of
Yes.
suit.
You take out notice.
Dispose of notice.
No, that notice has to be given before disposing of that matter. Final disposal, they have to be given the notice because some of the cases after disposal, they have moved that matter by that other side, saying that so many other events are. Therefore, you taken a
And
notice to that hand summons and then move that. After service, you move that will dispose. Yes. Permitted to take out hand summons. In addition, issue notice, in addition, permitted to take out hand summons.
Serial number 14, Prasanna DP.
In this matter,
Yes.
the plaintiff suit, they are seeking the writ of mandamus, seeking direction to dispose of the matter, my lord. Since the honorable trial court has ordered to issue the notice to D5, and even though he has not present.
Yes, take out notice.
Please,
Yes.
ma'am.
Issue amendment notice.
And hand summons of.
Permitted to take out hand summons.
Serial number 15, VB Shivakumar for petitioner, Nayanatara BG.
No,
Did
this
not
is a
there.
matter of day before. Your
Yes.
lordship.
No, none appear for the petitioner. Is this matter of 2 weeks? Let them come. Yes.
No, on the last date, your lordships are asked.
No,
when
yes, that is that. Yes.
He took the
He wants
document.
to bring that judgment. He has not come.
Very well. Your Lord.
Yes, let us. Yes.
Serial number 16, Abhinav Ramanandye.
Lord, petition is by the landlord.
Yes.
Lord, there is a decree passed, my lord, for eviction based on compromise.
Yes.
Lord, when the execution proceedings are filed, the tenant files a 92 petition, my lord, against the trust, saying a scheme is required for the trust.
Yes.
On the guise of the 92 petition, he files an application in the execution petition, saying, please stay all further proceedings because I have filed a suit under section 92, seeking a scheme to be framed. Lord, the trial court, my lord, passes an order of stay That is the order, my lord,
No,
which is
yeah, execution petition is filed on the basis of what?
compromise decree.
Compromise degree.
Yes, my lord.
Hmm.
Execution proceedings, my lord, he comes and says, the tenant has filed a suit against the trust saying frame a scheme. Since I have filed a suit against the trust saying frame a scheme, stay the present execution proceedings is the application that is filed.
Hmm.
That is allowed, and my lord, execution is.
Tenant has filed that,
Yes, ma'am.
what is his right for this thing?
My lord, only to protract, my lord, only to protract.
Yes.
He, my lord, assuming, my lord, even a scheme is framed,
No,
that
he
will
is
not
the-
nullify the order of eviction.
Yes.
My lord, the order is at, my lord, I have produced the order at annexure J. Page number, my lord, 112. Sorry, my lord, in the first matter, page number, my lord, 112.
Yes.
111, my lords will kindly see.
Position of Supreme State during the pendency of the OS. Yes.
I
Issue
have sought
notice.
for stay of this order. my lord.
Order dated 20th/12/2021.
Yes, my lord. My lord, before, my lord, COVID, my lord, this was, order was passed.
Hmm.
And subsequently, my lord, there was an order of injunction.
Hmm.
My lord,
Can you
NH
take out notice? Let them come.
my lord,
4 years over, Mr.
4 years over, my lord.
I
My
think
lord,
there is
some-
no interim order can be granted if there is any urgency of the threat, not that you take out.
My lord, rent is also not paid.
That you file an application, let us see that.
But
Yes.
some short date may be given, my lord.
Yes, you serve a hand summons.
Yeah, I'll
Yes.
and some short date may
Permitted
be.
to take out hand summons. After service, you move that matter.
Yes, my lord. It may be
Yes.
ta-
Cell number 17, VB Sitaramaya.
My lord, serial number 18 also same, my lord. Two cases are there.
Yes, notice permitted to take out. hand
Emergent notice.
summons.
With some date may be fixed.
No, after service,
Yes, ma'am.
you move that matter.
Yes.
Yes.
Cell number 17,
Appearing for petition, my lord.
Hmm.
Well, the petitioner has filed a suit for permanent injunction against the first respondent.
Hmm.
First respondent has filed another suit for permanent injunction against the petitioner.
Yes.
In a suit filed by the first respondent,
Hmm.
he has admitted that petitioner is in possession of the property.
Hmm.
Property.
Hmm.
At page number 28, my lord.
Hmm.
Sorry. In cross examination. Sorry, page number, my lord, 61. Sir, last para.
Hmm.
Last 3 line.
Hmm.
ಸರ್ವೆ ನಂಬರ್ 101/1A ವಿಸ್ತೀರ್ಣ 18 ಗುಂಟೆ ಪ್ರತಿವಾದಿಗೆ ಸೇರಿದ ಸ್ವತ್ತು ಎಂದರೆ ಸರಿ. ಅಲ್ಲಿ ನಾವು ಡಿಫೆಂಡೆಂಟ್ ಇದ್ವಿ. ಇನ್ ದಿಸ್ ಕೇಸ್ ವಿ ಆರ್ ದಿ ಪ್ಲಾಂಟಿಫ್ ಅಂಡ್ ದಿಸ್ 101/1A measuring 18 guntas belongs to property of the petitioner and it is the ancestral property.
Hmm.
My lord, my threat is only against the first respondent. Hence I have filed a suit for permanent injunction. My lord, subsequently with
Suit is filed.
by the petitioner,
No, OS 365 of 2018 is filed by whom?
by the respondent, defendant number 1, it's a counter suit.
No, same. He has filed in a counter claim.
Counter suit, not counter claim, it's in a separate suit.
Separate suit.
Suit with respect to some other property. He has admitted that I am the owner of survey number 101/1A.
No, he has filed in a suit 365 of 2018, not in respect of this property.
Claim that I have possession of 2 guntas in this property also. That is the contention taken by the defendant in this suit. But in the course of cross examination, is admitted that I am the absolute owner of the entire property of 18 guntas.
You are also party in the 365.
Yes, I am the, against me only he has filed.
Filed in a suit
So
for,
I have filed a suit against the first
he has filed in a suit for,
permanent injunction.
he has filed a permanent injunction in respect of which property?
My lord, survey number 101A/A with respect to only 3 guntas. Client is at page number, my lord will get client at. At page number
Hmm.
53.
Hmm.
101/1A measuring 3 guntas. ಅದಷ್ಟೇ claim ಮಾಡ್ತಾರೆ 18 guntas.
18 guntas ಅಲ್ಲಿ 3 guntas ಗೆ ಅವನು
Claim
injunction
ಮಾಡ್ತಾರೆ, but during the course of cross examination, he has admitted that I am the owner of entire 18 guntas. I got the property by ancestor by way of succession.
At page number
ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನದಲ್ಲಿ 180 ಗಂಟೆ ಸ್ವಂತ ನನ್ನ ಮಗ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅವರಿಗೆ ವಿಭಾಗದ ಮೂಲಕ
ಅದೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಸ್.
ಆದರೆ ಸರ್ವೆ ನಂಬರ್ 101, 24, 28 ಗುಂಟೆ ಸ್ವತ್ತು ನನ್ನ ಮಗ ಮಲ್ಲಿಕಾರ್ಜುನ್ ವಿಭಾಗದ ಮೂಲಕ ಬಂದಿದೆ ಸರಿಯಲ್ಲ.
ಅಕ್ಕಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಅವ್ರಿಗೆ ಸೇರಿದ್ದು. We have not disputing it.
ಪ್ರತಿವಾದಿಗೆ ಸೇರಿದ ಸ್ವತ್ತು ಎಂದರೆ ಸರಿ. ಪ್ರತಿವಾದಿ ನನ್ನ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನಕ್ಕೆ ಯಾವ ರೀತಿ ತೊಂದರೆ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಗೆ ತೊಂದರೆ ಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಪಿಯೋನರಿಂದ ಅಂತ.
Sir, my dispute, my lord, is only with respect to first respondent. So after he has given an admission during the course of transactions in his sort, some other persons have filed an application for impleading. The respondent number 2 to 8. We have no claim against the respondent number 2 to 8. They have
filed a suit injunction against that R1.
Only R1.
And now impleading has been filed by that whom?
Respondent number 2 to 8, several impleading applications has been filed.
What is their grievance in that injunction suit?
Injunction suit, they are not a necessary party in the injunction. That is my case, my lord. That
no.
applications came to be allowed by my lord only quoting the provision that amendment can be allowed at any stage of proceedings. That is the one.
Impleading.
Sorry, impleading can be allowed at any stage of
No,
proceedings.
any stage, but whether they are necessary or
They are
proper.
not a necessary party. We have no grievance against them.
Here is the finding. Let us see. Trial court, what is the finding given?
Next, sir, G at page number. Page number 47.
No, injunction suit, why they are necessary?
But they are not a necessary party. That is my case, my lord. It's misconceived.
Issue notice.
ಆಮೇಲೆ ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್ ನಾವೇ ತಪ್ಪಾಗಿ ಕೇಳಿದೀವಿ. ಸ್ಟೇ ಆಫ್ ದಿ ಆರ್ಡರ್ ಕೇಳಿದ್ರು ಸಾಕಾಯ್ತು, ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕೇಳಿದ್ವಿ.
Yes, they
That is also misconceived.
3/2/2025 passed by First Additional City Civil and Session Judge Tumkur in OS number 33303 of 2018. Passed on IA number.
ಅಯ್ಯೇ ಎರಡಕ್ಕೆ ನಂಬರ್ ಕೊಟ್ಟಿರೋ ಉಳಿದೋಕ್ ನಂಬರ್ ಕೊಟ್ಟಿಲ್ಲ.
I passed order dated so and so sir.
Passed on application 4 applications ಇದೆ.
Till next date of it.
Yes.
Cell number
Notice to R1 may be dispensed. R1 ಮೇಲೆ ಈ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಗ್ರೀವಿಯನ್ಸ್ ಇಲ್ಲ.
Yes. R1 dispensed. Yes.
Notice to R2 to R8 may be ordered.
Cell number 19, Siddharamaiah.
Is this Mr.
Yes, please.
Yes, Mr.
My lord, order of temporary injunction, my lord.
Suit for
permanent injunction. These are all the ancestral properties. My lord, I have sought a order of temporary injunction that has been rejected. My lord, in view of the concurrent finding, my lord, parties may be directed to maintain status quo. For declaration and permanent injunction, we have sought, my lord. So, order of temporary injunction has been rejected. We have produced the kathas, RTCs.
Then why it is rejected? What is the reason?
My lord, we have not, prima facie, we have not proved the title over the property is the finding given by the.
Where is that finding? What is your sources of title, Mr.?
Sources of title, my lord, it is the ancestral property. I have produced the genealogical tree at annexure A.
What is that column number 9 shows in that RTC, Mr.? Have you produced that?
So notice may be ordered, my lord.
Yes, issue emergent notice.
Cell number 20 adjourned. Cell number 21, Ramesh T.
Appearing for petitioner, my lords. My lords, in this case, my lord, it is a suit for declaration.
20 as for the respondent, my lords.
21.
Apologies, my lord. Serial number 20 as for the respondent.
20, somebody has taken time, Mr.
All right, my lords. Oblige, my lords.
Yes. 21.
21. Yeah. Appearing for petitioner, my lord. My lord, page number 14, my lords, it's interim prayer.
No, suit for?
My lord, it is suit for declaration and injunction. Plaintiff, the respondent is a plaintiff in a trial court, my lords, and I am a defendant in a trial court, my lords.
Yes.
And I have filed this for expedition matter, my lords. My grievance is limited grievance, my lord, as stated in interim prayer. My lord, what happens is, here, the plaintiff has no title on that. he files a declaration injunction suit and he takes an injunction order and order sheet is annexed as annexure A. My lord, while granting temporary injunction, no proper reasoning has been stated. There is no reason why this injunction is being granted. And that we challenged that and we filed an application to vacate the injunction that came to rejected. And again, in the plain.
Where is the application is rejected and?
My lord, that is not the, my lord, that is not part of the grievance of this year.
No, it is confirmed.
It is rejected and it is confirmed, my lord. That is not the grievance, sir. We are challenging the petition and the matter is going on. My lord, the plaintiff files the suit and drags the matter. And we have filed this writ petition for expedite of matter. My lord, our prayer is on page number 13, my lords, and proper court fee is not paid, my lords.
No, for that and all, you have to
My
raise an
lord,
objection or file an application.
Agree, my lords, I agree. For that, for proper court fee, we filed CRP and we got an order, my lord. That is also annexed along with the documents.
To direct the honorable court to, you want to dispose of the suit expeditiously.
Yes, my lords.
Yes.
My lords.
You take hand summons.
My lord, and summons and this one, my lord, after CRP 158 is allowed before this honorable court, we filed the copy of this judgment before the trial court and filed a necessary application under 149. That application has been dragged in the month of November. We filed.
I think you serve a copy, let him appear.
My lord, we'll and summons, sir, we will serve a copy on the counsel of the.
Both you can do. Yes.
My lord, and interim order, my lords.
What is that interim order?
Directions to the honorable court at the trial court to decide the interim application IA8 on or before 15th March.
What is that IA8?
IA is improper court fee. That is marked annexed as.
You are seeking only, sir, that is the direction.
My lord, small direction, limited grievance, annexure F, my lords.
IA.
Annexion F.
No. What is that main prayer?
Sir, main prayer is
decide the suit. No, you want to decide the suit or you want application?
My lord.
No, one you have to be sought.
My lord, decide the suit on or before that, they have to come, my lords, for final disposal of this suit. And for final disposal, they have to come, my lords. Before they come, my lords, let my application be heard on IA8 by 10th.
Also, you serve a copy.
My lord, yes. My lord, prayer, interim prayer, my lords.
No, I have seen that. You
my lord, my argument on main matter. Let the trial court hear my.
If you are not insisting main prayer for disposal of the suit, I can dispose of your writ petition itself, directing your application may be disposed of.
It's by April 29th, I'm.
No, where is that your application?
It's in page number 12, my lords. Main prayer.
Page number?
12.
No, not main prayer. I'm asking that you have said you have filed an application.
That is annexure A, my lords. Page
number 8.
IA 8 over this one.
For what?
For decide this court fee. Court fee is not the issue here, my lords. Let the court decide on anything, whether it allows or reject. I am not grieving on that. I have made necessary petition. Let the court decide. My grievance is let the court, honorable court, decide that IA application pending before 15th March and hear me on main petition because already plaintiff has made his arguments on main petition. My main petition, orally and written arguments on or before 30th.
Dispose of that, you serve a copy. Yes. Directed to
1 week's time, date may be granted, my lords. And
serve it and move that hand summons. Permitted to take out hand summons to the respondent. Yes.
If date is,
Sorry, serve madbuttu.
My lord, if date is given, that emergent notice will be printed expeditiously, my lords.
See, they will give a 10 days time to appear. After service, after 10 days, you move that matter, we will take that matter. Yes.
22.
For the petitioner. Suit for recovery filed by respondent. This petition challenging the order of dismissal of rejection of application to recall and reopen to lead further cross-examination of PW2. I have led the cross-examination and completed the cross-examination on 11/9/2024. Subsequently posted for defendant evidence. I come up with an application to cross-examine the PW2. That has been rejected by the trial court with cost of 1,000 rupees each. The application is page 39, my lord, is my affidavit. Sought for limited question. page 39 is my third para. I want to lead further cross-examination with regard to the certain question, my amendment exhibit P33 only limited to the extent of with regard to P39, 33. That has been rejected by the trial court.
Oh, why you have not done it in that first instance?
I have cross-examined. I have limited questions to be left out. Some questions has to be left.
Now, why it is left out? Law doesn't say that since you can left out, that can be asked later, unless you show that why you have not put that question in that earlier stage. There should be a reason for recalling, Mr.
I will cross-examine on that point. From the answer of that, I need to ask certain questions. That has to be.
That cannot be permitted under that law.
The findings of the court in page 18. my lord.
Suppose subsequent events is happened.
The trial court went on to give on the merit of the case. I kindly permit to read page 18.
Further cross-examination, that can be permitted. Subsequent event, it is related to the case. This has to be.
This is related to the case only.
No.
I've taken
Supreme
the
Court
finding of the
said
trial court that
you have not done it first stage when it is available for you or that first
my lord,
stage.
the finding of the court that I have not disputed the exhibit P33. That's why you have not be permitted. But kindly turn to page 35 is my written statement, para 10, my lord.
Now, where is that order, Mr.?
Order is page 18, 20. 18 is the relevant portion.
Yes.
Para 10, my lord, page 18.
Yes. Yes, read.
Yes, after examination of above said facts and also the reason assigned by the plaintiff and the objection raised by the plaintiff, this court has the opinion that defendant took substantial adjournment of facts of cross-examination in length by taking several adjournment, and the cross-examination has not been done in one stretch. It has been taken after taken several adjournment. It was done in the part by the part. Then question of leaving any question of a particular document by oversight cannot be appreciated. Secondly, if the pleadings of the defendant pleaded in the written statement are considered, the issuance of the amendment was not in dispute, under which the new specification has been given and the revised amendment amount has been mentioned. In fact, the defendant has not disputed the said document. If the contention of defendant is concerned, the delay in the manufacture supply, it was sold. Kindly term, that is written statement in page 35, my lord. I have taken a specific contention in para 30, disputing the very.
ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ತಾನೇ ನೀವು ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿರೋದು.
Please.
ಮತ್ತೆ ಅವಾಗ ಯಾಕೆ
That
ಮಾಡಿಲ್ಲ ಅಂತ
subsequently went on to give on the merit of the case.
No, you forget about that, Mr. You give an explanation why you have, see, this was point which was available when you have cross-examined the PW1. Why you have not done? That's what that law says. If it is subsequent event, if it is, even though you have raised, you cannot, this thing, satisfy the court, then only it can be recalled. Otherwise, the purpose of that provision will be defeated. That too, see, order 8, rule 13 for
recall order 18, rule 17.
17. Yes, you see that has been 17A has been deleted.
Yes,
Order
sir.
8, rule 17 is only for the purpose of the court for clarification. Supreme Court said 151 can be excised if there is sufficient reason has been shown.
The finding is they went on to give on the
Adbidi,
merit of the case, my lord.
First ಹೇಳಿದಾರಲ್ಲ, examination is not done in one stretch. We are given so many.
That is not the case, my lord. He has not appeared before the court 2 occasions. I have cross-examined 2 occasions.
What is the, why you have not done it in that first instances? You have to convince the court. Then only it can be allowed to.
I have cross-examined to a certain extent, certain questions which was to be.
These are all that.
The finding of the court. my lord.
That matter, Mr. That cannot be allowed. That's what the Supreme Court.
Court can influence on that subsequently while passing in a judgment that went on to give the on merit of the case. I may be permitted, that has to be
Will
deleted.
say, well, deciding that case without influencing any finding on this IA.
My lord, permission is given, I will be cross-examined with cast down. It may be cast.
This is happening in all cases every day. 10 to 15 cases before me, when matter is posted for arguments, they will file an application for recalling that witnesses. That to see, you are not cross-examined at a stretch. Court has given so many.
No, that is not the case, my lord. I have produced in page para 3 of my statement. He has not appeared.
Notice.
But order may be stayed. I have sought for interim order because matter is set down for argument on 10th, my lord.
No. There we know that at the stage only application will be filed. Yes.
Cell number 23, Narendra, yes.
Speak for petitioners in this case, my lord. It's a plaintiff litigation, my lord. Suit is one for declaration and version, my lord. My lord, initially suit was filed for seeking declaration, my lord, and later on the matter was dismissed for non-prosecution on 3/4/2019, my lord, for further matter is posted for cross-examination, my lord. Thereafter, my lord, because of the ill health of the plaintiff, he was admitted to the hospital, my lord. That has been narrated in the miscellaneous petition filed under 9 Rule 13, my lord. That was also came to be dismissed by the trial court, my lord, based on that delayed approach, my lord. Because of the pandemic, my lord, he could not able to file within time, my lord. COVID-19, my lord, could not able to file. From past 50 years, he is in possession of social property. He's a residential premises, my lord. He sued for declaration. He has led his examination chief also. Matter was posted for cross-examination. For cross-examination, he could not able to appear, my lord, because of old age, my lord. He is aged about 81 years. He was succumbed to death on 2023, my lord, because of his old age and age-related problems, and he was also undergone for cardiac arrest, my lord. Because of that, he has dead, my lord. Because all the reasons miscellaneous has not been, lord, only sole ground on that delay has approached before the court in recalling the order 9 to 13, my lord. My humble submission, matter may heard on merits, my lord, since from past 50 years.
What is that order you are challenging here, Mr.
Order passed on miscellaneous, my lord, 9 Rule 13, not to restoring the matter for
9 Rule 13.
Please, my lord.
43 could
Annexure F is the impugned order, my lord.
9 Rule 9,
Please, my lord.
Order 9 Rule 9. You
I'm
have to
sorry,
file
sorry. 9 Rule 9, my lord. My lord, he is in possession of the property, my lord, from past 50 years, my lord. Solely on the delay.
Order,
Solely on the delay, my lord. In filing the miscellaneous petition,
43 Rule. Order 43 Rule 1. Dismissal of that order of the suit. No, you have to file an appeal. How can you writ is maintainable?
based
Officer has not raised an objection.
no, my lord.
Order 9 Rule 9, you see that under 43, Order 43 Rule 1, any order under Order 9 Rule 9 rejecting that application from an order to set aside the dismissal of the suit. Yes, there is an
Dismissal of miscellaneous suit was dismissed for non-prosecution, my lord.
Your
As
petition
against that,
under
my
Order
lord,
9 Rule 9.
miscellaneous petition has been filed in miscellaneous 11 of 2021, my lord. He already filed an application for restoration in miscellaneous has been filed, my lord, for restoration of the suit, my lord.
You have filed
That-
an miscellaneous.
Please, my lord. That has been dismissed on the solely on the ground of delay, my lord.
No, miscellaneous is filed under, where is that application? Under which provision?
My lord. Annexure F is the miscellaneous petition filed by me for seeking restoration of the
Page.
internal page 51, my lord.
This is Order 9 Rule 9 only.
Please, my lord.
Then there is an appeal. Tertiary appeal. The Order 9 Rule 9 ಅಲ್ಲಿ ಹಾಕಿರೋದು ಹೆಂಗೆ ಗೊತ್ತಾಯ್ತು? Yes, pass off.
Please, my lord.
Serial number 24, Pradeep GC.
Petitioner. A suit for partition filed by respondent number 1. Partition filed by respondent number 1 and 2. The sisters against the brothers, the petitioner herein and defendant number 3 and 4. Initially, the petitioner herein files a written statement admitting all the plaint averments.
Yes.
Now he sought for amendment, proposed amendment. He files an application withdrawing the earlier admissions.
Where is that? What is that amendment now we sought?
It is nothing but a replica of the written statement filed by the defendant number 1 and 2. That is the Hebrew brothers in the file madidare is exactly replica, identical. Nothing new.
What is that he wants to withdraw? Show me that.
Earlier, he admitted all the plaint averments of the plaintiff. Thereafter, after completing of the evidence, stage of arguments, he files an amendment application, my lord, his
Seeking?
petitioner. Seeking the amendment, rejecting of the suit, saying that nam tanda ಈಗಾಗಲೇ marriages of the daughters ಎಲ್ಲ
Who has
ಮಾಡಿದ್ದಾರೆ.
filed that amendment application?
The defendant number 3, that is the petitioner hearing.
Defendant?
He was defendant number 3 in the, now here in the petitioner hearing.
No, who has filed that application for amendment? Your application has been dismissed.
Yes,
Where is that?
is annexed here A, ink page. My lord,
Order really the order.
order 20 page, ink page 22, my lord. Trial court rejected my application only on the ground that if the proposed amendment is allowed, it will affect the rights of the plaintiffs accrued by way of the submission.
Yes, read reasoning, para 7.
Plaintiff has filed the suit for relief of partition and separate possession of the share in the suit scheduled properties. Defendant 1 and 2 have contested the suit by filing the written statement. Whereas the defendant number 3 filed his written statement admitting the plaintiff governments and praying to grant the decree for partition, allotting the share of the plaintiffs and also his share. Now evidence of the plaintiff side is completed. Evidence of the defendants 1 and 2 is also complete. When the case is about to heard on merit, defendant number 3 has come up with this application. Substance of the proposed amendment of the written statement of the defendant number 3 is that, except the relationship of the parties, he wants to withdraw the remaining admissions and to seek a dismissal of the suit. Defendant number 3 is none other than the brother of the plaintiffs. He is not an illiterate person, as could be seen from the Wakalat written statement and affidavit filed in support of this application.
No,
Yes,
that
signed in English.
earlier you have admitted all that.
10 governments.
Now we cannot be. You can't withdraw that by amendment.
Amendment is nothing but the replica of the brothers in file ಮಾಡಿದ, that is the written
Name
statement.
stand now is that you are admitted that what
Yes,
is there, you
I
can't
agree.
withdraw.
I agree with that.
Yes, that's all. Tell. This petition, anyhow that if they are succeeded and you are entitled for the share will come. Why do you worry? Yes. This petition is filed by defendant number 3 under Article 227 of the Constitution of India, challenging order dated 12/11/2024, passed by Senior Civil Judge JMFC, Kanakpura, in OS number 458 of 2011, on IN number 11, whereby application filed under Order 6 Rule 17 has been dismissed. Plaintiff has filed a suit for partition and separate possession. On service of summons, defendant number 3 has filed a written statement, has admitted that allegation made in the plaint. Even defendant number 1 and 2 has filed their written statement on the basis of the pleadings of the parties. Issues has been framed and parties has adduced that evidence. The evidence of defendant number 1 and 2 is also completed. At that time, the plaintiff has filed, the defendant number 3 has filed this application under Order 6 Rule 17 for amendment of the written statement. He wants to withdraw that entire statement made in that written statement, except admitting that relationship. By way of amendment, parties cannot be allowed to withdraw that admission made in that written statement. Therefore, trial court has rightly rejected that application. There is no error or illegalities in the order passed by that trial court. Accordingly, writ petition is dismissed.
Serial number 25, Shanta Kumar PSC.
Petitioner counsel.
Yes.
Defendant writ petition. Suit for specific performance.
Yes.
An agreement of sale dated 20th/11/2014 was the agreement of sale.
20th/11/2014. Yes.
I denied the every execution of the agreement. Now the plaintiff wanted to produce an unregistered Xerox copy of the document as a secondary evidence. I am questioning that. Unregistered Xerox copy.
It can be produced as a secondary evidence.
Secondary evidence ಕೊಡಕ್ ಬರೋಲ್ಲ.
What is that application you have filed?
Plaintiff
His
wanted-
application is allowed.
plaintiff wanted to mark the document,
Hmm.
Xerox copy of the sale agreement.
Where is that order?
May kindly take the annexure E, page 22. Page 24.
That is
Where are-
allowed.
That application has reason.
Allowed and subject to rise and objection. Supreme Court said, see, in respect of marking of documents, whether Xerox, anything, it has to be decided validity only at the time of argument.
To secondary evidence only.
Secondary evidence, Xerox, anything, marking of the documents, subject to that objection, it has to be decided at the stage of final arguments. On that basis only, I have, by 2 days back, I have dismissed that.
ಅವಾಗ ಈಗಲೇ ಅಲೋ ಮಾಡ್ಬಿಟ್ಟವ್ರೆ secondary evidence.
ಅದೇ ಹೇಳಿದ್ದು ಅಲೋ ಮಾಡಿರೋದ್ರನ್ನೇ, but allow subject to that you can raise an objection. Trial court while deciding that suit had to be examined whether it is necessary or not the stage of the marking ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಆತರ ಆರ್ಡರ್ ಇಲ್ಲ. ಆತರ ಆರ್ಡರ್ ಇಲ್ಲ.
Supreme Court.
Plaintiff
Supreme
is
Court
for-
judgment relying on that, that is also case related to the one of that members of that bar that has been argued by that Mandigi. On the basis that I have dismissed that.
Application allow ಆಗಿ ತಾವು ಹೇಳ್ತಾರ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ ಸರಿ ಹೋಗೋದು. Straight away allowed the application to mark the secondary evidence.
No,
There is no rider as such.
no, that will clear, make it clear. I will make it clear that
Page 29.
in that case also I have made it clear that subject to that objection. That is what that Supreme Court said.
That observation. Page 29 ಅಲ್ಲಿ.
2 days back, I have decided that is election petition affidavit filed by that senior member Pramila Nesargis, that affidavit.
ಇವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿಲ್ಲ. ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರು ಜೆರಾಕ್ಸ್ ಕಾಪಿ. ಪ್ಲೈಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಸ್ಟ್ರೈಟ್ ಅವೇ ದೇ ವಾಂಟ್ ಟು ಮಾರ್ಕ್. ದೇ ಶುಡ್ ಮೇಡ್ ಎ ಫೌಂಡೇಶನ್ ಫಾರ್ ಸೆಕೆಂಡರಿ ಎವಿಡೆನ್ಸ್ ಇಸ್ ಕನ್ಸರ್ನ್.
Whether that can be accepted or not, while deciding that, court has to be decided, not this. At this stage cannot be rejected. The Supreme Court said tomorrow case has been decided on the merit. If it is come to that appeal before the appellate court said that no, this has to be allowed, this document is necessary, then the entire suit has to be dismissed. Again, has to be therefore it should be on the record. Court has to decide, no, this cannot be relied because of this reason, therefore I am going to pronounce the judgment.
ಆ ತರ ರೈಡರ್ ಏನಿಲ್ಲ ಇದರಲ್ಲಿ. Straight
No,
away allowed.
Allah, that is what the law is that. If you want, you go through that judgment. That is Bipin Shantilal Panchal versus State of Gujarat and another. Following that, Supreme Court has sent so many matters, and I have disposed of only last week. Yes, I will say that this marking is subject to that objection. Yes, Kali. In this writ petition, petitioner has called in question order dated 15/11/2024, passed by learned Principal Senior Civil Judge JMFC Hassan in OS number 385 of 2022, whereby application filed by the plaintiff for marking Xerox copy of
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿಲ್ಲ.
application seeking for marking of Xerox copy of agreement to sale dated 20/11/2014. In spite of objection raised by the defendant, the trial court has permitted to mark the documents. The apex court, in case of 2001-3 SEC volume 1, in admissibility of the evidence, objection against that admissible of the documents, instead of court should make a notice of such a objection and decide it at the last stage of the final judgment. This procedure has to be followed except where the objection is related to the deficiency in the stamp duty of the document. The relevant paragraph (13) extract ಮಾಡಿ. In view of the above, there is no error or illegalities in the order passed by trial court. The writ petition is dismissed. It is made clear that the admission of that documents is subject to that objection and decide parties can raise that objection at the stage of arguments.
Fungibility of document subject to proof.
Yes, objection subject to the proof. Yes.
Serial number 26, Manu Prabhakar, Kulkarni for petitioner, V. Rupesha.
Please appear for the rest.
I have a short list of dates, my lords. Your lordship had heard this matter for a little while.
Yes.
This is about the plaintiff is claiming rights of easement. Lord. Lord, your lordship may please just see the list of dates.
Yes.
15/5/1987. There is a partition deed amongst the members or the ancestors of the plaintiff side family. In that partition deed, no easementary right is drawn out. There is no dispute there. Then, my lords, at serial number 3, there is a sale deed of one of the branch of the family.
Yes.
At serial number 3 sale deed,
Yes.
there is some common passageway or common road shown. The plaintiff filed suit on the basis that from 2004, there is a sale deed which shows some easementary right. Therefore, I am entitled to easement. That is the plaintiff's case. Lord, serial number 3, there is a sale deed. Serial number 4, there is a sale deed.
Yes.
That also says there is a common passage. Serial number 5, there is a sale deed. Serial number 6, there is a sale deed. They all refer to some land.
Yes.
Then, my lords, my respectful submission is after this, there are 2 other documents. Serial number 7 is an order of the revenue authorities.
Yes.
Where a kaludari that was passing through the land is rerouted to outside the land. In this order of the revenue authorities, there is no recognition of the road that is found in serial number 4. That is subsequently. 2004 sale deed says now on common passage bitkondidive. In the order of the deputy commissioner, that is the revenue authority at serial number 7, this road is not recognized. Then, my lords, your lordship may please kindly see serial number 8. This is the plan sanction issued by BDA in respect of the entire property. In this plan sanction also, there is no reference to the road.
Yes.
After this, my case is I build a compound wall and I develop some apartment complexes. In 2024, the plaintiff files a suit and obtains an ex parte injunction against me. The injunction is, he does not say, alli munche dari ittu compound wall katkondidare, direct them to break the compound wall and allow me to go. That is not his prayer. He says, no, alli dari ide, they are trying to obstruct me, injunct them. Ex parte order comes to be granted. I come before this honorable court in a writ petition because on the strength of that ex parte order, they bring a JCB and break down my compound wall. This honorable court says, all right, you don't use that road till the application for vacating stay is disposed of. During the time when this honorable court granted that order, they are using the kaludari created by the revenue authorities. Then my application comes to be rejected. The honorable trial court holds against me. I file an appeal. The appeal court also holds against me, and therefore I am before your lordships. Lord, my respectful submission is I come before this honorable court on 5 points. Lord, my first submission is,
yes,
when the plaintiff says prima facie that he is entitled to easement, Supreme Court has said he cannot simply say I have right to easement because there are different kinds of easements. He must specify in the plaint what is the kind of easement he is actually claiming right under. And that forms part of his prima facie case. My respectful submission is, in this case, his claim is that he has a right to easement on the basis of a sale deed. And I will show the plaint for that. There is case law of the Honorable Supreme Court and the Madras High Court which says, document basis mele easement right keltidre, only persons who are party to that document are entitled to the easement. Admittedly, the plaintiff is not party to those sale deeds.
No, subsequent purchaser through that property will not be pass on to that.
My lord, I bow down, it will pass on to subsequent purchaser. He is not subsequent purchaser. I am subsequent purchaser. So, my lord, suppose he has, my lord, that easement right. He sells the property to me. Only I will have the right. He is third party to the original transaction. Third party to original transaction does not have the easement. An easement created by contract is available only to parties to the contract or their successors. It is not available to a third party.
No, he is also purchaser.
He is not a purchaser.
I am one of the brother.
He is one of the family members of the original partition deed. A partition deed ಆದವಾಗ ಅದರಲ್ಲಿ ಇರಲೇ ಇಲ್ಲ. ಅವರ ಫ್ಯಾಮಿಲಿ ಅವರು ಈಸ್ಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ. Some other ಅವರ ದೊಡ್ಡಪ್ಪ ಯಾರೋ, they made the easement in favor of each other.
Yes.
I am saying that does not accrue to his benefit. It may accrue, as your lordship said, my lords, I bow down, it will accrue to the benefit of the parties or subsequent purchaser. I am the subsequent purchaser.
No, that he is not that person who is purchasing that property, that party who has, make an arrangement for this thing, easementary right.
Please, he is not. He is not. I will show from the plaint itself.
Where is this property then?
My lord, may I respectfully request your lordships? I have filed, my lords, the entire trial court records along with a memo.
Yes.
In that memo, there is a picture I will rely on which the plaintiff himself has filed. Page number. Page number. May I request your lordships to please go to page number 66 of the trial court record. This is plaintiff's file. This was filed along with a memo of all documents dated 10/2/2025.
Yes.
Lord, your lordship may please come to page 66. This is produced by the plaintiff himself. A rough sketch.
Yes.
If your lordship sees, my lords, at the bottom of page 66,
yes,
it says Schedule A property belongs to plaintiff. Purti kelage.
Purti kelagada schedule A. Yes.
Schedule A property belongs to plaintiff. Our tale mele, there are properties belonging to, on the left hand side, immediately above plaintiff on the left hand side is property belonging to one Kallurappa son of Veernagaya. On the right hand side, property belongs to Kallurappa son of Veernagaya. That is not him, not me, third party.
No, this agreement is between these two.
No, my lords. Two steps above, at the top.
Yes.
Plaintiff is 1, 2, 3, 4. At 4 is the your lordship will see, my lords, Schedule C property anta, north-south axis alli, in between, they write Schedule C property. If I may show it here, my lords, illide. This is, they say, Schedule C property is the, according to them, the easement.
B is there, D is there.
B, my lords, D, and just touching D, perpendicular to D,
C
schedule.
is the road. C is the road.
Please, my lords. They claim C and D both are the roads.
C and D are the roads. This who has made an agreement for easementary in this property?
My lords. So it was made by the Veernagappa, who is his some relative, is what he says, but it's not him. He is not part.
Owner of which property?
He is owner of Schedule B property.
Schedule B property.
Schedule B property.
He is easementary right with that, which is that other person?
My lords, the other person is from whom I have bought today.
No, which is his property?
His properties both are part of Schedule B only.
Schedule B.
Only Schedule B.
Easementary rights is between that owner of the B schedule.
B schedule property.
No, he is come there, somewhere there. Yes.
He is in Schedule C.
Yes.
Therefore, my lords, my first respectful submission is on the basis of contract.
Yes.
Aur keltidre, he must be party to the contract. He is not a party to the contract. This point neither the Honorable Trial Court appreciates nor the Honorable Appellate Court appreciates.
8 feet common person. 8 vanilla, 8 labor.
Yes. Then what my second respectful submission is, yes, the other kind of easement is easement by necessity. Yes. The plaintiff respondent has fairly admitted that there is another road. Ade map alli on the corner, there is another road. That is the road that I have created pursuant to permission of the deputy commissioner. Therefore, he has access. Avarig dari illa anta enilla. Therefore,
That easement of necessity
please, my lords.
to take out that right, you are creating that.
I have created a road.
Now that will take out his right for an easementary.
Of necessity, it will take out. If he claims easement of necessity, then section 41 of the Easements Act says, as soon as another road is created or another access is created, easement of necessity vanishes.
Yes.
Because it is dependent on necessity.
Yes.
In fact, my lord, in the last hearing, injunction, High Court injunction, how are you going on? Then my learned friend very fairly said,
Now you said that there is other road.
please,
No, but creating that other road by that other person.
I have created that other road.
His right has been
Changed,
taken. Yes.
not taken away, changed.
Yes, let us see that judgment later.
Please, my lords. This is second point. I will just make, my lords, 5 points. Third, my lord, my respectful submission is, on the date when the suit was filed, Schedule C and D property, there was a compound wall. I have pleaded it in my written statement. Now, I am not saying he cannot ask injunction, he can ask interim mandatory injunction. But the standard is very different. The circumstances in which interim mandatory injunction can be granted are very different. Neither the Honorable Trial Court nor the Honorable Appellate Court consider the fact that to access Schedule C and D, he has to break open my compound wall, which he has done. During the pendency of the suit, there is FIR on that basis.
Now this, who are the parties in this case?
Lord, the parties are only plaintiff and me. There is,
No, you are the only a contesting.
I am the only contesting person.
Because after I spending so much time, it cannot be say that other parties is not served.
The service complete.
Service complete.
Service is complete. Service is complete.
I represent for all.
Yes.
Yalla plaintiffs, so my learned friend is appearing from. That, my lord, is my third submission. That the existence of a compound wall prima facie should have been examined by the Honorable Court.
Yes.
My fourth submission is,
Yes.
both the Honorable Trial Court and Appellate Court proceed on the basis that one sale deed ಇದೆ, ಆ sale deed ಅಲ್ಲಿ ಏನೋ ಒಂದು ದಾರಿ ತೋರಿಸಿದ್ದಾರೆ, therefore it's a tribal issue. Lord, my respectful submission is, sale deed is from 2004 to 11, 3-4 sale deed ಆಗಿದೆ. In all the sale deeds, there is some road shown.
Yes.
Subsequently, there is a development plan sanctioned by BDA.
Yes.
Subsequently, there is a road sanctioned by the revenue authorities.
Yes.
Both of them don't show the existence of this easementary road.
Yes.
Neither BDA sanction plan nor revenue authorities.
Yes.
Now, my lords, my respectful submission is prima facie. Once upon a time, there were some sale deeds showing some road.
Yes.
But BDA sanction plan does not show any road. Therefore, my lords, on documentary basis, prima facie, today there is no road.
Yes.
That BDA sanction plan is not challenged. It's of 2017.
Yes.
They have not claimed any relief in that regard. That, my lords, is my point number 4. Then, my lords, my point number 5 is, at the prima facie stage, balance of convenience, I have built an apartment complex. They have another road. They don't dispute they have another road.
Yes.
In those circumstances, and they have sought for a declaration that this road is easementary road. Before declaration is granted, if they anyways have a road and that road is sanctioned by revenue authorities, should an injunction be granted? And has this point been considered? In this light, your lordship may please, my lords, in that same memo of documents, please kindly see page number 4, which is the plaint.
Yes.
In that very memo, my lords, page number 4 is the plaint.
No, in that,
in that compilation itself.
page number?
Page number 4, the first document, my lords, is the plaint.
Yes.
If your lordship will please see, my lords, paragraph 4 at page 6.
Hmm.
The plaintiff submit that all the children of Irnagaya got divided the joint family properties under partition deed dated 15/5/1987. In the said partition, land bearing survey number 25, measuring 2 acres 34 guntas of Dodbele village, Kengeri Hobli, was fallen to the share of the first son, namely Dasappa. They are not children of Dasappa.
Yes.
Now your lordship may please note, my lords, page number 7, ಅಲ್ಲಿ ಒಂದು ಚೆಕ್ ಬಂದಿದೆ in the middle of the page. Just below that, my lords, just below the check bandi, the plaintiff submit that in the partition deed dated 15/5/1987, there was no description with regard to road in the scheduled properties in respect of land bearing survey number 25.
No, page number?
Page number 7, my lords.
After that, yes, yes.
Yes, my lords. May I read it again?
Yes.
The plaintiff submit that in the partition deed dated 15/5/1987, there was no description with regard to road in the scheduled properties in respect of land bearing survey number 25. Lord, I will subsequently read out section 13 of the Easements Act. Section 13 says, family property iruvaga partition deed ಮಾಡ್ಕೊಂಡ್ರೆ easement must be shown in the partition deed. If it's not shown in the partition deed, there is no easementary right.
Yes.
Then, my lord, subsequently what happens is,
What is the stage in the suit?
Issues for issues.
and I have 7 rule.
No, as per that arrangement made by this court, in that earlier petition, can be continued.
No. I am not.
I'm not forcing you. I will hear you. In case after hearing that, if I give any finding, it may affect that final decision of the court. Therefore, I ask that.
No,
Yes.
no.
I will hear you that.
Please.
Yes.
That is the internal arrangement. They have made a false submission before this honorable court and obtained it.
No, that. if
Thereafter,
it is-
bringing
if
the
you are
facts before
agree-
this honorable court, the honorable court directed the trial court to consider. Till then, ಇಲ್ಲಿ status quo ಮಾಡಿದೆ, ಅಲ್ಲಿವರೆಗೂ status quo ಇರಲಿ ಅಂತ ಮಾಡಿದೆ ಅಷ್ಟೇ. Apart from that, they are suppressing the truth. Let my learned friend argue whatever he want. I will make my submission.
Yes. Yes.
Then, my lords, at page number 7 itself, on there is a just above the Chakubandi, there is reference to a sale deed. This is for the first time that in any record, even according to the plaintiff, there is reference of an easement. Even according to the plaintiff. That sale deed, my lords, your lordship will please see the date. It is 25/3/2004. Just above the Chakubandi, it says,
Yes.
sale deed dated 4 lines about 25/3/2004, which
Yes.
is registered in the office of the sub-registrar Kengeri, so and so.
No, according to you, said that after 2014, when the suit is filed,
2024,
as on that day filing, there was no.
there was no road, there was a compound wall.
Yes.
In this Chakubandi, my lords, what they rely on is
Yes.
Dakshinake, ide jamininalli, that's page number 7.
It is between whom?
My lords, this sale deed
Yes.
is between one Iranagappa and Guru Rajappa. It is not between the plaintiff. And
25.
ultimately, I have purchased this property.
Yes. Between?
Lord, ultimately, I have purchased it. They don't dispute that.
Yes, between whom?
This, my lords, is between Guru Rajappa, Iranagappa sells in favor of Guru Rajappa. That sale deed is at page 43
Iranagappa to
Guru Rajappa.
from them you have purchased.
Lords, from then, there is,
Jayamma.
Yes, yes,
there is one Jayamma, and ultimately I have purchased.
yes.
After it changes
Yes.
various hands.
Yes.
So in the plaint, they also say how in each one of the sale deeds, the same Chakubandi was maintained. Then your lordship may please come, my lords, to their prayer at para 12, at page 12.
Yes.
Declare that the suit schedule C and D properties as common road passage, which is part and parcel of suit schedule B property for ingress and egress to suit schedule A property. Lord, my submission on easement would be that until and unless all the neighbors are made parties, No such relief can be sought. Now, my lords, your lordship may please see the prayer in page 12 and your lordship may please come to page 66. This is the plaintiff's sketch. So therefore, this is not in dispute at all that he is not the neighbor of suit schedule B property.
Yes,
There are two properties in between. They may be his relatives.
yes.
He claims to be. But page 66 is the map.
60? Yes,
66, my lords.
yes.
Suit schedule A property ಮತ್ತು suit schedule B property madhya there are other property owners. Lord, my respectful submission is entire Easement Act is based on the premise that they are neighbors.
Yes.
One is dominant owner, one is servient owner.
Yes.
The moment neighborhood is not there, easementary right cannot be claimed.
Yes.
Then my lord may kindly come to the valuation slip at page number 19.
90.
19, my lords.
Yes.
In this, your lordship may please see, my lords, point number 3.
Yes.
The subject matter of the suit schedule C and D property for the purpose of jurisdiction is valued at rupees 50 lakhs. Plaintiff's own valuation.
Yes.
At 50 lakh, the suit should have been filed before the court of the Honorable Senior Civil Judge. Suit is filed before the court of the Honorable Junior Civil Judge. Not candidly, 39-192 stage ali, I did not take this point. Before the appeal court, in the first appeal in MA, I took this point, saying suit itself is not maintainable. The Honorable Appeal Court says, applying section 21 CPC,
Yes.
you Calgin court ali tagobekagittu, tagondilla, therefore today you are precluded in raising this point before me.
Yes.
My respectful submission, my lords, is there are two judgments of the Honorable Supreme Court on this point, that it's only after trial that section 21 applies. Section 21 does not apply at preliminary stage. And here, nothing needs to be proved.
No, still deciding that jurisdiction, is it a bar to decide that IA under Order 39 rule or not?
It is not their case at all before the trial court.
Wait.
I am obliged, my lords. Before the Honorable First Appellate Court, I submitted 3 judgments of this Honorable Court saying prima facie jurisdiction is part of prima facie case. If prima facie jurisdiction is not there, 39-1 and 2 must be rejected. I submitted 3 judgments, consistent view of this Honorable Court.
No, that, where is that court fee? They have mentioned that?
Lords, page 19,
Yes.
point number 3. The subject matter of suit schedule C and D property for the purpose of jurisdiction is valued at rupees 50 lakh. So he himself is valuing the suit at 50 lakh. It must go before senior civil judge.
Where you are reading?
Page number 19, valuation memo.
Valuation slip.
Please, my lord, see the valuation slip. There is point 1, 2 and 3.
Yes.
Please, your lordship may please see point number 3. The subject matter of the suit schedule C and D property for the purpose of jurisdiction.
What is that pecuniary jurisdiction of that civil judge junior division?
5 lakhs, man.
5 lakhs. Yes, now that, why that you have raised that?
Lord, kindly see point 1, my lord. ಅವ್ರಿಗೆ ಏನ್ ಪಿಕ್ ಅಂಡ್ ಚೂಸ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಏನ್ ಬೇಕು ಅದನ್ನ ಹೇಳ್ತದ. The suit is one of easement right through suit C and D property. Hence the suit is valued as per section 24 subclause D and 30 of KCA F and SB Act. The subject matter of suit C and D schedule property is valued at rupees 1,000 and hence the court fee of rupees.
That is for the court fee. Jurisdiction, you said 50 lakhs. You said that 50 lakhs for a jurisdiction, Mr.
That by mistake it has been.
that is-
Now they have filed an application before for transfer of case. Aden idinta illa.
No. Now the law is, if the.
It is not their case before the trial court. Allah written statement or contention.
You answer my question. If the law is that 39-1 and application cannot be considered when there is an objection regarding the jurisdiction.
Yes.
I will ask them to do it.
No.
Reconsider that.
It is not their contention in the.
I don't want to waste unnecessary time. I am putting that, shortcutting that points to answer If you are ready, I will do it. Otherwise, I will
Alla,
decide on the basis.
I can
I
restrict
see-
my claim and I can file fresh valuation slip 50 lakhs alla 5 lakhs anta.
I don't know that all this, whether law permits
I
or
will-
not. As on today, it is that, let the court decide, there you can do it, whatever that. If that is the law, if you are not disputed, why I want to waste the time? Because see that I my lease,
Alla,
therefore I am worrying that, otherwise I can sit
Alla,
leisurely and hear.
the
That is not-
subject matter is different.
No, this jurisdiction point can be raised. That is what he said. If that would be the judgment, unless
He
he
has not produced any judgment, he is simply is saying.
Counsel, you have right to argue everything. If you are, yes, that is true. If you are accepted, I can shed court and send it. Otherwise, I will hear you. I will hear you that, yes.
I can restrict that point, I can file fresh valuation slip before the trial court. That is
That
not.
is all after your filing. As on the date passing an order, this was the valuation. Yes, could you judgment?
ಅಲ್ಲ ಅವರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದನ್ನ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡ್ಬೇಕಿತ್ತಲ್ವ ಸ್ವಾಮಿ ದೇ ಹವ್ ನಾಟ್ ಟೇಕನ್ ಸಚ್ ಕಂಟೆನ್ಷನ್ ದೇ ಹವ್ ನಾಟ್ ಅಮೆಂಡೆಡ್ ದೇರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ದೇ ಹವ್ ನಾಟ್ ಮೇಕ್
I will see whether it can be permitted. That's what he is arguing.
when they have not taken such contention in the return statement.
Yes, you are. Wait, mister. You take your seat, mister. I will hear.
Please,
Yes.
my lords.
Just finish.
Last time
Yes.
I had submitted, my lords, list of judgments.
List of the authorities.
Please, my lords.
Yes.
The first judgment, my lords. Your lordship may please come to para 59 and 60.
Yes.
But para 59 and 60, my lords will please find at page 52 and 53.
Para 59.
Para 59 at page 52.
First judgment.
First judgment, my lords, judgment of Honorable Coordinate Bench,
Yes. Page.
page 52, para 59.
Yes.
As for the sale deeds and the gift deeds, the alienees are in possession of the properties. In that view of the matter and also in view of the legal presumption of complete partition, plaintiff being in joint possession is highly doubtful. Despite that, the suit is valued under 35(2) of the Karnataka Court Fees and Suits Valuation Act, and the court fee of rupees 200 is paid. The suit appears to be covered under 35(1) of the Act, which requires payment of court fee on market value. Therefore, the correctness of valuation of the suit and payment fee is also doubtful. It is settled position of law that prima facie case includes maintainability of the suit. When maintainability of the suit as formulated is doubtful or the suit is prima facie vexatious, it cannot be said that applicant has prima facie case.
Yes.
Then, my lords, your lordship may please come to para 63 at page 54.
Yes.
When there was no prima facie case, the question of considering other aspects of balance of convenience does not arise. Trial court failed to evaluate materials in an objective manner. Impugned order of temporary injunctions suffers perversity. Application is rejected.
Yes.
This was also an MFA. Then, my lords, the second judgment of Honorable Division Bench of this Honorable Court. Your lordship may kindly come to para number 14 at page 61 and 62. At page 61, para 14.
Yes.
The trial court has made certain observations doubting the genuineness of one of the documents filed by
Para?
the para 14, my lords, page 61.
Yes.
The trial court has made certain observations doubting the genuineness of one of the documents filed by the third defendant by reference to the date mentioned. This again is a matter of evidence which will have to be considered afresh by trial court. Any expression of opinion may prejudice the rights of the parties. Hence, we do not express any opinion in this regard. Thereafter, my lords. However, one of the factors to be considered by the trial court while considering the case for temporary injunction is whether prima facie case is made out by the plaintiff. That certainly would include, the nature of the suit filed and its maintainability. If on the face of it, the suit is not maintainable, the question of issuing any temporary injunction would not arise. The third defendant had raised the question of maintainability of the suit, and the trial court has left it open to be considered at a later stage. We do not think that this is a case where the trial court should have postponed the consideration of the said question, having regard to the very nature of the pleadings.
Yes.
Third decision, my lords, again of a honorable coordinate bench at page 63. The relevant paragraph, your lordship will please find at page 73. This is also MFA. The judgment at page 63 is also, my lords, an MFA.
Page 63.
Please, my lords.
Which is that paragraph you are relaying?
Paragraph, my lords, is para 23
Yes.
at the last page, page 73, just from the top, if your lordship
Yes.
permits me to read, my lords.
Yes.
this view of, by me above, this view of mine is also fortified by the view expressed by the Honorable Division Bench of the High Court of Delhi in the case of so and so. Therefore, in both the cases, the court at Bangalore would lack jurisdiction. In the case of Sterling Mac versus Donald Corporation, this court has held that no temporary injunction can be granted if the suit on the face of it is not maintainable. Therefore, in the instant case, the contentions urged on the aspect above of deceptive similarity and other aspects on merits would not arise since discussion made above.
Yes.
Therefore, only on jurisdiction. Then, my lords, your lordship may please see the next judgment of the Madhya Pradesh High Court. This explains in great detail why this is so. This judgment starts, my lords, at page 74. The relevant paragraph, your lordship will please find at para 7, page 77. Para 7, my lords, page 77.
Yes.
By judgment dated so and so, this court held that before granting injunction, the court is required to consider the existence of a prima facie case, which would imply prima facie consideration of jurisdiction of this court. There would not be a prima facie case if the court considering has apparently no jurisdiction to entertain the suit. We are clear in our mind that the observation made by the learned single judge are perfectly justified. For consideration of existence of a prima facie case, the court must consider its own jurisdiction while considering prima facie case.
Yes.
If the court holds that it does not possess jurisdiction and or the suit is barred under some provision of law and or suit is otherwise not maintainable, then certainly the court considering prima facie case has to hold that there is no prima facie case in favor of the plaintiff. Every court must bear this aspect in mind and seek its prima facie satisfaction that it has jurisdiction to entertain the suit before it proceeds to pass an order injuncting the defendant. Once the court is satisfied that it has jurisdiction prima facie, then the court would be called upon to consider a prima facie case on the facts of the case. If the court is of the opinion that in view of the prima facie case, which ordinarily means a triable issue for consideration of the court, then the court will have to proceed further and make an order under the circumstances of the case.
Yes.
Now, your lordship may kindly see, my lord's judgment of the Honorable Supreme Court that if there is no jurisdiction, then the decision is of no consequence.
1964.
Yes.
Then your lordship may please come, my lords, to
Yes.
here your lordship may kindly see, my lords, para 7. My lord, this was a case where a suit comes to be filed. In response to a suit, an application is filed saying, please refer it to arbitration.
Yes.
That application is rejected.
Yes.
Thereafter, the plaintiff says, no, this honorable court does not have territorial jurisdiction. Then the defendant takes a point saying, you did not take this point earlier, therefore you have waived this point. In that context, your lordship may kindly see para 7.
No, that is under the CPC waiving is only at the final degree is passed.
I am obliged, my lords. That is precisely what the Honorable Supreme Court says in para 7.
Yes.
Counsel for the plaintiff also submitted that defendants having neither alleged nor proved that there has been a failure of justice in consequence of the order of the High Court, they are precluded by section 21 of the code from raising this objection in this court. We think this contention has no force. The suit has not yet been tried on merits. So far, only preliminary issue as to jurisdiction has been tried. That issue was decided in favor of the defendants by the trial court.
That's the intention is that after court has
trial,
put in so many effort and decided that, then in that appeal or later stage, if it is raised this objection, all this will be, yes. Yes,
Therefore,
that is what that intention.
please,
that
my lords,
21 is.
candidly, my lords, before the trial court, I had not taken, but before the first appellate court, I mentioned this and I took this point. The first appellate court says, I cannot look into it. The first appellate court does not say, no, there is jurisdiction. Therefore, my lords, as your lordship had indicated, if the matter is remanded, it may save time.
Yes.
With regard to jurisdiction, my lord, it is not a point before the trial court. They have not taken any contention as such.
Yes.
In their written statement with regard to jurisdiction. At first point of time, they have raised in the appellate court.
Yes.
Even till today, they have not made any amendment, filed application with regard to amendment of written statement with regard to jurisdiction is concerned.
Yes.
The trial court and appellate court, looking after the prima facie case, passed the order. When they have not taken the contention of jurisdiction before the trial court at all,
Yes.
before this honorable court, they are not entitled to take. In all the cases which my friend relied, it is the contention of the parties before the trial court with regard to jurisdiction. Here they have not taken any contention at all.
Yes.
When they have not taken such contention, it is. The facts of the case is, my lord, one.
You are relying any judgment that if it is not taken. That's.
He has not produced earlier, he has produced.
Before the first appellate court, I filed the same list. This my friend cannot say.
He has not, only with regard to
Order
easement, yes, ma'am.
All points should be ready. See, I have wasted all these times. Therefore, time and again, I am saying that you make your properly, because I do see, it is not that I'm just sitting and enjoying, Mister. See that list. So many matters are there.
Lord, this
Therefore,
was
that
not the judgments produced. He has produced other judgment. This was not.
lawyer should be ready in all points, Mister. It is cannot that after raising that, I will take it and.
I am ready with regard to jurisdiction. It is not his case before the trial court.
Yes, sir. That's what you have not raised that. Therefore, it is first time it is rising. Yes. What is that next point? Yes.
With regard to, I will.
No, that's not. See, jurisdiction. See, pecuniary jurisdiction. It is touches the jurisdiction of the court. Even if it is not raised,
I will.
It is for the court to take any decision, and if it.
On the other hand, my lord, now the senior civil judge has passed an order confirming the order of the trial court.
That doesn't.
If the matter transferred to the senior civil judge, there is a number of apex court judgment. Our judgment part is
because High Court has earlier entertained. Therefore, it can be, that cannot be that. Now that whether court has a power to raise.
The order of the past in MA will be continued. Only the thing is that if it is court finds that there is no jurisdiction, it will be transferred to senior civil judge. That's all. Apart from that.
No, whether before deciding that, can I grant an injunction? That is what the judgment he has relied.
It is
He has
not.
no jurisdiction. Now, if that would be the case, first court has to decide, yes, this valuation is correct. If I have no jurisdiction, go to that so and so court. Their court will decide that for application of.
I will verify and I will come back to my lord.
That is the what the law.
Please.
That should be have to be submitted. Yes, tomorrow.
2 days.
Tomorrow, I will forget, Mr. Whatever the
Nale
law, that is what that. Yes.
Tuesday, my lord. 11th.
Tuesday, yes. This, that is the point. Instead of going all other points, I said that if you satisfied that, then you will go to that other. Otherwise, unnecessary wasting the time. This touches the jurisdiction of the court. Therefore, whether court can be passed. That's
if he has raised such contention in the trial court, avaga madbodittu. They have not raised. Their case is. Let my learned friend point out in the written statement saying that I have raised the question of jurisdiction. He has not made.
No, you show me that this is the judgment. If it is not raised in respect of that, court can be proceed. See, if it is not raised, if he raised after that judgment, it cannot be. It is barred under section 21.
Yes, he is raising at the appellate stage. Hence, the appellate court has.
No, degree, after the degree. Yake anta andre, ಕೋರ್ಟು ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿ ಟ್ರಯಲ್ ಮಾಡಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಾದ್ಮೇಲೆ ಇನ್ ಅಪಿಲೇಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನೀವು ರೈಸ್ ಮಾಡಿದ್ರೆ ಆಲ್ ದಿಸ್ ಒಂದ್ ಸೂಟಿಗೆ ಇಟ್ ವಿಲ್ ಟೇಕ್ 2-3 years. Therefore, legislator has start that there should be a break for that. If it is in the earlier stage, then if it is court has no jurisdiction, that order which is passed is null and void. It is in nullity. That cannot be allowed. That's what that. Yes.
11th.
Yes. 11th. Yes.
Cell number 27, Partition GS.
Yes.
35. After that, she being a woman folk, the document was of 35, your lordship.
Yes.
She has, subsequently, she has obtained the documents and she has filed 2 applications, one for suit for partition and separate possession.
Yes.
She has filed, after obtaining all the documents, there were several registered transactions between 35 to 87.
What is that amendment you sought?
Annexure C is the amendment application. I have sought for amendment of the pleadings, your lordship.
What is that pleading you wants to be inserted?
That item number 2 of the scheduled property was purchased by her father during 35. And after that, due to some financial necessity, the mother has, after the death of her father, mother has sold the property. Registered conveyance deed has been done, your lordship, and 2-3 registered transactions are there. Subsequently, the property was purchased in the name of the mother and she has executed a will in favor of the defendant number 1.
In favor of?
Defendant number 1. Respondent number 1. Now I have produced all the documents I have obtained subsequently.
No, see, you have filed in a suit for partition.
Yes, your lordship. At the time of filing the suit, I have mentioned that the property was purchased by the mother of the plaintiffs during 87.
Mother of the plaintiff has purchased that property.
Yes, your lordship. Subsequently, I came to know that the property was purchased by her father during 1935, and after the death of the father in 1966, the mother has sold the property for the financial necessity, and subsequently she repurchased the same. 2-3 registered transaction has been done.
Now, first it is father. Then mother has sold.
Mother has sold.
Then mother has purchased.
Purchased.
Now, ultimately, it is property is purchased by that mother later.
Mother later, your lordship.
Yes.
She has executed.
Now, property which is purchased by that her husband, she has sold.
Due to some financial necessity.
Yes. Now she has purchased. It become her Sridhana.
No, your lordship. Section 14 will not attract. Previously, the property was purchased by her father. My contention is that it is
No,
joint
property purchased and she has sold for a family necessity. That is the end of the matter.
He was not having any financial income.
No, once it is sold, now she maybe purchased the same property.
Yes, your lordship.
She could have purchased other properties also. If it is same property, you can't say that it is in a joint family property.
The registered transaction was the reconveyance deed. And she purchased that. The defendant also admits that in the written statement, the property was purchased by the father during 1935. That I came to know later, and I have filed 2 applications.
Yes.
One for production of documents and other for amendment of the pleadings. My application.
Why it is rejected?
That the cause of action will change.
Where
But
is
no cause of action. The reasons start from in page 60, your lordship.
60?
60.
60.
60.
Yes.
But the reason for rejecting the amendment application is that in page 71, para 24, your lordship.
Yes.
These proposed pleadings are connected to the above discussed paragraph.
Para?
24.
24. Yes.
In the work, these proposed pleadings are connected to the above discussed paragraph, that is paragraph 7. In the original plaint regarding item number 2 of the suit settled property, the plaintiff has averred that it is the property purchased by her mother. Now she is changing it as the said property is purchased originally by her father. The date of sale deeds is also different. As per proposed amendment, she is totally changing the cause of action of the suit in respect of item number 2 of the suit scheduled property, which is not permissible under law. This is a suit for partition. Cause of action will not change. The fact that the property has been purchased by the father is admitted by the defendant in the written statement.
Issue notice, stay of further proceedings in OS number 5129 of 2018, pending in the file of 16th Additional City Civil and Such that Bangalore till next date of hearing.
Cell number 28, K. Ravishankar, for petitioner Rakesh Tini.
30. Yes.
1 week time.
Yes, at the request, read this matter. At the request of petitioner, read this matter of.
Would I be permitted to file my objections, my lord, because they are not produced all the records?
Serial number?
Kvitter, my lord. I represent the Kvitters Council.
30?
28, my lord.
28.
Kvitters Council.
28. You file an objection. Yes.
Cell number 29, Vamshi Krishna C for petitioner.
Appearing for the
connected matter,
petitioner's
Rajeshwara PN.
Yes.
In the connected matter, I appeal for the petitioner. In the first petition, my lord, I appeal for respondent number 4, 6, 7, 8, 9, my lord. I have to file objections to the application.
Their
My
case.
lord, I have received the copy of the petition and annexure.
No, you are appearing for whom? Respondent number?
4, 6, 7, 8, and 9, my lord.
No, what about that other respondents? Who is appearing in your case?
My lord,
You have not made them as a party.
my lord, no, my lord,
Other
my
notice in a
learned
certain-
friend-
I am appearing for the respondent in the WP filed by them, my lord.
No, you are appearing for only
Because
some of the
notice has
respondents.
been issued to my case, interim order has been granted by this court. Now, the address has been, my lord, come back conserved. I will take. steps
That
in
service has
correcting.
to be completed.
For
Then you
certain,
are,
for certain other respondents, I have entered my appearance in
Yes.
so far as.
now you will issue notice in your case also. You take that notice. You will take to whom?
I will take 4, 6, 7, 8, and 9, my lord.
4, 6, so on.
My lord, I may also be permitted to take notice to the other side.
Yes, that
lawyer.
will, yes. Issue so and so is undertake to appear for so and so. Issue emergent notice to so and so other respondents. Yes.
Next
By,
week, my lord.
by hand, my lords, on the council appearing in the trial court,
In
I'll.
addition, he is also permitted to take out hand summons to that counsel appearing for the respondent before the trial court.
Please.
Yes.
In the meantime, I will file objections to the file.
In the meantime, you pay the process, Mr. Other.
Sir, I will, please.
My lord,
in my
I'm-
case, in my learned friend case.
My
I
lord,
will
in
file my objection.
serial number 21, I'm just told that we have already served copies on all the respondents. But however, my learned friend, of course, they seem
No,
to
how
have.
can you, sir? The notice is not as ordered. Before that, you can't. Mr.
Notice-
By hand, we had already.
No, but no notice has been
All right, my
ordered by
lords.
the court.
All right,
Yes.
my lords. So
Yes.
next week, my lords.
Yes, next week.
My lords, a date may be fixed, my lords.
Yes, when do you want, Mr.?
Next week, my lord.
11th or 12th, my lords, at your
11th or
convenience, my lords.
18th.
Please.
18th.
Interim
18th, my lords. My lords, 1 week earlier. If it is not too inconvenient, my lords, there's some urgency in the matter, my lords.
11th and 12th,
13th, my lords.
13th, I think a holiday. 13th,
Holiday, my lord.
Monday, my lords.
14th,
14th, my lords.
14.
14th.
Obliged,
Yes.
my lords.
My lord, interim order, my kind.
Interim order granted earlier is extended till next date of hearing.
14th, my
Number
lords.
30,
Highly
adjourned cell
obliged.
number 31, Nanjareddy PN.
Miller, suit was dismissed for default.
Hmm.
Miscellaneous filed, miscellaneous also dismissed for default. ಅದಕ್ಕೆ MFA ಹಾಕಿದ್ರೆ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಂತ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ವಿ.
Your miscellaneous filed under
ಆರ್ಡರ್ 9 ರೂಲ್ 9 was dismissed.
order 9 rule 9 ಅಲ್ಲಿ appeal ಇದೆಯಲ್ಲ, how can that treat is
ಅಲ್ಲ
maintained?
ಅದಕ್ಕೆ ಅದ್ರ ಮೇಲೆ ಮಿಸ್ಲೇನಿಯಸ್ ಹಾಕಿದ್ದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಿಸ್ಲೇನಿಯಸ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್.
No, you have filed a miscellaneous under which provision?
ಆರ್ಡರ್ 9 ರೂಲ್ 4.
Order 9?
ರೂಲ್ 4.
Rule 4.
ಎಸ್.
Order 9 rule 4. Where is that order, Mr. Reddy?
ಅಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಿಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
ಅನೆಕ್ಷರ್ ಪೇಜ್ 30 ಅನೆಕ್ಷರ್ ಡಿ.
No, why the suit is dismissed?
ಸೂಟ್ ಅಲ್ಲ ಮಿಸ್ಲೇನಿಯಸ್ ಸೂಟ್ ಅದೇ ನಾನ್.
No, how you can file an application under order 9 rule 4? It is only for restore to the suit where the suit is dismissed under order 2 rule 3. Then only you can file under order 9 rule 4.
ಅಲ್ಲ ಫಸ್ಟ್ ಆರ್ಡರ್ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಅನೆಕ್ಷರ್ ಬಿ.
Yes.
Annexure B, typed copy, 23 page 23. 23. Case called again at 3:10 PM. Since the date of the order, so on steps not taken. No representation for plaintiff. Plaintiff also is absent. There is no reason to adjourn, hence suit is dismissed. Against this period, I filed Annexure C, Order 9 Rule 4.
Order 9?
Rule 4, Annexure C. To restore the suit.
So that was also dismissed, for not taking steps. Against which I filed an appeal before the annexure E, page 33. This Honorable Court had felt that there was an office objection.
Annexure?
Annexure F E, my lord, page 33. There was an office objection that appeal is not maintainable. So this Honorable Court permitted.
43C so and so praying to that so and so. When the council of to filed a memo for withdrawing the appeal, as present appeal would not be maintainable before this court. So the petition before appropriate court. Why it is not maintainable?
Because on miscellaneous, other male miscellaneous, not against the order of the miscellaneous. Other male another miscellaneous was filed.
Out of 43 rule 1. No, you may be classified as a miscellaneous. That is not miscellaneous. That is an application, Mr.
Application.
Classification may be wrong.
Allee,
Order 9, rule 9.
Allee, all application dismiss another miscellaneous and then they will register.
No, that should be, you see that order 43, rule 1. An order under order 9, rule 9, rejecting an application for an order set-asiding the dismissal of the suit, the appeal is provided, miscellaneous appeal.
Oh.
You have classified wrong, that doesn't mean that law will change. That has to be brought to the notice of that earlier court. That order is not against the miscellaneous petition, against that application.
Yeah, application.
That cannot be there.
Yeah,
That is what is that appeal you have filed is correct, but you have mentioned that order 9, rule 4, not order 9, rule 4. Order 9, rule 4 is,
That may be,
should be order 9, rule 9.
that may be a mistake.
Order 9, rule 4 ಅಲ್ಲಿ ಏನ್ ಬರುತ್ತೆ ಅಂದ್ರೆ plaintiff where the suit is dismissed under order 2, rule 3, order 2. Under rule 2, rule 3, where suit is dismissed under rule 2 or rule 3.
Well, maybe that's
Where neither the parties appear suit to be dismissed. Oh, correct. Where neither the party appears when the suit is called on hearing, court may make an order that suit is dismissed. Or this is under, your suit is dismissed for non-prosecution.
Yes, default.
Either where that order, under order 9, rule 9 another. Degree against the plaintiff by default. The suit, where the suit is only dismissed under 8, the plaintiff shall be precluded from bringing in first.
The lordship may order notice on terms, it may be considered.
Wait, mister. Let
Yes.
us see what is the
Well,
jurisdiction
correct.
under. Before that, we can't. Yes. Plaintiff may bring a fresh suit or a court may be restore the suit to the file. Where a suit is dismissed under 9, the plaintiff may. He may apply for an order of set-aside and dismissal order. If satisfied the court that cause such a suit, reference non-compliance case may be, shall make an order set aside in the dismissal, shall appoint there. Yes, this is, it is not a miscellaneous. This is also an application.
The application.
But against that appeal is not maintainable. Writ is maintainable.
Correct.
Yes. Yes, issue notice.
Bless.
Dismiss for default, you can file an application there.
Yes, sir.
Recalling, against that writ is filed. But if ex parte order is passed under order 9, rule 9 will
Rule
come.
9.
Yes.
Cell number 32, yes.
My lord, I appear for petitioner, my lord.
Yes.
My lord, in a suit for recovery, initially filed before the Honorable Senior Civil Judge at Holenarsipura, came to
Yes.
be transferred to Bangalore Commercial Court, and later, my lord, it was retransferred to the Commercial Court at Hassan.
Hmm.
My lord, well before that, the defendant had filed his return statement. And in the original suit, as it was filed, my lord, the issues have been framed. Later, my lord, during the pendency of a commercial suit before court at Hassan, my lord, the defendant died, his legal heirs were brought on record. My lord, here I had filed 2 applications, my lord. My lord, the money is due for recovery of certain amount paid by me for purchase of peeling license and sawmill, my lord, and machineries, etc. My lord, without my knowledge, he sold it to someone else, and he moved it by about 5 trucks, my lord. So they all have passed through checkpost and under E-Sugam. Under E-Sugam. And my lord, what money I paid 70 lakhs, 65 lakhs, same day he put it to his bank. Now today that he is not there. So I had to file these 2 applications, my lord, for under order 11 rule 5 of the Commercial Court Act, my lord. Requesting the court to call for certain documents. The court is of the opinion, my lord, that I should have issued notice under Form 7, but that it is not like that, my lord. My lord, I may kindly be permitted to read.
Yes. First, we come to that impugn order. Where is that order?
Page 46, para 7 may kindly be seen, my lord.
Yes, read.
Yes. Moreover, as per clause 2 of rule 5 of order 11, the notice shall be issued in the form provided in form 7 in appendix C of CPC. As per the said form number 7, the notice shall be issued to any party or opposite party of the suit or proceeding or to the pleader. This would clearly show that the question of issuing a notice directing the third party to the suit to produce any documents does not arise under the provision under order 11 rule 5 of CPC amended by the Commercial Court Act. My lord, for a moment I will pass here, my lord. Your lordship may kindly, my lord, I will read rule 5, my lord, as amended by Commercial Courts Act.
Yes.
Order 11 rule 5, my lord.
Yes.
Any party to a proceeding.
No, you are
may
reading
seek.
that. No, order 10 rule 11 rule 5.
No, order 11 rule 5, my lord.
Order 11 rule 5. What is that starting?
Production of documents. Any party to a proceeding may seek or the court may order. My lord, my emphasis is on the word or the court may order.
In corporation or body of a person, whether incorporated or not empowered by law to sue or be sued. Yes, read.
My lord, it comes under schedule first, my lord.
Yes, read.
Amended.
Yes, read, mister.
Yes, ma'am. Any party to a proceeding may seek or the court may order. My lord, my emphasis is on the word court may order at any time during the pendency of any suit, production by any party or person.
No, mister, wait.
Yes, ma'am.
No, that 11.
Yes, my lord.
3.
This is 5, my lord. Actually, sub rules are more in each section, each of the rules.
Yes, there are so many subclasses.
Yes, my lord. Yes, my lord.
Where is that exactly?
After sub rule 7 under rule 4, rule 5 begins, my lord.
Yes. 7.
Unfortunately, properly compiled act, Bear Act has not come, my lord.
Wait. 6 is electronic records.
Correct, Swami. Correct.
Yes,
4
is 5 I am not getting here. Yes, production of documents.
Yes, my lord.
Yes. Any party
to a proceeding may seek or the court may order at any time during the pendency of any suit, production by any party or person of such documents in possession or power of such party or person relating to any matter in question in the suit. My lord, these are the things that are in question in this suit. Therefore, because I am not an account holder, I can't expect the certified copy to be given to me by the bank. The bank can only produce it in the court, my lord, further to direction. And E-Sugam records also, which proves.
Now, what is the reason given by the trial court?
I should have issued notice under Form 7, it says, my lord.
No, this is
Actually,
court has to issue notice under 7.
Court has to issue, my lord.
Where is
That
the
is the
Form
point.
7?
Form 7, my lord, it is under, actually that format has not been changed, my lord. It has been retained without any changes.
Yes, form number 7 is not inserted in this.
Not inserted, my lord. I think court is carried away by that unchanged format.
Yes, this is not there.
Yes, my
Any
lord.
party to the proceeding may seek or court may order at any time during the penal session. Form number 7. Yes. You take notice, Mr.
My lord, meanwhile, an interim order of stay, my lord, it's my suit. The
Yes,
court is
Lord.
insisting me to
Issue
proceed.
notice. Stay of further proceedings in OS number. Commercial OS number 2 of 2019.
Yes, my lord.
Pending in the file of Principal District and Session Judge Hassan till next date of it.
I may kindly be permitted to serve a copy on the counsel appearing in the suit,
Yes,
my
in
lord.
addition, permitted to serve copy on the counsel appearing for respondent before the trial court.
Yes,
Page
my lord.
number 33.
Highly obliged, ma'am.
Per petitioner, my lord.
Yes,
My lord, the application, my lord, the 21 rule 29.
yes,
Stay the execution proceedings was dismissed by the trial court, challenged in this petition.
yes.
By reason, my lord, earlier very same the respondent filed the suit, my lord, 1-2-3-2-2006, it was decreed. 4-2-2011, that was decreed. My lord, again, 2014, on 5-4-2014, 5-1-2004, OS number filed against the defendant. My lord, that suit was, my lord, the evidence was completed. On that, my lord, the respondent taken contention. His property is survey number this 1/6.
No, suit is decreed.
First, my lord, the injunction suit was decreed. That is decreed on 4/12/2011 against the father of the petitioner. My lord, thereafter he has filed the suit for mandatory injunction for the declaration against the son of the father. But that OS number filed on 5/4/2014. After lapse of 4 years, he has filed the suit for mandatory injunction to demolish the building and recover the position. In the respondent has filed the statement, taken contention that the property
So
is.
suit is decreed.
My lord, that suit is pending.
That suit
Now,
is
my lord, their 16/3/2011 has filed the execution petition.
in the on executing of
Earlier suit. That in the execution of the earlier suit, the execution petition is filed.
No, that is only for injunction.
Injunction. Now, my lord, in meanwhile, the pendency of the second suit, he admits that he has no objection to appointment of the commissioner
Now,
to inspect the
now
property.
what is the order which is challenged here?
My lord, challenge is 21 rule 29. That application was dismissed by the trial court.
Where is that?
That is, my lord, page number 12, my lord, annexure A. Reason is my lord, last page number 19. Only protract the proceedings by the JDR in the last line, my lord. Protract the proceedings in JDR. In case of the hand, the application filed by the JDR is nothing but delay the proceedings. Hence, the application is liable to be dismissed.
Yes, you take notice.
My lord, earlier, my lord, this honorable court has issued the appointment of the court commissioner, page number.
Yes, this order is passed after 1 year. You are coming before this court.
My lord, court commissioner appointed, court commissioner has
Now you are
submitted.
challenging after 1 year.
My
You
lord,
take notice, Mr.
Earlier, this honorable court has directed to submit the court commissioner report. Court commissioner report, my lord, it is against the respondent also. Earlier, this honorable court has.
No, in this case, order which you have challenged,
Yes, my lord.
passed in that
2024
February.
My lord, 1 year,
Yes.
1 year.
Now there is no
In-
urgency. You take notice.
The urgency, my lord, this
No,
honorable
Mr.
court directed.
Or
to-
I will dismiss it that on the delay itself.
Yes, please.
Yes.
And permitted to serve the notice on record.
Yes,
in the
in
trial
addition,
court.
permitted to serve a copy on the council appearing for the rest. Yes.
Serial number 79, my lordship. Last time it was said, no adjournment would be given because of some, this one. Kindly take it up at 4:30, my lord.
Let us see, Mr. We have.
Request to.
Serial number 54, my
Huh?
serial number 54. Expedition file ಮಾಡ್ಬೇಕು, it has to be MFA file ಮಾಡ್ಬೇಕಾಯ್ತು, conversion.
50? Yes. Office has raised an objection regarding the maintainability. Counsel for the petitioner has filed in a memo. You want to withdraw and file a fresh or
I'll
convert? Filed in a memo seeking leave of this court to convert this writ petition into miscellaneous first appeal. Memo is taken on record. Petitioner is permitted to convert this writ petition into MFA. For the statutory
Cell number
purpose.
51, your lord.
Is there, ma'am?
Yes, you convert it and move before the
Cell 51, your lordship.
59. Oh. Yes, have you informed other side?
Taking steps against the respondent.
Yes, you are only one respondent. Yes, so and so. Undertake to appear for respondent. Office is directed to show her name. Yes, leave this matter.
Lordship, cell number 51. I pray 1 week time for compliance, your lordship.
50?
51.
Yes, at the request of counsel for the petitioner, week's
1
time
week
is
time.
granted to comply of.
Much obliged.
My lord, serial number 40A, I appear for the petitioner, my lords. 1 week's time may be granted for office or objections compliance.
Yes, week's time to comply of subjection.
Serial number 45.
45.
In 2 days, I complied office objection.
Yes, 45 weeks time is granted.
My lord, serial number 23, past of matter, it's dismissed for 9 to 9, my lord. I am permitted to convert the same in MFA, my lord. Liberty reserved for me and section 14 maybe limitation act for the wrong forum, my lord, maybe
Which is that serial number?
23, my lord.
23.
Please, my lord, am I permitted to liberty to convert the same writ petition as a, since a miscellaneous order under 9 to 9, my lord, it was passed.
Again, officer. ಏನಂತಾರೆ ಏನಂದ್ರು ತಪ್ಪಾಗಿದೆ ಅಂತ ಅಂದ್ರೆ ಏನಂದ್ರೆ
Please, my lord.
Yes, memo haki.
Please, my lord.
Learned counsel for the petitioner has filed in a memo seeking leave of this court to what this statutory filing. File a lecture. This writ petition into that miscellaneous first appeal. Memo is taken on record. Permitted to convert this as an appeal for the statistics purpose.
Section 14 may be wrong forum, delay in cause.
Convert ಮಾಡಿದೀವಲ್ರಿ 14 ಎಲ್ರಿ ಬರ್ತದೆ.
Please.
Permitted to convert 14 ಎಲ್ ಬಂತು.
Please.
May I request for a date in that serial number?
ಬರತ್ ಮೇಡಮ್. Yes. Yes.
ಎಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಆಗಿದೆ? 48 ಎಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಆಗಿದೆ? ಇವಾಗ 35
ಮೆಮೊ ತಗೊಂಡ
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಇದೆ ಕೊಡ್ತೀನಿ ಎಲ್ಲ ಎಲ್ಲ ಕಳಿಸ್ತೀನಿ.
ಆಯ್ತು.
ಅರ್ಜನ್ ಆಗಿದೆ 2:30 ಬರ್ತಾರೆ ಅಲ್ಲಿ ಸಾಹೇಬ್ ಬರ್ತಾರೆ. ನಾವು ನೋಡ್ಬಿಡ್ಬೋಣ. ನೀವು ನೋಡಕ್ಕಾಗಲ್ಲ ಸರ್. ಅವರು ಎಲ್ಲ ಸ್ಕೂಟರ್ನಿ ಕೊಟ್ಟಿರ್ತೀನಿ ಸರ್, ಎಲ್ಲ ಬರ್ಬೇಕು. ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳ್ತಾರ ನೋಡ. ಏನಾಯ್ತು ಕಾಂಪ್ರಮೈಸ್? ರೆಡಿ ಮತ್ತೆ ಬರ್ಲೇ ಹೇಳ್ಬೇಕು. ಬೆಳಿಗ್ಗೆ ನಾಳೆಗೆ ಇವತ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ನಾಳೆ ಕೊಟ್ಟಿಲ್ಲ. ನೀವು ಮಧ್ಯಾಹ್ನ ಬಂದು ಅನ್ಅಫಿಷಿಯಲ್ ನಾಳೆ ಅಂದ್ರೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಬಂದು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ನೋಡೋಣ. ಅವ್ರು ಕೊಟ್ರೆ ನನ್ ಕಡೆ ಕೊಟ್ರೆ 3 ವಾರದ ನಂತರ
ಸರ್ ಮೇಂಟೈನಬಲ್ ಅಂದ್ರ ಇಲ್ಲ ನಾನ್ ಮೇಂಟೈನಬಲ್ ಅಂದ್ರ? ಅಲ್ಲಲ್ಲ ಅವ್ರು ಇವರು
76. ಇಲ್ಲ ಇಲ್ಲ 230 ಹೌದಾ ಈಗ ಬಂದಿದೆ ಡೇಟ್ ಹೋಯ್ತಾ ಈಗ ಮೂವ್ ಮಾಡ್ಬೋದಲ್ವಾ ಎಷ್ಟು ನಿಮ್ದು ಆಗಿಲ್ಲ ಭಯ
Conversion ಗೆ ಮೆಮೊ ಹಾಕಿ dispose ಆಗಿದೆ. ಮೆಮೊ ಕೋರ್ಟ್ ಆಫ್ ಲಿಕ್ವಿಡ್ ಇದ್ರ ಕೆಳಗಡೆ ಇರುತ್ತಲ್ಲ. ಕೀಬೋರ್ಡ್ ಕೆಳಗಡೆ ಇಟ್ಬಿಡಿ.
ಸರ್ ಅದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕಾಪಿಗೆ ಹೋಯ್ತಾ ಫೈಲ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿಗೆ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಫೈಲ್ ಹೋಯ್ತಾ ಇಲ್ಲಿ ಬರುತ್ತೆ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್
ಐವತ್ತೊಂಬತ್ತು serial number. ಒಂದು ನಿಮಿಷ ಕೊಡು. ನೆಕ್ಸ್ಟ್
ಇಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸ್ ಇಲ್ಲಪ್ಪ, ಕೋರ್ಟ್ ಆಫೀಸ್ ಇಲ್ಲಿ ಹೌದಾ? ಏನಿಲ್ಲ, ನಿನ್ನೆ 2 ದಿವಸ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾನಂತೆ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ, ಫೈಲ್ ಇನ್ನೂ ಹೋಗೇ ಇಲ್ಲ. ಅಲ್ಲ, ಕೋರ್ಟಿಂದ ಹೋಗ್ಬೇಕಲ್ಲ ಕೇಳಕ್ಕೆ, ನಿನ್ನೆದು. ಹಾ, ಮತ್ತೆ 2 ದಿವಸ ಟೈಮ್, ಅದೇ 2 ದಿವಸ ಟೈಮ್ ಹೋದ್ ಹೆಂಗ್ ಕಂಪ್ಲೈ ಮಾಡ್ತಾರೆ? ಇವ್ರು ಬಂದು ಹೇಳ್ತಾರೆ ಸ್ವಲ್ಪ, ಕೋರ್ಟ್ ಆಫೀಸ್ ಹೇಳ್ತೀರಾ?
2663 of 25. 3.
ಬಹಳ ಕಷ್ಟ ಆಗುತ್ತೆ. ಎಲ್ಲೆಲ್ಲೂ ನಾನೇ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿರ್ತೀಯ ನೀನು. ಶ್ರೀನಿವಾಸ. ಅಲ್ಲ ಅದು ಬರ್ಬೇಕಲ್ವಾ ಇನ್ನ. ಮಸ್ತಾಗಿ ಹೇಳಿದಿದ್ದಾರೆ ಮಗ. ಹಾ 99 ನೋಡ್ಬೇಕು. Passive performance and possession, then how is it that possession ಅಂತ ಹೇಳ್ತಾರೆ. Agreement of sale come possession agreement. Come possession agreement. Come possession. Agreement is that.
ಈ ಕೊಟ್ರೆ ತಪ್ಪು ತಿಳ್ಕೊಂತಾರೆ. ನಾನು ನಂಬರ್ ಕೊಟ್ಟೆ.
ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ.
ಹಾ ನಂಬರ್.
ನಾನೇ ತಗೊಂಡೋಗಿ ಕೊಡ್ತೀನಿ ನಾನು.
ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಈಗ ಕೊಟ್ರೆ ಅದು ಬೇಕಾದಂಗೆ
ಬೇಕಾಗಲ್ಲ. ಹಂಗೆ ಹೇಳಿ.
ಆರ್ಡರ್ಸ್ ಇದ್ರೆ ಮಾತ್ರ.
ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಹೋಗಿದ್ವಿ, ಈ ಕಡೆಯಿಂದ ಹೇಳಿ
ಯಾಕಂದ್ರೆ ಸಾಹೇಬ್ರ RF ಯಾವ್ದು ಬೇಡ ಅಂತ
ಆರ್ಡರ್ಸ್
ಅಲ್ಲ, ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಇರ್ಬೇಕಲ್ಲ.
ಇದೆ
ಫೈನಲ್ ಇಯರಿಂಗ್ ಇದ್ರೆ ಆಗಲ್ಲ.
ಇಲ್ಲ
ಹೇಳಿ
ಗೊತ್ತಿದೆ ಆರ್ಡರ್ಸ್.
ತಿರ್ಗಾ ತರ್ಸಿ ಅಂತ ನೋಡಿ. ಹಾ ಸಬ್ 76 ಕೇಳಿ ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ಕತೆ ಅಂತ. ಎಲ್ಲ ಅವರೇ ಡಿಸೈಡ್. ನಮ್ ಕೋರ್ಟಲ್ಲಿ ನಂದೇನು ಇಲ್ಲ. ಅವ್ರು ಬಂದು ಈಗ ಏನಿದೆ ಪೊಸಿಷನ್ ಅಂತ ಕೇಳ್ತಾರೆ, ಅದ್ ಹೇಳ್ತೀನಿ, ಆಮೇಲೆ ಅದ್ ತಗೊಳ್ಳಿ ಅಂತಾರೆ, ಹಂಗ ಹೋಗಿ. ನಿಂದಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಇನ್ನೊಂದು ಮೆಮೊ ಇಲ್ಲ ಎರಡು ಫೈಲ್ ಇಲ್ಲ ನನ್ನ ಪಾಸ್ವರ್ಡ್ ಅಂದ್ರೆ ಹಂಗಲ್ಲ ಅದು ಅವ್ರ ಕಡೆ ಕೊಟ್ಟು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೇಳಿದ್ದೇನೆ. ಎರಡು ಪಾಸ್ವರ್ಡ್ seven. ಫೈಲ್ ಬರ್ಬೇಕು ಚೇಂಬರ್ ಎರಡು ಚೇಂಬರ್ ಹೇಳ್ತಾರೆ ತೊಂದ್ರೆ ಆಗ್ತಿತ್ತು
Court officer? Court officer? Court officer? Serial number 85, my lord. Matter is settled. Not to pay the amount, my lord. So kindly have it on 90th.
Serial number
85.
85. The request of counsel for petitioner, please this matter next week.
19th. Inform the party. It's 19th.
Yes, 19th.
Serial number 83, my lord. Only quoted the premier hearing, my lord, as a vote for the partition. A permitted to concession. Now, allow ಮಾಡಕ್ ready ಇದ್ರು, respond takes time. But 2 times is coming, is not reached. Premier hearing ಹಾಕೊಂಡ್ರೆ
ಎಲ್ಲವೂ ಅಷ್ಟೇ ಏನ್ ಮಾಡೋದ ಅಲ್ಲಿ ಎಲ್ಲವೂ ಅರ್ಜೆಂಟ್ ಇರೋದನ್ನೇ ಹಾಕೊಂಡಿರೋದ
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ
ನೋ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಇಟ್ಸ್ ಎನ್ ಅರ್ಜೆನ್ಸಿ
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡೋದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೇಳಿದ್ದೀನಿ.
You show me that any only some of the matters I don't know that advocates has to be understood that ಆರ್ಡರ್ ಆಗಿ 5-6 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಅದನ್ನು ಕೂಡ ಮೂವ್ ಮಾಡ್ತೀರಾ ಅರ್ಜೆನ್ಸಿ ಇರೋದ್ ಮೂವ್ ಮಾಡಿ ಅಂದ್ರೆ ಅದನ್ನ ಮಾಡ್ತೀರಾ ನಾನು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ
ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಅವತ್ತು ಟೈಮ್ ತಗೊಂಡ್ರೆ ಅದಕ್ಕೆ
you have to wait your turn mister see that in all matters where there is an orders everybody is an urgent if I say your matter other person will also say that it has to be posted in the top of the list it cannot be done mister no one case cannot be done that preliminary hearing all matters before this list all urgent matters only ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ನಾವು ಪೋಸ್ಟ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟ್ರೆ 120 ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇದೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ನೋ ಇಫ್ ಐ ಥಾಟ್ ಯುವರ್ ಮ್ಯಾಟರ್ ದೆನ್ ಅದರ್ ಮ್ಯಾಟರ್ ದೇ ವಿಲ್ ಆಲ್ಸೋ ಆಸ್ಕ್ ದಟ್ ಟು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಲೆಟ್ ಅಸ್ ಸಿ ವಾಟ್ ಟು ಡೂ ದಟ್ yes you have filed an application
ಹೌದು
yes see that preliminary hearing matters they are moving that 50 to 60 matter what to do some of the matters there is no urgency still they are moving that
My lord,
I can point out after hearing then that yes let us see yes
serial number 109.
serial number yes 59 only you are there is no other person
ಅಲ್ಲ ಅವರು
she has filed an wakalat yes we said next week yes 14th 10th yes 14th let us see nothing will happen we will see on that 14th yes see in between if they one day holiday then my list will be become double I think that I don't want any holiday for that what to do that is the situation now because burden is for me again it will comes to that see nothing will happen I can sit at 5 o'clock and go I don't want to see that lawyers are standing here for hours together but what can I do I can do whatever I can do it that's all yes
My lord, serial number 109, there is an inconvenience.
serial number
109.
109
So senior is flying to abroad, sir. So kindly list it on 14th of this March.
yes sir the request party in person for the respondent madam who is that
serial number 109 Neha Gauss party in person.
if it is there you just inform
He is
yes
not there.
yes
So list it on 14th.
yes at the request of counsel for the petitioner please this matter next week let us yes no what is that you are moving that matter no vacating you give that memo we'll post it or 2 or 3 days we'll give an edit no what is that stay here
50 lakhs. So out of the compromise date is 4.48 lakhs. 4 years now I'm waiting for execution. Not paid. Some amount may be payable from the PWD is pending, but PWD direction issued by the execution court, PWD is ready to deposit. By virtue of the stay, he may really get release of the amount and run away from the.
Who will get released amount from there? Who has deposited there?
PWD is payable to the petitioner here.
Hmm.
And PWD is directed by the trial court member in the execution, deposit for the execution court.
Hmm.
Now, by virtue of this state, there are, the PWD may disperse to the petitioner. Then, my lord, my, will be expected for execution.
Yes, tomorrow, yes. Yes.
Serial number 77,
70?
7, my lord.
Hmm.
Please, my lord, hearing on IA, I may request for 14th, my lord, because I have to file an application in that. See, IA for amendment al bandide ivattu.
Yes. Who is the other side?
Respondent has not appeared.
Kumar,
Yes, at the request of counsel for the petitioner, leaves this matter after 2 weeks.
My lord, 14th, that repetition becomes infructuous because I have sought for interim order. However, there is an
14th,
application
yes.
pending.
14th,
Open.
yes.
76. Compromise.
Hmm. 76,
please.
76. Parties are ready.
Yeah.
Yes, yes. Compromise will, yes. What is this suit for? Hmm.
76.
Hmm. 46 RF. RF. 76 RF.
Serial number 76, Radha Krishna A for appellant B.S. Satyananda.
And for the appellant, please. Kumar.
Suit
Last
for?
of appellant.
Yes. Yes.
ಏನೇನು ಗೊತ್ತಲ್ಲ.
Yes. Yes.
And in turn, my lord, he is supposed to give what?
10 lakhs, 5 lakhs each to the respondent.
5 lakhs.
Suit ಅಲ್ಲಿ ಏನಾಗಿದೆ?
Suit is decreed. I had to execute a sale deed in their favor.
Execute
Now
sale-
they are giving up their right in the property.
Yes, you are giving up there, right?
Please.
Then, my lord, I think.
Money, yes. Who's- No, but who is defendant number, deceased, respondent number?
Both appellant and respondent are deceased, please, my lord.
Yes.
For appellant also LRs are on record. For
Yeah.
respondent, LR application is good.
Where is that LR application? First we'll all.
Also filed, please.
No, application is allowed.
No, it has to be allowed.
ಎಲ್ಲಿದೆ? Yes. IA 1 of 2024 is filed for bringing LRs of deceased respondent for the reason stated in the accompanying affidavit. IA is allowed. LRs of deceased respondent is permitted to come on record. Learned counsel for the appellant is permitted to amend the casted leave, amend the casted. So and so learned counsel is undertake to appear for LRs of defendant number, defendant R1 and R2, R1A and R1B. Yes. Where is that petition compromise? Yes. The plaintiff has filed in a suit for specific performance of contract in OS number 15544 of 1999. The suit came to be decreed by judgment and degree dated 13/12/3/2010. Being agreed by the same, defendant has filed this regular appeal before this court. After service of notice to that plaintiff respondent, the parties has settled that matter and they have filed a compromise petition under Order 23, Rule 3, read with Section 151 of CPC. The compromise petition is taken on record. The parties are present before, ಎಲ್ಲ settle ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? Parties are present before the court. They have been identified by their respective counsels. The compromise petition has been. The parties are agreed that they have settled that matter between the parties. They are abide by the terms of the compromise petition. Accordingly, compromise petition has been extracted below. Accordingly, you have mentioned in this. Yes. Compromise petition is extracted pursuant to the compromise petition's condition. Respondent plaintiff has handed over the key to the appellant respondent.
Appellant defendant.
Appellant defendant. Accordingly, compromise petition is disposed of. Office is directed to draw the degree in terms of compromise petition. Yes, yes. Office is directed to modify the degree in terms of the compromise. Yes.
Payment you will notice. 10 lakhs.
Adal mention ಮಾಡಿದಲ್ಲ. That's enough. Yes. Yes, ಕೊಟ್ಬಿಡಿ ಅದು. Party signature ಅಂತ ಹೇಳಿ. Continue. Yes.
List number 1, serial number 35, Jagadish HT for petitioner. Serial number 35, Jagadish HT.
Yes, none appear. Please this matter of 36.
35. 35.
I 2 weeks. ಬರ್ದಿಲ್ದಿದ್ರು
Office objection.
You urgent it ಅಷ್ಟೇ. Don't wait them. Yes.
Office objection, first time matter, serial number 36, PP Agde.
May please.
Yes.
May please. Some urgency with it.
No, what is that office objection? Provision of loss to be stated correctly, index to serial number, para number to be stated, typed copy, details to be stated. Objection, court fees to be paid.
That has been paid.
When?
That has been paid.
You pass or you comply office objection? Pass or, yes. Complaint, then we will take up, yes.
Serial number 37.
They have urgency, my lord, sir.
No, all that only after complaints, I will take it up.
Please.
You have to complain, huh?
Please.
If that office objection which is can be overruled, I can take it. Otherwise, others
My
have to be
please.
complained on, yes.
Please.
37 and for petitioner, my lord. And 2 office objections. The correction in the affidavit and
Blank to be filed in that affidavit, all annexures to be sworn. Annexure sworn ಮಾಡಿಲ್ಲಲ್ರಿ.
my lord, the clerk mistake I will
Yes.
rectify that mistake. Matter is very urgency, my lord.
No, ಈ affidavit swear ಮಾಡ್ದಾನೆ, how can this?
I will comply, my lord.
Yes.
Serial number 38, Umashankar ML.
35. 2 weeks adjourn ಆಗುತ್ತೆ ಸರ್.
Next week.
ಅಲ್ಲ ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ. Preliminary hearing.
You are not there. I am
Sorry,
waiting
sorry,
that advocates is not there. I will call it. Yes, pass over, Mr. Pass over ಮಾಡಿ. Yes. Yes.
38.
38 and Malad. Mother has wakalat filed by petitioner.
Details of the petitioner cost title does not tally with, okay. Signature of the petitioner or the affidavit does not tally with the wakalat.
No.
Yes.
Malad, the mother has filed the wakalat and son has sworn to the affidavit.
Yes. Who are the parties? Mother, both are. Jayama is signed.
Jayama is the party, Malad. Jayama has signed the
wakalat.
Wakalat.
Yes. Yes.
Affidavit filed by son.
Yes. What is this?
Malad, now, the suit is of the year 1989. FDP proceedings are filed in the year 2004.
Now, what is the suit for?
Suit for partition and separate possession decreed.
A degree.
Final degree proceedings are initiated. And Lordship can see, final degree proceedings are initiated in the year 2004. But now, the first respondent, mother has filed an application seeking share in the property. She has not filed any suit. In the final decree, she has impleaded. Her application was rejected.
No, she can, if she has any right, she can file an application in the FDP.
Correct, my her application was rejected.
Yes.
Rejected. Now, wife, I'm sorry, the daughter files one more application seeking share in the property.
Yes.
Impleaded. Can you see the application, page 26? Without mentioning any relationship.
Now, this property is dividing between whom?
Divided between the petitioners and the respondents therein.
Oh, what are their relationship?
They are the blood relatives.
No, she'll come in that.
No. She is the third party.
That she's not a.
No. She is not in the preliminary decree.
What
Her
is
mother
the
has filed application. She is also not in the preliminary decree.
What is the reason given by the trial court?
Trial court has said, page 23.
Yes.
On perusal of the order dated 15/3/2011, the application filed by the mother of the proposed respondent number That is respondent number 9 hearing has been rejected on the ground that certain respondents have already filed OS number 73 of 2010 seeking partition and separate position. If at all the respondent number 9 is entitled for relief of 1/4 share, the only remedy for the respondent number 9 is to get the decree decree, that is preliminary decree modified.
She is not related to any of these parties.
No, my lord, no. Not the proceedings need not be stayed. Only order has to be stayed.
Issue notice.
A notice to respondent number 1 matra.
Order dated 1/2/2025, passed on IA number 37 in FTP number 9 of 2004. Pending in the file of Principal Civil Judge JMFC, Mandya at Annexure A till next date of hearing. Yes.
My lord, notice to respondent 2 to 17 may be dispensed.
You file in a memo? Yes.
I will file my.
Remaining respondents issue emergent notice. Yes, submission is accepted, office objection is overruled.
Serial number 39, PP Hegde.
Yes, same. Yes, password is complete. Yes.
Serial number 40, Rajesh G.
Yes, myself is it. Same objections have been raised, Your Honor.
Hmm.
Objection number 2 and 3.
Yes, what are the tough? Petitioner number 2 has filed an wakalat on behalf of petitioner number himself as party in this petition. Same petitioner in a party, in a person in this case. Then, yeah, yesterday's matter.
Yesterday's matter.
Why it is urgent today?
ಇದು ನಾಲ್ಕನೇ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು ಸ್ವಾಮಿ. ಅದರ್ ಅಬ್ಜೆಕ್ಷನ್ ಚೆಕ್ ಆಫ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಂತಿತ್ತು, ಅದನ್ನ ಕಂಪ್ಲೀಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದ್ ಮಾಡ್ಲಿ ಅಂತ
ಮಾಡಿದ್ರಾ? ನಾನ್ ಕಂಪ್ಲೇಂಟ್
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
Yes, what is this matter?
And other thing is respondent number 1, he has passed away and this has been reported before the trial court on Monday, Your Lordship. And I am filing a LR application.
Who is that?
Death certificate.
Who is?
Plaintiff, Your Lordship.
No, here he is the respondent.
Here he is respondent, Your Lordship.
Now he is dead.
He is dead, Your Lordship. I am filing the necessary application.
Yes. Who are the tellers?
Legal heirs, it is shown in the application, Your 3 illegal heirs, Your Lordship.
No, you
Wife
do
and
one
other
thing.
2 daughters, Your Lordship.
When they dead?
He passed away on 4th of February, Your Lordship.
When
Last
you have
month.
filed a writ petition?
Writ petition was filed on 28th, Your Lordship, February 20th. The trial court matter was on 3rd of
No,
March.
when they, before filing a writ petition or after that?
Before filing the writ petition, he has passed away and this was reported to trial court on 3rd of March, Your Lordship.
Then you amend that writ petition, why application? Before that,
Yes, you.
if they are dead, you can make them LR as in a party and make in a note that since petitioner is, plaintiff is dead, LR has been made as in a party. But you make them as in a party. You see, who is that LR?
Wife and 2 daughters, Your Lordship.
Wife and 2 daughters has been made as R1A and R1B and mentioned that since plaintiff has dead and so on so dead, therefore LR has been. Yes, Pastor.
Serial number 41, Kavita C.
Yes, none appear. 2 weeks time is granted to comply of subjection.
Serial number 42, Karumbai T.A.
Yes, none appear. 2 weeks time is granted to comply of subjection.
Serial number 43, Sunil S. Narayan, 1 court fee.
ಒಂದೇ ₹100 ಕಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ. 2 prayer ಇದೆ, ಇನ್ನೊಂದು ₹100 ಕಟ್ಟಬೇಕು ಅಂತ.
Yes, court fee you have to pay.
I have paid ₹100.
Now you have to pay one more.
One more.
Pastor, yes, paid. Yes.
Pay ಮಾಡ್ತೀನಿ. ನಾಳೆ
Yes.
ಹಾಕ್ಬಿಡ್ತೀನಿ.
Nale, yes. Release this matter tomorrow. In the meantime, directed to comply of subjection. Yes.
Serial number 44, Venkatachalapati S.K.
Kindly pass over the.
Yes, Pastor.
Serial number 45, Adjournment. Serial number 46, Dilraj Jod to Ananda.
Yes, none appear. 2 weeks time is granted to comply of subjection.
Serial number 47, Vinod Kumar to Yerad office objection.
Yes,
I am for the petitioner. My lord, in this matter,
you comply office objection. Typed copy of the manuscript as per the annexure. See, all parties have not made the parties in the writ petition. Why they have not made parties? What is that urgency, mister? Is there any urgency?
it's a speedy disclosure, my lord. My lord, in that, they have posted
Incline
to-
court to season court to early disposal.
Yes.
Yes, you take notice.
Yes, exceptional.
Issue emergent notice. In addition, petitioner is also permitted to serve a copy and the, I will take hand summons. Yes. Additional hand summons. Office objection is overruled. Yes.
Serial number 48, Adjournment. Serial number 49, Anusha L for petitioner, connected matter.
Yes. Yes, week's time is granted to comply of subjection.
Serial number, office objection, second time matter, serial number 50, Umesh MN.
I am for respond number 1 minute.
Yes.
Comply the most of it. They know the other more objections, they will comply.
Yes.
I request you lordship to kindly have it on Tuesday.
Yes.
My lords, not on Tuesday, my lords, Wednesday, my lords.
Yes. Leave this matter on Wednesday. In the meantime, directed to comply of subjection.
Serial number 51 adjourned, serial number 52, PM Siddhamalappa.
Yes, Siddhamalappa.
Office objection.
Yes. 2 weeks time is granted to comply of subjection.
For order, serial number 53, Cashier for petitioner, Ganesha NA.
Letter input. This court by order dated 30th July 2024 directed that correct. Directed that family court to dispose of that MC petition not later than 3 months from the date of the receipt of the copy of this order. The registry has received a letter from Principal District and Session Judge Tumkur seeking further extension of the time of 3 months to disposal of the case MC number 106 of 2023. In view of the reasons stated in that communication dated 14/2/2025, the further period of 3 months has been extended from today.
Serial number 54 disposed of, serial number 55, Ravindra VS.
Objection has been completed, court fee katide. Another office objection not, oath commissioner seal.
Serial number
55.
Attestation affidavit has to be attached, Mr.
Attest agidi.
Non-payment of the court fee. Court fee has been.
Court fee katide.
What is that serial number? Attestation in that affidavit.
ಅದು ನನಗೆ ಅರ್ಥ ಆಗಿಲ್ಲ ಸರ್ ಏನಪ್ಪ
Affidavit ಎಲ್ಲಿದೆ?
Verifying affidavit, I think, my lord. Otherwise, another application has been filed seeking for production.
ಇದೆಯಲ್ರಿ ವೆರಿಫಿಕೇಶನ್ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡಬೇಕು? Affidavit before me, notary.
Notary seal is number, serial number ಇಲ್ಲ ಅಂತ ನಾನು. ಐಎ ಒಳಗಾಗಿದೆ.
Yes, what is this matter?
I have sought for dispensation of production of the order passed on IA number 4.
Why?
IA number 4 has been filed. Under order 6 rule 17, seeking certain amendment in my return statement itself. Now the court has passed today, the order passed on 19th February 2025.
Today?
To date for cross-section of PW1.
No, suit for?
Suit for the suit for specific performance suit. But I have sought, I have stated my return statement denying the entire government. Since at no point of the defendant has executed the agreement itself. It is only the agreement part with as a partnership deed with respect to the suit property. Now, in the return statement at para 9, kindly see, para 9, I have referred that in paragraph number 9.
What is that order you are challenging?
Now, order challenge with respect to rejecting my IA for seeking for amendment of the return statement. Though I have admitted that the transaction is happened with respect to the property itself, not as the agreement to sell. Now the court saying that, my lord, once you admitted in the return statement, you cannot withdraw, you cannot make other subsequent, my lord, the events, or you cannot take any inconsistent plea. My lord, since, my lord, the settled principle law itself is stressed, my lord, though, my lord, the plaintiff cannot, my lord, take an inconsistent plea. Now, my lord, the defendant can say, take a, my lord, the inconsistent plea in the return statement.
Which is the
Now, my
judgment?
lord, the order passed.
Which is the judgment which you are relying on, Mr.?
My lord, since it is objection, then I have referred it in the.
Yes, you
petition
produce
itself.
that. When do you want? Yes.
Next week, any date? my lord?
Yes, at the request of petitioner, release this matter next week.
Please.
Cell number 56, sir. Chaya ke.
Appear for the petitioner's counsel. Hello, this is an writ petition challenging an interlocutory order.
What is that office objection?
Well, the office objection is this. In the proceedings in the miscellaneous petition,
Not a
we have
party to the first.
names of defendants 3 and 4 has been correctly reflected in the main petition before the Order 9 Rule 13 proceedings. In the suit, it was erroneously mentioned by the plaintiff in that suit, which was decreed ex parte. So, but we have gone with the correct description as per the main, as per the impugned order also tallies.
Yes.
My lord sees the impugned order. The description of those two defendants tally with the petition before my lord.
Which is that impugned order, annexure?
Yes.
Yes.
A, annexure A.
You are the, which party in defendant number?
3 and 4.
3 and 4.
This is the wrong matter.
3, only 3 is there. Where is 4?
Yes.
What is that? Venkatesh?
Yes.
Manju.
My lord, may
Are
kindly
you-
come to page 44.
Mrs. Marina and Mr. Ryan.
No, Venkatesh is the petitioner.
Yes, he is correctly reflected.
Anju is also there.
Yes, correctly reflected.
In the suit, your name is not there.
It is there at page 44.
44.
Yes.
Yes.
My lord, see defendants 4 and 7.
4
Correctly
is-
reflected.
44, 4 is Gita.
I mean 5, sorry, 5 and
Venkatesh.
5 and 7.
Venkatesh 7 is there.
Yeah.
Then why that they said it is not reflecting?
That is regarding, my lord, will see
Number
at
2 and
page
3.
44. Defendant number 3 is one Mrs. Marina. And in the previous page, my lord will see one Mr. Ayub. Now, these two individuals have been correctly named in the annexure A, page number 24. Kindly see 3 and 2 and 3.
Yes. Oh, Geo Private Limited.
Yes. 2 and 3. Kindly come to page 24. 24, my lord.
Yes.
In the impugned order,
Yes.
those two individuals are named at 2 and 3 correctly.
Yes. 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 What
Therefore,
is
there
this?
is, we have to be in tune with the impugned order.
Yes.
We are not challenging the decree before my lord's court.
Yes.
So, my lord, this is a proceeding for restoration. An ex parte decree was passed. It's
Yes.
very, my lord, a case where a lot of people were cheated. What happened was a residential building
Yes.
consisting of about 7 apartments,
Yes.
of which one was occupied by the owner herself. What she did was, remaining 6 apartments, she gave it to a company, authorizing the company to lease it out to third parties. She entered into an agreement which was unregistered, empowering this man, the company, to lease the remaining 6 apartments. The 6 apartments were leased out to 6 different individuals. The petitioners before my lord are 2 such individuals. All these 6 people are retired employees who didn't take it on monthly rental. They took it on a lease premium. Like, for example, the first petitioner paid about 13.5 lakhs for a 3-year term. The arrangement being, and after the expiry of 3 years, they return the money and they will vacate the premises.
Yes.
Similarly, the second petitioner paid about 11 lakhs and odd and took possession of 1 apartment.
Yes.
Now, this lessee, the main lessee, the principal lessee appears to be a fraudulent company. What they did was, they took the money and disappeared. They didn't pay the rentals to their landlord.
Yes.
The landlady was sitting in one of the apartments and was observing all this and did not raise a finger objecting to this.
Yes.
And this man, the company which leased the premises to us,
Yes.
promised to defend the suit. She already instituted a suit for eviction against the principal lessee,
Yes.
which was not brought to our notice. Summons was received. Let me confess to the honorable court. When we confronted it with the principal lessee, he said, I'll take care of it. I'm fighting this case. He's also a partner. He entered appearance and we were cheated. We were all employees given our hard-earned money.
Yes.
An expert, they didn't contest the suit.
Yes.
An ex parte decree came to be passed.
Yes,
Now,
what-
we are on a legal point in this writ petition under Article 227.
Yes.
My lord, we filed an Order 9 Rule 13 application citing these developments, the fraud. And my lord, this company has defrauded over 200 apartment complexes in North Bangalore.
Yes.
That's a major scam. So we said that we were cheated, therefore we were not able to enter appearance. Therefore, kindly give us an opportunity, we will defend ourselves. My lord, an interim stay application was filed. In the meantime, because execution was filed, there was an expired decree for ejectment and for damages, arrears of renters. And my lord, there's another point which I'll come to. In the eviction suit, the landlady filed one suit against all tenants, which is hit by order two, a multifarious suit, not maintainable. That's a different matter. When we come back to the main suit, we'll argue that out.
Yes.
But in an Order 9 Rule 13 application, we said that we were defrauded. Kindly give us an opportunity. In the meantime, stay the execution. My lord, the Honorable Court in Annexure A, while disposing of interlocutory application, treats this as though it is an executing court passing an order of stay until an appeal is filed. Kindly see the operative portion at page 34.
Yes.
He passes it's not really a stay. He passes a stay in a miscellaneous proceeding, saying that the stay will be operative till the petitioner seeks stay of judgment and decree in OS number 1964 of 2023. Where do I do that? In an appeal proceeding? Well, that he is entitled to do in the execution. Execution, you have the power to stay the judgment until you.
Now, have you filed an appeal?
We have not filed an appeal. Though that remedy is available to me parallelly, my lord is aware of that. I filed a restoration proceeding.
Yes.
And my lord, in terms of Order 9 Rule 13, even if a final order of allowance is, if the petition is allowed, he can
Yes.
only put me on terms of cost.
Yes.
What-
Where is that judgment and degree?
Yes, my lord, will find it at page 43. And the operative portion. Decree. The decree, my lord, is at page 62. 62, my lord, will find the decree.
Yes.
My lord, I read the last paragraph of the decree. It is further ordered and decreed that the defendants are hereby directed to quit, vacate, and deliver vacant possession of the respective suit scheduled properties
Yes.
within 3 months. And then, my lord, kindly see the next page. It is further ordered and decreed that the defendants jointly and severally, my lord, we are tenants having separate agreements. He's treated, I mean, the suit was filed against all of us in one suit. That's the problem. The court passed an unworkable decree, joint and several liability to pay arrears of rent, which the principal lessee was due to the landlord. We ended up paying 13.5 lakhs, lost that money. Now we are now foisted with the liability of the principal lessee.
Who is that principal lessee?
He is absconding. Kindly see the cost title at page number 59. ZU Homes Private Limited. My lord will have the first defendant.
Yes.
This is the man who has scammed 200 apartments in Bangalore city.
Where is that execution petition?
My lord, fine, the execution is not produced here. No, the execution is not produced.
What is the stage in that execution petition?
The delivery warrant is issued.
Yes, you are appearing for. Who is responding? Yes. According to you, what is the due amount for payment of the rent?
My lord, we have paid a lump sum lease premium of 13
You
lakhs.
are lease, but
Yes, my
he
lord.
has entered as a renter.
He has entered into a rent, but the argument is, my lord, on merits. On merits, my lord, my premise submit, the landlady was occupying one apartment. And by the time some of the tenants came in, the trouble had already started and she knew that this man had defrauded. She did nothing to warn us. We paid up the money and entered the premises. By then, she had already issued notices to him for check bounce cases of the monthly rental, which he had to pay her. We entered in, the lady did not even tell us that she's the owner. She was occupying the last apartment in the building.
What is that agreement entered that middleman? He is saying that he is the owner or he's.
When he represented to us, he claimed to be the owner.
But now in the agreement is.
Agreement, he was a lessee.
Was a
Lessee from her. All the 6 apartments.
Yes.
So therefore, it gave an impression that he was the owner and she was there. I mean, my lord, these are matters where we might succeed or we may not succeed. Depending upon where acquiescence of the defense.
No, he has not appeared before the trial.
No, he has not appeared. When the summons was served on all of us, including the defrauding company. He represented to us.
You will take notice to whom, madam? Yes. No, we'll hear that. Today is coming for admission.
Yes.
Which is the serial number?
56.
56.
Yes, sir.
Yes. You are taking notice to whom? No, you can't, I have not yet issued the notice, you can't file. Yes. Respondent number? Yes, so and so is undertake to appear for respondent number 1. Then what about 2, who is 3, 4 and 5, 6? Yes. Yes.
No, notice may be dispensed with.
Yes.
That is in which one? In which proceeding? Execution.
Where is that order?
But my lord,
No,
those
where
were
is that
execution-
order of this court to pay of rent? Where is that?
No, it's not part of the record.
Not-
But my lord, those were in execution of the decree. These are proceedings for allowing us to.
No,
set aside.
I will see what is that order.
Please. He's right.
You give that copy tomorrow.
Quite right.
It is referred. I want to know that copy, if you want to furnish it or not. You give it, yes, you have the copy.
Not part of the record, we furnish.
Wait. No, this is passed in that execution
The
petition.
execution.
No, I am asking that this court has. passed
No,
it.
not at all. Not at all. No, the execution. She's referring to the execution. There's no other writ.
He is saying writ petition.
In that execution. Yeah.
Yes. Yes. Hmm. Hmm. Now, where is that judge order of this court?
I have it with you. Writ order. No, where's the writ
Madam,
order?
I want to see that order. You are referring that, what is that? If it is, the order is available, you produce that tomorrow.
I have it, yeah, tomorrow.
Tomorrow, yes. Yes,
Tomorrow.
tomorrow. You produce that copy. Yes. Now everything is available on net. If you are producing for making so much.
Sorry.
Yes.
Tomorrow we'll
He
produce.
might have not produced to see that it should not be brought to the notice of the court. When you are there, you produce, we'll see that. Yes.
Serial number 57, Punit C for petitioner.
Yes. What is this, Mr. Maintain?
It is on maintainability.
What is the order you are challenging?
Lord, page 15. That the order of granting an ex parte injunction
Hmm.
is being challenged in the writ petition, please, my lord. I am the defendant
Hmm.
before the trial court.
Order passed under order 39?
39 on 1 and 2.
Hmm.
I am the defendant before the trial court, please, my lord.
Hmm.
The next date is on 7/3/2000, that is tomorrow.
Yes.
Now, please, my lord, the office has raised an objection with respect to the maintainability of the writ petition is concerned.
Hmm.
But may I request, my lord, one, in similar circumstances, the court has entertained the writ petition.
Yes, yes. Hmm. What is that matter, Mr.? Yes.
My lord, what has happened, please, my lord? My lord, my synopsis for a moment, page 1.
Yes.
My lord, the petitioner, my lord, he acquired a portion, my lord, measuring 2 acres in survey number 134, measuring to an extent of 2 acres under a registered partition deed which is effected in the year 2001.
Yes.
revenue entries are affected.
Yes,
I am in possession of the property.
yes,
Well, subsequently, the property is being coded and Hadbust has been fixed. For a moment, may I kindly peruse the Hadbust, copy of the Hadbust, my lord, which is at last page, please, my lord, last page of my writ petition. I have
yes,
to Wakalat. This is the copy of Hadbust, please, my lord.
yes,
Now to the eastern side, please, my lord, your honors may kindly see survey number 135.
yes,
Now 134-2 is my property, that is the suit property measuring to an extent of 2 acres of land.
yes,
Now, in the bottom of the same, please, my lord, page para 4. ಈ ಅಳತೆಯಲ್ಲಿ ಈ ನಂಬರಿನಲ್ಲಿ ಒತ್ತುವರಿ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. Last line.
yes,
Which clearly identified, please, my lord, that there are no encroachments in survey number 134/2.
yes,
My lord, the plaintiff number 1, please, my lord, since he interfered, my lord, I was constrained to file a suit for bare injunction. My lord, trial court grants me an ex parte interim order.
yes,
Subsequently, on appearance of the plaintiff number 1, please, my lord, interim order was confirmed. Thereafter, I filed an application for police protection since he interfered. There is also a contempt proceedings, please, my lord, which is pending before the court, pending for adjudication. Even the police protection order is also being given by the trial court, please, my lord.
in OS number?
In OS 87 of 2024.
Yes,
Against the order of police protection, please, my lord, there is no appeal or writ petition being filed by the plaintiff number 1. My lord, in order to obstruct the, my lord, the order of the granted by the trial court, he approaches the court by filing a suit for permanent injunction. Well, the very same court, please.
what is the suit schedule?
Well, suit schedule, my lord, land bearing survey number 1, old survey number 61.
Where is that plaint?
Well, plaint at page 20.
Yes.
Well, my schedule, old survey number 61. After code 134.
Where is that plaint in this suit?
Well, that is at page number. Well, at page 62.
Yes.
Well, he wants to give survey number 61.
Yes.
Which is not being coded. He claims that he is adjacent to the western side of my property.
No, see that boundary, Mr.
Well, at boundary, east by land belongs to Birappa. West by land belongs to Chichanappa, my lord, who is my brother. Well, if your lordship would kindly take the Hadbust, well, at 134/1. Your lordship would kindly take, my lord, Hadbust, last page. Well, at 134/1 is allotted to my brother under the registered partition deed. 134/2 is being allotted to me.
Yes.
Now, please, my lord, he says he is adjacent to 135. He is adjacent to 135. He says that to the western side of his property, that is to say, from the 135. Now, please, my lord, 134/2 is there. Now, he wants to say that this 134/1, by giving a boundary, my lord, to the western side.
He is claiming that west side of his properties is 135.
130.
Then it is beyond that
135. He does not say 135.
You see
he says, my lord, to the western side that the land belongs to Chikkachanappa. That is to say, please, my lord, who is none other than my brother.
Chikkachanappa is 134/1.
134/1. Naan irodu 134/2 nalli.
Then south land belongs to Rudrappa.
Yes, please, my lord.
ನಿಮ್ದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಸೌತ್ ಅಲ್ಲಿ?
ನಂದ್ರಲ್ಲಿ ಬಾರ್ಡರ್ ಆಫ್ ಅಪ್ಸಂದ್ರ ವಿಲೇಜ್.
ಎಲ್ಲಿ?
ನಂದು ಅದ್ಬಸ್ತಲ್ಲೇ ಇದೆ, ಅಪ್ಸಂದ್ರದ ಗ್ರಾಮದ.
ಅವ್ರದ್ದು ಯಾವ್ದು ಅದು ಬೌಂಡ್ರಿ ಮತ್ತೆ?
ಅದು ದಟ್ ಈಸ್ ಅ ಡಿಫರೆಂಟ್ ಬೌಂಡ್ರಿ, ಪ್ಲೀಸ್ my lord, where the plaintiff has to prove.
ಆಯ್ತು, ಅವ್ರ ಬೌಂಡ್ರಿ ಇದು ಲ್ಯಾಂಡ್ ಇಲ್ದಿರೋ
what I am submitting is that, please, my lord, now, please, my lord, by taking advantage of this, my lord, he is trying to again interfere. Why? Because he is trying to create conflict of interest. Why? Because, please, my lord, there is an order in my favor which is being made absolute and also a police protection being granted. Now, day and come again by virtue of this interim order, please, my lord, he is trying to again interfere. Virtually, please, my lord, the order of injunction granted.
Now, what is that order you are challenging?
My lord, that page 15, my lord. My lord, I have been restrained.
You file and vacating. There is a remedy of filing and vacating. Why you are approaching this court? All injunction is filed, you vacating the application. We will direct them to consider that. Only thing still you have to appear the ex parte. Within the 30 days, they have to decide.
Not if that observation, my lord, to that
Yes,
extent.
yes.
Within 30 days, the trial court may.
That
be-
is the, see that.
39 rule 3 is there, my lord.
Ah, that-
39 rule 3 is there.
If law is there, why I have to say, you have to point out the court.
My lord, yakandre, it is my request, please, my lord. Yakandre, my lord, it is, my lord, it is in the, my lord, Hoskote jurisdiction, my lord. There are huge number of cases before the rural court. My lord,
Yes.
there will be difficulty for the.
No, these are all ideas will be given by the two. How that suit has to be filed. Yes,
Allah, hangante. My lord, that observation, my lord,
yes, yes.
within 1 month, tomorrow is the date, I'll appear.
No, you have not filed it as unto.
Tomorrow
this
is the
writ
date, I'll
petition.
file my wakalat.
Petitioner has challenging order dated 20th to 2025, passed in OS number 65 of 2025, whereby IA filed by the plaintiff under order 39 rule 1 and 2. Ex parte injunction order has been granted, restraining the petitioner defendant from interfering into that suit scheduled property and also restraining from putting up in a compound wall. Since ex parte injunction order has been passed, the remedy available for the petitioner defendant to file an application for vacating under order 39 rule 4 of CPC.
My lord, I'll not file an application directly, my lord. Instead of filing an application, directly I'll go and address my return
No,
statement.
you file an application and yes.
ಯಾಕಂದ್ರೆ
if
ಮತ್ತೆ
such a
objection ಗೆ ಅಂತ ಡೇಟ್ ಹೋಗುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ.
Adrne 30 days already, even if it is an objection also, it has to be decided. Yes. In view of the above, in view of petitioner having a remedy under order 39 rule 4 for seeking vacating that ex parte injunction order, the writ petition is disposed of, reserving liberties to the petitioner to file an application under order 39 rule 4. If such a application is filed within 30 days from the date of filing that application, trial court is directed to dispose of IA 39, IA 1 and 2 filed under order 39 rule 1 and 2. Yes.
Please.
In accordance with law. Yes.
Cell number 58, Vivekananda, yes.
Appear for the petitioner, my lord. Because the petitioner herein is the plaintiff, number 1.
Yes. What is that of subjection, Mr.?
My lord, office objections are cleared, my lords.
Prior to be more clear and specific, IA number 4 of 25 to be filed.
My lord, IA number 4 is not being challenged, my lord. There is a mistake in the order. IA number 3, my lord.
Objection
that is
to
all.
IA 3 to, yes. What is this, Mr.?
Lords, the impugned order, my lords,
Hmm.
this is a suit for partition.
Yes.
The petitioner herein is the plaintiff number 1. Lords, the respondent number 1 in this petition, my lords, is the
Yes.
brother, defendant number 3.
Yes.
He has been collecting the rents from 2013 to 2017, my lords.
Yes.
An application was filed before the civil court, directing him to deposit the rents. That application came to be allowed.
Yes.
That was challenged in a writ petition, my lords.
Yes.
That writ petition, my lords, was recently disposed of, and the writ petition was dismissed
Yes.
as against the respondent number 1, which is at page number 50, my lords.
Yes.
Based on this, my lords, the matter is, I file an application, I bring it to the notice of the trial court that this is the order, and seek for a direction that he must deposit.
Yes.
The trial court notices, my lords, at page number 27, my lords, that he has not complied with the order on 24 to 2025, my lords.
Yes.
Subsequently, my lords, I file an application that he be directed to, that the defense be struck off. In view of the fact that he has not come, 1 crore 9 lakhs has been collected, my lords.
Yes.
As against all the other brothers, he's collecting the rents
Yes.
illegally, and he continues to collect. My
Yes.
humble submission is the honorable trial court closes my evidence as not filed. And under the impression that I've sought an adjournment. This application, he posted for objection. My humble submission is my rights would turn around if the defense is struck off. But my humble submission is, even if he were to get a share, he wouldn't get such a huge amount.
What is that order you are challenging? Where is that?
My lords, it's at page number 29, my lords.
Yes.
My lords, plaintiff, I quote, my lords, plaintiff in person present, plaintiff number 2, alas, so and so, counsel present. Plaintiff in person praised time for evidence, but since this is a direction matter, And also, my lord, direction is for 18 months from July 2024. And also matter is more than 20 years and hence prayer rejected and evidence of plaintiff number 1 is hereby taken as nil. At this stage, plaintiff number 1 files an application under 151 CPC to strike off defense of defendant number 3 based on judgment of the Honorable High Court of Karnataka dated 22/1/2025 as IA number 3 along with Xerox copy of orders. At this stage, plaintiff number 2 counsel files order 39/2A. So I am concerned so far as IA number 3 of 25, where I have filed an application for striking off defense of defendant number 3, respondent number 1. Without considering that, my evidence is closed. That is my only grievance. The application may be considered and I may be allowed to.
Yes, of audience prior to rejected. Why you have sought for any time when you are?
I filed this application, Milaj. The moment I filed this application, court considers, because Milaj, if I may draw lordship's attention to the
Praise time for evidence.
Yes, Milaj, my humble submission is, if I may draw lordship's attention to the page over 27, the Honorable Court notices the last paragraph, if I may quote. Hence, matter is posted for plaintiff evidence with direction to proceed with trial without seeking adjournment. Milaj, I file an in fact, 2 paragraphs before that, Milaj. Hence, it goes to show that the defendant number 3 has not
your suit.
My suit, Milaj. I should not be deprived of Milaj, my humble submission.
You have to be, you know, given evidence and to see that the matter has to be disposed of early.
Yeah, absolutely.
But you have asked the time.
Milaj, my humble submission is, Milaj, I have filed the application for striking off the defense, Milaj. Milaj, if his defense is struck off, Milaj, all the irrelevant contentions he has taken in the written statement would go, Milaj. And Milaj, for a moment, if I were to file the evidence, he would immediately cross-examine me on all the defense that he has taken.
So that application is posted for orders.
For objections, Milaj.
Yes. No, again, it will be delayed that process. Yes, that. Our issue notice. Stay of further proceedings in OS number 15734 of 2023. You are that
2003,
no, you have filed in a suit for
partition.
Partition.
Yes, Milaj, he's collected the rents. In fact, his conduct is brought out in the writ petition that was dismissed recently, Milaj.
No, where is this court has directed to deposit that rent or strike of that?
Milaj, if I may just draw lordship's attention to page number 27, Milaj. Page number 27, third paragraph. Hence, it goes to show, Milaj, page number 27. The plaintiff counsel files memo of calculation as per orders.
Where is that order of this court?
Milaj, the order of this court, page number 50, Milaj.
50.
50, Milaj. It's dated 22nd of January. Milaj, if I may just draw your lordship's attention to internal page number 5. This writ petition is filed under Articles 226 and 27 of the Constitution of India, praying to quash the order dated so and so passed by the court.
No, where is that order to deposit that amount?
And directing the petitioner to deposit the rent of 1,09,80,000 for the last
page.
Milaj, page number 5, Milaj, internal page number 5. Running page number 54, Milaj.
Yes. No, but that is that prayer.
Prayer.
No,
Same,
where is that order?
Milaj, the order, Milaj, of dismissal, Milaj.
Conformity with the trial court.
Paragraph number 13.
Yes.
Internal page number 15, Milaj.
Stay of further proceedings in OS number 15734 of 2003, pending on the file of 57th additional City Civil and Session Judge, Bangalore, Mehal, till next date of hearing.
May I request service also on the counsel appearing for the plaintiff?
In addition, permitted to survey copy on the counsel appearing for the respondent before the trial.
Much obliged.
Yes, submission is accepted. Office objection is over.
Much obliged.
Sorry, serial number 76.
Who
First LR is also no more.
Who?
First LR of the appellant is also no more.
Who are the tellers?
Same, other children.
File in a memo. Yes. Madbut amendment atara madbudi. Yes.
Serial number 59 Adjournment, serial number 60 Rakesh B. Bhatt. Serial number 60.
Yes, PF.
Sir. I have taken the liberty to serve on the advocate who is.
You are appearing. 1356. Ready?
Yes, sir. My lord, he has no dispute, my lord.
Yes, what is that urgency, Mr.?
My lord, tomorrow is the date of hearing, my lord. They have, I mean, I have, it is a suit for partition, my lord. I have filed an application. The suit is of the year 2022. It's a file in the year February.
Suit for
Partition, my lord.
suit for partition.
Yes, my lord. I have filed the IA under order 12 rule 6, my lord. That is annexure E, page number.
You are the
4.
plaintiff.
Yes, my lord.
What is your application?
Order 12 rule 6, my lord, at page number 49, my lord.
Yes.
They have unequivocally admitted the fact that they are also entitled for the share.
For the reason accompanying the plaintiff raised, this honorable court may kindly pleased to pass a judgment and degree holding that plaintiff and the defendants are each suit scheduled property on the basis of the admission made by the plaintiff defendant in the interest of justice and equity. Yes. What has happened to that application?
Application is pending, my lord. One or the other pretext, the defendants are taking time. Since from last 8 months, my lord, it is.
You are seeking for early disposal.
Only for considered for this IA, my lord, to dispose.
Yes,
this IA.
Mr. Will direct that to dispose of. No, we'll dispose. Only direction is to dispose of the IA. Who? Which one? That has to be considered with. That's what I said that. Then what you said that heard and no, we are not on that. We are only seeking a direction. Yes. Yes, tell it. You are taking notice to whom? Yes, so and so learned counsel. Undertake to appear for 2 and 4. Yes. In this writ petition, petitioner, you are appearing for 1356. 1356, you are 2 and 4. Alig ellarge service aitala. Yes. In this writ petition, petitioner sought directing the trial court to dispose of the IA number 5 filed under order 7 rule 6, order 12 rule 6 in OS number 1292 of 2023, pending before 7th Additional City Civil and Session Judge Bangalore as expeditiously as possible. Plaintiff has filed a suit for partition. After service of summons, defendant has filed the written statement. Thereafter, plaintiff has filed IA number 5 under order 7 rule 6. When you have filed, Mr.
On 26. 26/6/2024. 26/6/2024.
Filed an application on 26/6/2024. As on today, the application is not disposed of. Hence, he sought for early disposal of that application. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of that IA number 5 filed under orders 12 rule 6 in accordance with law as expeditiously as possible, not later than 3 months from the date of receipt of the copy of this order. Yes.
2 months, my lord.
3 months, let them, they have to file an objection and here.
They have filed, my lord. They have filed.
Yes, they will make a submission and yes.
Serial number 61, GM Ananda.
60.
Petition.
Yes, yes.
The application filed by the PW1 under Art 26 rule 1 and 2 for recording cross
Writing
examination.
service. Notice service agila.
But it is bring it to the notice of the PW1 to his counsel.
And someone stand idira.
And summons illa, but when at the time of hearing before the trial court, it is bring it to the notice of the court
You
and
take
as
an
well
hand
as the
summons, sir. Take a hand summons. Yes.
Please.
Yes. Awaiting service of notice to respondent. In addition, petitioner is also permitted to take hand summons to the respondent.
Please.
Yes. After service, you move that matter. Yes.
13th
Serial
or
number
14th.
60,
14th.
Any date after moving that. Yes.
Please.
serial number 62, Ajay Kumar and for petitioner, Kamaleshwara Pujari.
Yes. Yes. Now that all parties are served,
Yes, yes.
you are appearing for.
No, all the others are not served.
You are the
We are the decree
you are
holder.
the degree holder. Others are not necessary party. Yes.
Others have to be served.
Served,
ಇಲ್ಲ ಆಗಿಲ್ಲ.
No, are there necessary parties?
No, they're all parties who have rival claims.
No,
Because-
now what is that order you are challenging?
No, the order we are challenging is our order is an application which we had filed for cross-examination or further cross-examination of the court commissioner. That my lord is rejected by the court. And if your lordships see the order, my lord, I think it is more that the
No,
judge.
now that he is that degree holder, others are judgmentator.
Others, my
Only
lord,
he is
are
the
interveners.
objector.
No, they are interveners because this, my lord, what happened was a particular property was developed by the Army Welfare Housing Organization. We developed it, and there are houses which have come up all over.
Yes.
Now, when the preliminary decree was made in their favor, that a certain extent of land must go to them, a commissioner was appointed under section 54 of the CPC. And thereafter, my lord, he has demarcated a certain portion without even noticing as to whether there are roads or anything of that kind. Therefore, first time when we cross-examined the court commissioner, we tried to confront the plan and certain other documents of the court commissioner to say as to how he has identified that particular area as the area which has to fall to them. To which, my lord, the questions were not allowed. And we specifically have pointed out in our affidavit that these questions are material in this case because location is everything there is in the case, my lord, of determining where the property must come. Then, my lord, the court gets very upset with us, of course, and says you've made various allegations against the court and all of that, and then finally dismisses the application. It is against that order we are before your lordships.
Yes.
And therefore, my lord, I would also think that other parties who have an interest in this property,
No, if
where
it
it
is,
falls,
no,
of
if
course.
it is allowed,
yes,
to give an opportunity to that.
Correct.
Only affected is that degree holder, how they are affected.
that is true.
If it is dismissed, then they are not, neither way they are not this thing. No, I am asking that whether other parties are necessary to decide. If it is not, otherwise after hearing that, suppose if court feels that if it is to be allowed, then other party who is affected is not in a party, then if it is dismissed, there is no problem. Therefore, I don't want to waste the time.
Yes.
Yes. Yes, yes. Now we will let him argue. Yes. Yes. Yes, Mr.
My lord, please come to page 26. That's the order, my lord.
Page.
Page 26.
Yeah, first suit for
My lord, suit originally was for partition.
partition.
A preliminary decree, my lord, was passed
Yes.
saying he's entitled to a certain share.
In that FDP, you have implemented.
Yes, my lord. In the,
Who are you? How
Lord,
you are?
my lord, I had purchased this property
Hmm.
and developed a layout of sites.
Yes, you
So
have
the-
purchased from whom?
We had purchased not from the other defendants.
Now you come to that plaintiff.
Defendant numbers 1 to 3 in the suit.
Yes, where is the plaintiff?
So now we are in execution proceedings.
No, 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 that's what.
Huh.
See, I want to know from which
Yes, yes.
parties you have purchased.
Judgment, my lord, is page 113. 113 is the judgment.
113.
113.
Yes, you have purchased from whom?
Lord, we had purchased, my lord.
Our vendor is not available. They have purchased the car.
My lord, ultimately the defendants 1, 2, and 3 were the persons who had sold the property, and we had purchased from the person who had purchased the property from them.
No, yes, defendant number.
That defendant is not a party.
He is not a party in that OS.
In the OS, he is not a party.
Who is he?
He is another builder, my lord.
He is
What is the
not-
name?
Nani Builders.
Nani.
He has purchased from whom?
From defendants 1, 2, and 3.
1, 2.
Defendant number 1,
2, and 3.
1, 2, and 3.
3.
They
These
have
are, my
sold
lord,
a property to which is that builder name?
Nani Builders. Nani Builders. Nani Builders.
Nani Builders.
Nani.
Nani.
Nene.
Nani Builders. And from Nani Builders, the different number 6, that is the AWH.
Now petitioner has purchased from Nene Builders.
In the year 1999.
99.
Yes.
Then suit was filed in the year 2010.
Yes, what is that shares which is allotted to 1, 2, 3?
Yes, lordship may kindly come. to page 160, my lord.
160. Yes.
Plaintiffs 1 and 2 are entitled for 1/5 share each in the suit schedule property item numbers 1, 2, and 5 by meets and bounds.
Yes.
This preliminary decree has been challenged by us.
Hmm.
It was originally filed before this court, then it went back, my lord, to the district court, and there it is pending as on date. There was no interim order granted.
No, this preliminary degree is under challenge.
Under challenge. It is under challenge.
Yes.
The
now
court,
you-
my lord.
now, yes, now it is no relevance.
No,
Now
no,
you come to that FDP.
Yes. Now thereafter they filed the FTP proceedings.
Yes.
The FTP proceedings, my lord, will find at page 164.
Yes, schedule is.
My lord, will come to page 171. Is the schedule.
Yes.
Item number 1, my lord.
No, they themselves has made you as a party, or you impleted here?
They've made us a party.
Yes.
They've
You are,
made us a party.
Respondent number?
Respond number 6 or
6.
Six.
Army welfare. Also.
Army welfare.
Yes. Yes. Which is the suit item you have purchased?
Item number 1.
Item number 1. Yes. Yes.
It is described as.
Then, Lord, of course, this land is converted, but the land is shown as agricultural land
Yes.
in the suit,
Yes.
and therefore the demarcation seems to have been made by the commission also trying to treat it as agricultural land.
Yes.
But today the fact, my lord, is that there are various houses that is built by retired army officers who are living there, which is really, my lord, the concern and consideration here. Therefore, during the first time when we cross-examined the commissioner after he submitted a report, we tried to, my lord, place the layout plan for that entire area to show where, my lord, these houses are. And because roads and other amenities have already been.
What is that report of the commissioner?
Report of the commissioner, my lord. Lordship may kindly see how it is shown.
Yes.
Page 202. No, 260. This one, 280.
200.
216. 216. my lord.
Yes. Yes.
Lord, if your lordship sees 216.
Yes.
1 and 2 in the sketch.
Yes.
That is what the commissioner has identified.
That is the property you
That's
have.
the property, my lord, which they have allocated to them. There, my lord, your lordship will see the site numbers 9, 10, 11, 12, 13, 14, 15.
Yes.
Which will get affected. There is some parks.
Yes.
There's a road there as well, which has already been relinquished, my lord, to the development authority.
Yes.
None of that is identified in this sketch.
Yes.
Therefore, my lord, what we did is, during the cross-examination, we
Yes.
wanted to place this layout sanction plan at page 102 to show, my lord, as to how there is no non-application of mine by the commissioner while he draws out the entire sketch for the purposes of distribution under section 54. 102. This is a layout sanction plan.
Yes.
I won't trouble your lordship by showing it because
Yes. You
it's
have.
something which we want to cross-examine him on.
Yes.
To which, my lord, the court does not allow us to cross-examine, doesn't even note it.
Yes.
Then we file an application specifically because the court does not allow us,
Yes.
saying now permit us. These are the documents we want to mark. We want to show him this and show him as to how he has demarcated the property. At that point in time, this order comes to be passed.
Yes. Which is that order?
Order is at page 26.
Yes.
My lord, may I just read para 2 for 1 minute, my lord, because your lordship will get the entire idea there.
Yes.
It is stated in the accompanying affidavit, petitioners have filed this petition on the basis of preliminary decree. Respondent number 6 is concerned only in respect to item number 1. As per the application, ADLR is appointed as court commissioner. He has submitted the report. Stated that commissioner had apparently conducted spot verification, which is disputed. There are several discrepancies and omissions in the report. Detailed objections filed by respondent number 6. Dispute is with regard to identification of the scheduled property. Court is bound to consider availability of the property and present status of item number 1, which is converted. The report of the commission is void. It is not containing the land area like roads, parks, open spaces, civic amenity sites, and water tanks, which have been relinquished to the appropriate local body. The report doesn't stand to legal scrutiny, does not demonstrate the correct picture. Several questions were asked to the court commission with regard to item number 1, conversion and date of conversion. This court has refused to entertain, did not record the list of questions asked during the cross-examination. orally stated to get the preliminary decree set aside before the appellate court. The questions involving subject matter vital for adjudication, without assigning valid reason, court has omitted to record the aforesaid questions and mechanically proceed to ignore the vital questions that were necessary. Court commissioner was confronted with several documents, conversion sketch, relinquishment deed to Gram Panchayat, layout plan pertaining to item number 1. Though commissioner had admitted the same, court refused to mark the documents without assigning the reasons, not recorded the same. Same is vital to demonstrate the case. Discrepancies are materially affected to the outcome of final decree proceedings. Respondent 6 has not accorded fair opportunity to challenge the findings of the court commissioner. It has been evidenced by the refusal of court to consider vital documents and so on. All these questions, which we wanted to ask, which were stopped, we had to put it on record somehow. And if the court says, I will not record a question, there's no way in which I can change it. Therefore, I filed an application. Then objections were filed. Please come to para 5.
Yes.
Please see para 5. I'll just read this because I want to show you lordship how they are, even on facts.
Yes.
The court has made a complete mistake in saying that we were responsible for causing some kind of a delay.
Yes.
This petition is filed on basis of preliminary decree. Written arguments are filed. In these applications, advocate respondent number 6 have made allegations against the court and have made irrelevant comments in respect to court proceedings. There are no valid grounds mentioned in the application. Therefore, the application can't be considered straight away. As per the application made by respondent number 6, which is IA number 6, court had allowed the prayer of respondent number 6 and witness summons have been issued to the court commissioner as per order dated 23/4. Thereafter posted on 27/4. Since there is a direction by the Honorable High Court of Karnataka in WP number so and so, on that day also respondent number 6 and advocate for respondent number 6 were absent, posted on 35 after vacation. On that day, advocate for petitioner was present, seriously objected, submitted about the conduct to respondent number 6 and advocate for respondent number 6. Then also times were given to take steps. On 1/6, process fee was paid by respondent number 6. Witness summons had been reissued and posted the case on 10/6. Then also witness summons was not issued. Accordingly, it was, I had paid the summons.
Yes.
Accordingly, it was reissued, posted on 18/6. On that day, advocate of petitioners filed protest memo stating about the filing of IA and consideration of IA, and is also stated that absence of defendants and the advocates. Thereafter, this court has considered memo and rejected the same in a detailed order. Further, witness summons had been reissued on 18/6 and posted the case on 15/7. On that day, respondent number 6 and respondent number 6, advocate have not taken proper steps as per law, adjourned to 27/7. On that day, advocate of petitioners filed memo stating about the act and conduct of respondent number 6 and advocate. It has been noted in detail in the order sheet dated so and so. Later in the evening, advocate of respondent number 6 filed IA number 8, it was allowed. From the date of the order on 23/4 till that day, respondent number 6 and advocate have not taken proper steps to get the witness summons served to the court commissioner. I was required to make payment of the process. I was not asked to go and serve it on the commissioner and come back.
Yes.
And I have made payment of the process. Court says, no, you did not take steps.
Yes.
During that period, the advocate for petitioners have seriously objected for grant of adjournment, stating that to drag proceedings, application was filed by respondent number 6. Court has adjourned case with the intention to give opportunity to respondent number 6 and advocate so and so to contest the case properly. Advocate and respondent number 6 and respondent number 6 have misused the adjournment granted by this court. In the application, it is stated that no fair opportunity has been given to them. Not believable. It shows the act and conduct of the said persons. They have made comments and allegations with respect to proceedings of this court and stated that the court has refused to record questions, declined to grant adjournment. Advocate for respondent number 6 has taken several adjournments unnecessarily. Order sheet corroborates the same. Although there is a direction to dispose the petition within time limit with the Honorable High Court, respondent number 6 and advocate have not given any respect to the direction and have not obeyed the direction strictly. They have not cooperated with the court proceedings in a proper manner. This is also submission and objection of advocate for petitioners. Advocate for respondent number 6 was putting questions with respect to preliminary decree. Therefore, this court has objected the questions, stating it is open for him to get cancelled or set aside the decree. The petition has limited scope. Only on the basis of preliminary decree, petition has been filed. Respondent 6 or advocate for respondent 6 can't ask questions about validity of preliminary decree in the petition. If they are not satisfied with the said decree, law is there to get relief before proper forum. Therefore, court objected to the questions. With respect to identity of item number 1, questions were asked. In this petition to the court commissioner, it is not proper way to ask questions. That is exactly my application. For that purpose also, there is remedy to respondent number 6 and advocate for respondent number 6 to approach the proper forum. Instead of doing so, they've come up with the present application, making allegations and comments in respect of court proceedings. It shows the audacity of the said persons. It also gives clear indication that have no knowledge about the court procedure. The serious action has to be taken against respondent number 6, who is deponent in the applications, and advocate for respondent number 6, who has not verified the contents of the affidavit and identified the same. Court is having responsibility to cut down unnecessary questions, irrelevant questions, to save the time of the court. and to prevent unnecessary questions being asked. Order sheet and conduct of the advocate respondent number 6 shows that they are in the habit of taking unnecessary adjournments and dragging the case. It has been noted by advocate of petitions in his memo and submission. Advocate respondent number 6 has to know first what questions are to be asked and what questions are not to be asked during cross-examination of court commissioner in a proceeding like this petition. After cross-examination so and so, advocate of respondent number 6 did not assign valid reasons for further cross-examination. Hence, his prayer was rejected. Court has done its duty properly. It has also been corroborated by the advocate for petitioners during cross-examination, stating that advocate for respondent number 6 was asking unnecessary, irrelevant questions to the witness. It has to be avoided and stopped. By considering his objection also, this court refused to take irrelevant questions, declined to grant adjournment for further cross-examination. It was also not known to the advocate for respondent number 6, and each and every question can't be recorded, and they can't be taken on record. And each and every question can't be refused by noting the same in the order sheet or in the deposition. It is a rule of prudence that each and every word and each and every
that is what that you want to confront that.
I want to confront these 2 or 3 documents, my lord. The conversion, first of all, because it is converted land. You can't treat it as agricultural land. The relinquishment which has been done with respect to the property and the consequence of the relinquishment to the Gram Panchayat. Because practically what the court commissioner is doing is giving the road to them. By that entire division, there are roads. Roads are going to give, how will other people then access the properties? There is a park there. Park has been relinquished. These are all questions, my lord, which the court commissioner has to examine and determine. And therefore, if I don't ask those questions, it will remain a situation where his court will finally pass an order saying there is no question with respect to identity, location, or the nature of the property. And therefore, it will have to pass an order accepting the report of the court commissioner. Therefore, am I so wrong, my lord, in making a request saying I want to mark these documents? And in my affidavit, I say so, that I want to mark these very documents.
Yes. Where is that evidence of CW1? Who is the court commissioner?
233. ADLR.
ADLR. Yes.
Lordship will see how much cross-examination have been allowed. 1 page, not even 1 page.
Yes.
I'll just read this one out if your lordship.
No, it's not necessary. Just we want to see that.
There's nothing. I have not been allowed to ask any questions at all.
Yes. What has happened to that your appeal?
My appeal, my lord, recently an order has been passed by the trial court saying because High Court has directed the FDP to continue, therefore I will not grant stay.
No, that is appeal is before that first appeal court, district court.
District court, the only reason given to refusing injunction is, or the interim order of stay is because of the order at page 235.
Yes. Yes, Mr. Yes.
Partition.
Yes.
Taken place among the family. They can see equity only against the say other two defendants. First thing. Secondly, this responsibility for the party divided in OS number, defendant number 6. He has already filed injunction. I also produced a result date.
Yes.
Where is my page number 51, my ID. File number 50.
Yes.
This is the point of the land and as the developer building permission from the competent authority and the various authorities who are from the armed forces have invested their savings and earnings and in acquiring the loss. We have taken our contention in their state. The learned trial getting indexed here, essentially, by relaying the judgment entered by the court, independently from the court. In case of SPN,
Written statement in that suit. Because they have no right. On the ground that they have no right. Yes.
Once they have taken contention in the return state, it is rejected. Thereafter, in the executive proceeding, they have no right to raise the very same question.
Yes.
Para number 62 of the table standard based on the site.
No, it's not necessary.
Person claiming under such number, who are all the necessary parties?
Para number? Page?
Statement. ILR 2007 Karnataka. Under page number 4192.
Produce ಮಾಡಿದ್ದೀರಾ ಇದರಲ್ಲಿ? ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ. ಹಾ. ಹಾ.
Page number 418.
41?
418.
Yes.
The court can add a party when a party comes to one after the meeting, but before the final meeting takes place. A suit for partition is finally disposed of only with the passing of the final decree. Including of additional parties subsequent to passing of a preliminary decree in a suit for partition is permissible. Only if none of the person, only if none of the person already settled by the preliminary decree would not have to be reopened by reason of the joinder. Therefore, it is clear in order to decide the share to which any number of a family or a person claiming under this number of a joint family, the necessary parties are only the members of the family. Then there is further contention that they have developed the land.
Yes.
However, they cannot take such contention, whereas 85 of the district don't find this.
See, either of the parties will not affect or get any benefit. Even by marking, you are showing that you have developed and there is a road and all. By marking, they will not affect. Ultimately, in the final degree proceedings, whatever the portions will be allotted to that your vendor, it will go.
They'll hand it over to them.
No, see, even if you want to show that these are all the properties where you have formed the road, you want to show that plan and all. Even that will not helpful unless that has to be allotted to your vendor. Even that is marked or it has been, that question has been put to that commissioner, they will also not prejudice.
They will. I'll tell you lots of why. Because
For a limited purpose, to divide the property as a preliminary.
Exactly.
It's not a complicated person to answer other these questions.
It's not
Even. No,
whether he has done his job properly.
Even if it is confronted to that commissioner saying that we have made a plan, you have made in a road and all, how it will prejudice to you? Nothing will happen by putting that question. That property will not go to them unless that property has to be divided, share has to be allotted. If that share goes to his vendor, then only. Nobody will protest why all both of them has fighting like this. I am not understanding that.
I think court is fighting with us a little more.
The purchase are only command record for a limited purpose. Only to work.
No, why you want to confronting these documents to that
I'll
commissioner?
tell you what is why. The commissioner, my lord, has to allocate land which are available in that particular property. Now, whether it should be done in that or in some other property is also a question, because there are 3 items in the property, 3 items in the schedule. Now, my lord,
First, he has to divide that shares of the
but
parties.
first, my lord, what he has to do is to identify also
Yes.
as to whether some of the properties can be allocated to my vendor.
No, that is what that. First preference for your vendor will be
vendor.
given the property which is sold to you.
Correct.
Whether in that you constructed in a building, whether it is in a road, it is immaterial.
No, my lord, it is material from the point of view of adjusting equities. Adjusting equities. Ultimately, now, today in final degree
Now,
proceeding,
in the commissioner report itself shows that you have constructed in a
it
building.
doesn't show.
It is It is there. What is that marking he has shown
No,
that?
nothing. It doesn't show anything. What building is there? What road is there? Nothing is shown.
He has shown
What
that
he
some
should do, my lord.
boxes. What is that?
That one thing your lordship saw was simply a line saying there are some site numbers there.
No,
What
so-
is there? Show me, man. 1 second.
216.
218. 218 is the sketch.
Yes.
216.
216, my lord.
216.
216.
Yes,
What is the
216.
Dimension of the.
In that, what is that? 9, 10,
They are
11?
supposed to be just the sites, my lord, which are sold.
Dimension of the.
By you. Wait. I want clarification. Yes.
Roads are not mentioned, park
Yes.
is not mentioned.
Here, my lord, there are some roads, there are parks.
Hmm.
None of that your lordships can see. What he actually has to do is to take the plan which is there, then superimpose
No,
it.
what is this box he showed? 9, 10, 11, 12,
Okay.
13, 14.
We do not know.
I think that is the building.
They are maybe the site numbers.
The dimension is also not.
Even that road is not shown or not. The preference has to be given to you.
Yes.
That where you have constructed that building.
Correct.
Even if it is, he has
But-
not demarcated the
So,
road.
my lord, question is, who do I ask that question to?
Yes.
I have to ask the commissioner. If he
Yes,
has gone
what
to
you
the
want?
site,
Yes. Your application for what? Yes. Hmm. Yes. Page 6, para 6, page number 10. IA for vacating stayly. Page number 10 is something is
26, page number 26.
this is 26. Yes. Yes. Hmm.
Like, at least the commission should have done this.
Wait. Let. Yes. Hmm. Hmm.
Block number A and B, first kind.
Hmm.
There is only 9, certain is
Hmm.
7, 9, 9 and 11, 12, 13, 14.
Hmm.
Then finally comes the pocket to provide. Page number 26.
Hmm.
Here, I selected this portion. Kindly. One this portion. A and B proposal is not here.
Hmm.
And I select C and D, 22 villas to here.
No, this is, he is yet to be decided the share. Commissioner has decided. Hmm.
The report, Commissioner mentioned the name of client.
No, this portion has been allotted to you.
A and B.
Hmm. No, therefore, they want to show that A and B, which is allotted to you, we have already developed. This is not notified view. Therefore, they want to confrontation. That is where the ultimately court has to decide. After confrontation, court has to decide. No, this even then you have developed. This has to go to you. That is just to court by confrontation or see production of the documents. Why that court has to take such an this thing? No, that you have to be argued when passing in a final degree. See, for evidence of the parties, you need not say all these things. At the time of argument, you can say that even if they are developed, even there is in a road, this has to be given to us. That has to be argued. This is that. Yes. Yes, I heard that. Yes. Hmm. Yes.
Page number, my lord.
Yes.
41, 42, 13.
Yes.
When such properties were acquired.
Yes. Page number?
Page number 4 to 1.
Yes.
When such properties were acquired under a deed,
Hmm.
the purchaser gets no title.
Yes.
Most so in this case that the seller was not absolute owner of the entire property.
Yes.
He had only 1/3 undivided say in the property.
sold, and such purchaser have put up construction without the sanction of law. The record shows that by virtue of such sale, and the which they got no pain. They got the product transferred, got some plan prepared, sanctioned, all of which would not regularize their item or construction, and they have in turn sold the properties and purchased the content.
See, this judgment you can place this judgment when court has passing in a final degree, showing that even though they have developed, even though commissioner has marked, in view of that, it cannot be. But you can't curtail the parties before marking the documents.
The money in the witness to purchaser itself is illegal.
Yes.
ಮೂವತ್ತೈದು ಜನ purchaser ಇದ್ದಾರೆ. 32 ಜನರು ನಾವು ಕಮಿಷನ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಬೇಕಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ
Where they have not filed that 35, they want to. See, now we'll permit only, they have to examine that commissioner to marking these documents, that's all. No further, that too when we have fixed the date, on that day they have to complete that. Yes. No, we'll fix the date on that day, commissioner has to be examined and you have to be concluded on that day itself. Yes. Yes.
Suit is decreed on 21/2022. Immediately activity is filed. Notice was duly served and done. Even after service of 1 year, my God, they never appealed before the court. Then we filed a petition before this honorable court.
Yes.
Seeking direction to dispose the matter.
Yes.
This honorable court was pleased to direct the court to dispose the matter within 1 year. Thereafter, my God, we appeared. He filed application to summon the witness. For 3 days, he has not done. 1 year successfully granted.
No, that has been reflected in the order. See, what here read, order is, court has explained why this has been refused, what the stage they have done it and all. Yes, I have gone through that.
Consider all that. Moreover, my God, one of the purchaser of this petitioner has already approved this honorable court.
Yes.
This order of the time.
No, we are not allowed that purchaser. We are allowed only this Welfare Housing Association. You are the party. R6, defendant number 6.
From the petitioner. He filed impeding application. This application came to be disputed.
Yes.
Again, that will be filed a petition before this honorable court.
Yes.
In directive number 312.1/2024.
Yes.
Where this honorable court made the point very clear.
Yes. Yes.
Page number 18.
Yes.
Not paragraph 96. In fact, paragraph number 7. In that view of the matter, the petition is allowed. The order constituted has the petitioner is permitted to command the court in minority only for the limited purpose of working equity, so as to allow the income of the purchaser to the sale of the report number 2/5, so as to regularize the right of the petitioner in respect of the not purchase value. This is a recent order arising out of the sale of the then my God, ITC, whether the allotment made by the court commissioner is against their interest or not. My Lord, we have taken reasonable steps.
Yes.
In our say.
Yes.
7 villas are there.
Yes.
Had we selected contract to C&D, 22% of the income.
Yes.
Had we selected D&D,
Yes.
11 villas, and all civic communities are included in that area.
Yes.
And consider all these aspects, my Lord, to cause little damages to them. We selected block number ALB.
Yes.
Considering all these actions.
Yes.
Moreover, it's not necessary party, the proper party has no right to examine the court commissioner.
Yes.
Their right is only against their vendor. And moreover, the water is clearly so there. There are about 32 villas. We don't want to cause any damage for them.
Yes.
At least let them say, in which person is most friendly for them.
No, that also they have no right to claim. Only that whatever that is vendor has been allotted, that he has to take. To protect their right and convince the court, they want to show that these are all the development I made it. This can be given a preference. Yes, yes. Yes. Yes, I will consider. Yes, I will consider that. Yes, sorry.
ADL is the government. They are not taking steps. he will not appear before the first property. 1 year time was granted because of examination of the first.
There's a variance in the order sheet.
No, we'll fix the date. We'll also direct that to court on that day,
It is what.
direct them to ADLR has to be present. On that day, they have to complete that. Yes, we,
So direction of that is 1 year, that direction is expired with the pending submission.
yes. Tali. In this writ petition, petitioner called in question, order dated 16/11/2024, passed by third additional senior civil judge JMFC Devnalli on IN number 10 and 11 in FDP 14 of 2022, whereby application filed by the petitioner sixth respondent for recalling,
Yes, recalling.
1806.
yes, further examination of
Recall and further.
recalling
Recall and
of
further.
CW1 and further cross examination. The plaintiff has filed in a suit for partition and separate position. The petitioner defendant number 6 claims yes, that is what that it's all settled law, mister. They can't go beyond that. What is vendor as entitled? Yes. Sixth respondent is also party in the suit as a purchaser of the portion of the property from defendant number. Alala, Mardar Yararo, 1 to Alala, suitally.
Totally 1, 2 and 3. 1, 2 and 3.
1,
1, 2 and 3.
1, 2, 3. See, defendant number 1 to 3 has sold the property in favor of Nene Buildings. Builders, builders. From them, the sixth defendant, sixth respondent petitioner herein has purchased. In the FDP proceedings, the preliminary degree has been passed on
21-22, my lord.
21/20/22.
This is for the execution.
That is there. Even without application, court has to start to
That is
FDP.
what
It's
the-
all settled that. Yes,
Now it's
yes. Yes, yes, that's what I said. Yes, yes. Suit was decreed. The OS number 492 of 2010 has decreed on 20th/11/2022. The plaintiff has filed the final degree proceedings in FDP number 14 of 2022. The trial court has appointed a court commissioner, ADLR as a court commissioner. Court commissioner has submitted a report. The respondent number 6 has examined court commissioner. Court commissioner has been examined as CW1. The respondent number 6 has cross-examined the court commissioner. During the cross-examination, they want to mark some documents which is related to development of property, that is plan sanctioned by competent authority and related documents. Since court has refused to mark the documents, they filed IA number, refused to mark that documents, and examination of CW1 has been closed. Hence, the sixth respondent has filed this application for reopening and further examination of CW1. The trial court has dismissed that application on the ground that the documents which sixth respondent wants to mark is not, it is not related to.
It's already produced.
Yes, he has already produced in that
Suit.
and that further examination, they wants to examine the CW1, that all unnecessary questions, it is not necessary for disposal of the FDP. Hence, their application has been dismissed. Therefore, the sixth respondent before this court. So and so, learned senior counsel appearing for the petitioner has contended that petitioner is a Army Welfare Housing Organization. They have formed the layout after obtaining necessary approved plan from the competent authority, and they have put up a construction, and they have also formed the road. To establish the same, they are required to mark the documents, the plan sanctioned by that authority and related documents. Since the report submitted by the commissioner as not disclosing regarding the development made by the sixth respondent.
It is stated, my lord. It is stated.
No, in that report, that is not shown, Mr.
Yes, it's shown.
Not shown that construction. It is only shown that 9, 10, 11, 12, 13, 14 and 15.
No, my lord. In his report, find is the page I produced.
In submission, that is their submission.
Please.
Yes.
And I just produced.
Therefore, that documents are very necessary to establish their case. Without considering this aspect of the matter, the trial court has error in dismissing that application. Learned counsel appearing for the petitioner, appearing for the respondent number 1, plaintiff has contended that the suit is for partition. The petitioner herein is claiming as a purchaser. Purchaser is not a necessary or proper party in the suit for partition and in final degree proceedings. Since in the written statement filed by that petitioner has been rejected by the trial court, now he cannot be permitted to produce the documents, and he cannot be permitted to further cross-examination of that court commissioner. He has also placed a reliance on judgment of this court in ILR 2012, Karnataka 4129, 2022 16 SCC 71, and 2023 Live Law SC 936 has contended that
Recent Supreme Court judgment.
these are all Supreme Courts. 2022 16 SCC is not a Supreme Court judgment.
Idರಲ್ಲಿ Chandan Ban case ಅಲ್ಲಿ is held that if the alienee developed the property, he has no right to claim even damages also.
Yes, yes.
Chandan Ban case.
And
Relying upon the
contended that
Sardar Chand.
the purchaser has no right or title, has no right in that partition suit. Even if he made any development, he cannot claim any right. Hence, he contended that just to drag the matter, they have filed this application. Trial court, after considering all these aspects, has rightly dismissed that application. Heard the learned counsel for the parties. It is not in dispute. Respondent herein has filed a suit for, respondent number 1 herein has filed a suit for partition and separate position. And it is also not in dispute. Sixth respondent has purchased part of the suit scheduled property by a registered sale deed, and he was also a party in the suit. OS number
492 bar 2010.
492 bar
2010.
2010. Yes. The specific case of the sixth respondent that there that Army Welfare Housing Organization for the benefit of, they are the members. Or you are, that we are constructing for the members.
Yeah, only for
Yes,
for
for the
forces, only for armed forces.
benefit of their members. They have put up in a construction residential, they have found in a residential site here and put up in a construction after obtaining necessary plan from competent authority. Even though they have no right in that suit for partition, since they can claim the right of their vendors. In the FDP proceedings, the trial court has appointed a commissioner. Commissioner has submitted a report. Adanne mark madidara?
Mark agide.
What is that marking?
It is marked as my lord.
CW?
CW1 anta ide.
CW1.
In my IA, my lord, page number 27.
Yes. The specific case of the petitioner that in that commissioner report, they have not shown that development made by that petitioner. Therefore, they are required to mark the documents related to their development, that is plan sanctioned by the competent authority. Then what else, Mr.? Only plan.
Relinquishment deed,
Relinquishment deed, conversion
order.
Relinquishment deed and conversion order.
These are not necessary.
Yes.
Only to drag the proceeding, they are filing.
Yes, yes. Since they want to establish that they have formed the layout in the property which they have purchased, they wants to mark these documents to establish their case.
Our case ultimately is to show that the commissioner report is wrong.
No, that is, you argue that. Now
No, so
here
I-
you want,
but when I cross-examine a commissioner, it is to show that his report is wrong,
yes,
not to
Yes.
establish my case. I'm saying just.
their
point-
main contention is that since commissioner has not
My lord, only one second.
disclosed,
They are not allowing anybody to enter the layout. They
yes,
inducted watchmen.
Yes.
They are showing such a high-handedness.
after that final degree proceedings, you go and execute that and
We
take
will
a
go with police.
Yes, yes. Their contention that since the commissioner report has not disclosed their development, the commissioner has not properly submitted in a report, not properly prepared the report to establish their case. They want to mark this document and they need further cross-examination of the commissioner. By allowing the sixth defendant petitioner herein to further cross-examination of that plaintiff, cross-examination of the commissioner will not prejudice to the right of that respondent plaintiff. Even though they have no right in the partition suit as held by this court as well as Supreme Court, they can claim equity on the basis of their right of his vendor. To that extent, they have to establish their right that they have developed that suit schedule property. Under these circumstances, this court of the opinion that the petitioner has to be given one more opportunity to further cross-examination of court commissioner after subject to certain condition. Accordingly, the writ petition is allowed. Order dated so and so is set aside. IA filed by that respondent number 6, IA number 10 and 11 is allowed. The trial court is directed to fix. I will fix the date on that day. You both of them appear without any notice.
With the commissioner.
No, commissioner, I will direct.
ಅವ್ರಿಗೆ ಕಮಿಷನ್ ಸ್ಟೆಪ್ಪೇ ತಗೊಳ್ಳೋದಿಲ್ಲ ಅವ್ರು ಆಮೇಲೆ ಅಲ್ಲಿ.
Wait, mister.
If my learned doubts us, he can
Definitely,
also-
sir.
he can
One
also
ವರ್ಷ delay
copy
ಮಾಡಿದ್ದಾರೆ.
to the commissioner. It's not only that we have to give.
No, I
If
will
he has a
fix-
problem, he can.
I
put
will
it there.
direct the court to
Send a copy.
send a copy and notice to the commissioner to be present on that.
Problem is that Musivalli,
No,
stop illa Swami.
no,
Stop
nobody
illa.
did not take that notice. I will direct the court to take the notice. Yes.
Please.
Parties are directed to be appear before the trial court on 25th without any further notice. The trial court is directed to issue a notice to the commissioner to be present on 25th.
My lord, kindly see, my lord. 1 year time ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು expiry ಆಗಿದೆ. 23 too long ಆಯ್ತು.
ನಮ್ದು ಆರ್ಡರ್ ಹೋಗ್ಬೇಕಲ್ಲ ಅವರಿಗೆ. ಅವ್ರ ಆರ್ಡರ್ ಹೋಗಿ ನಮ್ಮ ಆರ್ಡರ್ ಮೇಲ್ಗಡೆ he can send it. Yes, without my order they cannot issue, Mr.
Difficulties, my lord, plaintiff.
25th is also hardly 2 weeks, Mr. 2 weeks. I have to sign that order and send it, Mr.
My lord, they are senior citizen, my lord.
25th.
Unnecessarily they are delaying the
Yes,
proceeding.
on 25th, that respondent number 6 petitioner herein without any further adjournment has to be further examination of the court commissioner, and he has to complete his examination on that day without taking any further adjournment. Yes. Yes.
Kindly issue notice to the commissioner, notice of it.
Is directed the court on basis of this order, issue a notice to commissioner and to be present on 25th.
I have only one more
But it
request.
cannot be issued. Please, court. Yes, therefore my order has to be reached to the court to issue notice to the commissioner.
Please,
I
please.
have one more request not to make. There are some, my lord, unpalatable comments made about the lawyer. Now, a lawyer, my lord, he didn't even argue this.
That
application.
order is set aside, Mr.
No,
Let
no,
us-
but the lordship may only say those statements may be expunged, my lord, because.
No, order is set aside, then it will not
My
be
lord,
an
has
expansion.
to-
No,
has to
if
learn
that order
only-
is,
Unnecessarily, he is adopting the theory of the dragging the proceeding. Wherever he go, my lord, he
No.
adopt the same, very same theory.
no, maybe there.
Break
because-
respect, I am not
No,
objecting.
I-
Conduct has to be changed.
No, no, see, the way court
He's a
has,
lawyer, what is this thing?
who has, you are appeared there, you are appearing there. You both are appearing.
Yes, yes.
And then he's making general comments also about him saying in all
No,
cases.
boy,
do
I
the
think,
same. What is
The court has frustrated from both, therefore they have making an order like.
ಒಂದು ವರ್ಷ ಡಿಲೇ ಮಾಡಿದ್ದಾರೆ, ಒಂದು
ಅಲ್ಲ,
ವರ್ಷ steps ತಗೊಳ್ಳಿದೆ.
I've seen for the first
Again,
time
it
a
is-
FTP being
Fix
decided.
the date on 25th, yes.
Please, madam.
Yes.
Better said that.
Pass.
Fast over matter, serial number 5, Govindaraya Kamath K.
Or the
ಏನಂತ
petitioner,
ಹೇಳ್ತಾರೆ?
Lord.
ಅದು dispose ಆಗಿದೆ.
Just give this. Just open the CPC.
Eventually will dispose.
Just open all that window.
No, that injunction suit which has been disposed of, again review has been filed.
Yes, Lord, that's the background I was telling your lordship.
Hmm.
There's a review that was filed. The injunction suit is disposed of on 14/10.
Hmm.
I told your lordship, both the suits were reserved on 12/8/2024.
Hmm.
Lord, it was argued.
First, he only disposed of or some other.
The same, it's a lady judge, Lord.
Yes.
The lady judge had heard this matter at least on 4 dates. Both suits were heard together. And it was very clearly mentioned there, whatever happens in the partition suit will consequentially follow in the injunction suit.
First,
But
they have to be
ಅದೇನಾಗುತ್ತೆ?
decided this.
The matters are not linked. So in the injunction suit, because they have to get those points every month, there is no defendant's evidence led in the injunction suit. So that's easy to dispose of.
So now we will direct that to dispose of this.
Lord, it's reserved for judgment.
Yes.
That judgment has to be released. Lord, she's an 87-year-old lady. Lord.
Yes, in the month.
Lord, can I just show you one judge?
No, not that.
One judge, one. Lord,
No,
let
we
this
know
be-
everything.
Let this be used as an opportunity to pass some.
Hey,
direct-
we
Look,
know-
CPC
no,
takes
mister.
down, order 20 says 30 days. If you want 60 days, you make out exceptional reasons. The order sheet says for judgment, for judgment. Every time the 87-year-old lady goes there.
No, we
and
have in a
makes-
judicial academy, mister. We'll do it. Wait.
Yes.
Yes. Third. In this writ petition, petitioner has sought.
Lord, my prayer is at 2 weeks, Lord.
Wait. Yes. Directing so and so additional city civil and session judge Bangalore to pronounce the judgment and dispose of OS number 49 of 2018 within period of 2 weeks from the date of the order. In view of that direction sought by that petitioner, issuing notice to the respondent is not necessary. You are that defendant.
Yes, my Lord. I am for
Plaintiff.
defendant 1 and 2, petitioner 1 and 2.
Yes, plaintiff has filed in a suit for declaration in OS number 49 of 2018. Learned counsel for the petitioner has submitted that. After completion of argument of the parties, the matter has been reserved for judgment on 12/8/2024. Thereafter, one after the other is the matter is adjourned. The judgment has not been pronounced, therefore is sought for early disposal of the suit in view of the above, without expressing any opinion on the merit of the case. So and so court is directed to dispose of that matter not later than 30 days from today. Yes.
Lord, can your lordship make one additional observation? The matter was heard on 12/8. It's over 200 days. Lord, most of the judgments say that it has to be reopened for arguments. So lordship, the judge will hear us before passing judgment one, just to refresh our memory.
No, therefore, I think the order sheet which I produced is showing that further hearing.
For arguments.
No,
Yes, Lord.
somewhere you have shown that it's a, I have seen that paper, that page 66.
Yes, Lord.
It
All
is
right, all
next purpose is argument on 22/3/2025.
ಅದ್ ಯಾವಾಗ ಅಲ್ಲಿ ಹೋಗ್ತೀವೋ they will say injunction suit ಅಲ್ಲಿ order ಇನ್ನು review ನಲ್ಲಿ pass ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ. Now that your lordship has passed this direction, Lord.
Yes, therefore,
Yes.
they have said that it is argument. If
Out
it
of
is
limit of
not
30
posted
days.
before the court,
Yes.
they kept it for 2 months, then it has to be, that's what the Supreme Court says.
Yes.
Because they may forget that what has there.
Yes, yes.
Yes.
I'm grateful.
Cell number 35, Jagadish HT.
Yes, it's not, the petitioner has filed a suit for declaration and injunction of the suicidal property Malada. And based on the lease deed Malada, lease deed executed by the defendant number 1 to 3 Malada. And is in an unregistered document Malada. The court has directed to pay the duty penalty Malada. The petitioner has
Suit
paid,
for,
declaration and injunction. The portion of the suicidal property, the easing portion of the suicidal property.
you are the
plaintiff,
plaintiff.
Malada.
What is that order you are challenging?
But in the admissibility of the release date, Malad, in the annexure D, Malad, LDCD, annexure D,
Annexure D.
annexure D.
What is that order?
Order, Malad, is an unrestricted release date, Malad, cannot be marked in the evidence, Malad,
No, they refuse to mark that document.
document.
Why?
But if Malad is in an unrestricted document, Malad, the court has direct to pay the duty penalty, Malad, I paid the duty penalty, Malad. In
Unregistered further, it is relevant to note that plaintiff claiming in ownership possession of suit property is released, it cannot be marked with truth ownership. Yes,
like,
or issue notice. Stay of, why you want stay of order? Order stay ಮಾಡಿಸ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, marking of document, Malad, marking.
ಆಯ್ತು, ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಏನ್ ಸಿಗುತ್ತೆ ನಿಮಗೆ? ಮಾರ್ಕಿಂಗ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅಲ್ಲ, ಆಗ್ಲಿಲ್ಲ ನನ್ನ ಸೂಟೆ ಹೋಗುತ್ತೆ, ಸೂಟೆ ಹೋಗುತ್ತೆ.
ಅಲ್ರಿ,
ಬೇಸ್ಡ್ ಆನ್ ದಿ ರಿಲೀಸ್ ಡೇಟ್ ಮೇಲೆ ನಾನು ಕೇಳ್ತಾ ರಿಲೀಸ್ ಡೇಟ್ ಮೇಲೆ ಕೇಳ್ತಾ.
ಅಲ್ರಿ, ನೀವು ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಿಸಿದ್ರೆ ಏನ್ರಿ ಬಂತು ನಿಮಗೆ? ಡಿಸ್ಮಿಸಲ್ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಿದ್ರಿ. Yes, stay of further proceedings in OS number 1 of 2014 pending in the file of additional city civil judge JMFC Arsikere. Yes.
Cell number 36, PP Hegde.
Yes, typed copy of the annexures to be, typed copy to be filed. Yes,
Please,
yes.
my lords, the,
This could have been done your colleagues when it is filed. Yes, yes,
I do agree.
yes.
Please, my lords. My lords, the plaintiff is before my lord. He had the benefit of an interim ex parte injunction order, my lord, the owner of the plaintiff property. The relief is very simple, my lord. Kindly see annexure page 13, my lords.
Yes.
The relief sought is, my lords, against the respondents, Kaveri Niravari Nigama Limited, my lords, and their engineers. They want to form a new road inside the plain shell property, which belongs to him. And the plain shell property, my lords, is described properly, my lords. It's converted property, my lord. Page 16, it's 50 cents of land, it's converted. All the documents in his name is the purchased property, my lords.
Yes.
Now, my lord, the learned trial judge, my lords, granted the injunction order, my lords, page number 39. Restraining them from interfering with the possession and enjoyment of the plain shell property.
39.
Page 39, my lords, operative portion, the interim order. Now, my lord, it's because the defendants themselves said, my lord, return statement may beg to take the honorable court the return statement filed, page 28, annexure D.
No, you are the plaintiff.
I am the plaintiff, injunction is granted.
Injunction is
Because
granted.
defendant's return statement says, we are farming the road, but not in the plain shell property. ಯಾವತ್ತೊತ್ತಿಗೆ ನಾವೇ ತೊಂದರೆ ಮಾಡೋದು, that is the contention. Another contention, they urge my lords, ಅದನ್ನ ಅಳತೆ ಎಲ್ಲ ಮಾಡಿಲ್ಲ, etc. Another contention.
What that injunction order is vacated.
Is vacated and immediately after vacating that injunction order, my lords, they forcibly enter our land since yesterday and with the JCBs, etc. May I pass on the photographs, my lords?
No, they are saying that they are farming the road in which property?
They say the government land we are farming. That is the statement made in the return statement.
They are not farming in that suit-suitable property.
ಹೌದು, ಮಾಡೋದಿಲ್ಲ ಅಂತ. One more contention is taken. The plain shell property is properly measured, etc. Survey is not done, etc. And
To notice, parties are directed to maintain status quo in respect of suit-suitable property.
please, my lords,
Yes,
my lords,
next. They are farming other than that suit-suitable property.
we have no objection.
Yes.
Now, what they have done is, my lords, they dumped materials. Yesterday, they have almost started leveling, my lords. Let
Yes.
them not proceed with any work is my humble submission, my lords.
Parties to maintain status quo antandre, that's what that.
Yes,
Even
but
they can't take
the
out
status
that.
quo, because they have started farming the road. I may pray. in
That will
this
be
case
kept as it is. Yes.
as it is, my lords.
Office submission is accepted, office objection overruled. Yes,
Cell number
that-
37, Oka Reddy.
yes, yes.
Please, my lord, may I submit one, kindly excuse me, my lords. 30 ಇದೆ ನಿಮ್ಮದು ಯಾವುದು? 39 ಎರಡು ಒಂದೇ. ತಂದೆ ಮತ್ತು ಮಗ
Same ಇದೆ.
ಪ್ರಾಪರ್ಟಿ ಹೌದು.
Yes.
39. That your lords, kindly same better copy is ready, my lords.
No, same suit.
Two different suits, because 1 acre, total is 1 acre land. One is 50 cents, another 50 cents.
No, it is in father's name and
Oh, the father had, my lord, gifted the property to the wife who is no more. Now therefore the son has come up, my lords.
maintain status quo in respect of suit-suitable property till next date of it.
Please, both your
Seven,
lords, may kindly
Oka
grant
Reddy.
Yes,
hand delivering both. Grateful.
37.
yes.
Petitioner, my lord, who is the plaintiff.
What is that?
before the
You have
client.
complied that office objection.
Office objections complied, my lord.
Yes,
My lord, the petitioner has challenged the order,
Hmm.
the appointment of the commissioner.
yes.
The suit is, my lord, filed by the petitioner for recovery of the money.
You have filed in a suit. Hmm.
My lord, the petitioner has filed the suit for recovery of the money based on the lease agreement executed by the defendant.
Yes.
My lord, the petitioner is a tenant. The respondent is a landlord. My lord, he has received the 3 lakhs, the lease amount from
Hmm.
the petitioner.
Hmm.
My lord, the petitioner,
Hmm.
3 years time for the lease period, my lord.
Hmm.
After lease period, she has issued the notice,
Hmm.
demanding notice to pay the amount for vacating the premises.
Hmm.
My lord, notice has denied, the position denied and the lease agreement was denied.
Hmm.
My lord, even after the evidence closed, my lord, the plaintiff has produced even the photos.
Hmm.
In the premises, he is in possession of the property. Kindly.
Now, what is that commissioner?
Commissioner appoint only limited for the petitioner is in possession of the property. Kindly see the photos, my lord, annexure M1.
Where is that order?
My lord, order is, my lord, the annexure. Yeah, my lord. The page number 20.
ಆಯ್ತು, ನಿಮಗೂ ಒಳ್ಳೇದಾಗುತ್ತಲ್ಲ ಈಗ. ನಿಮಗೆ ಅವ್ರು ಇಲ್ಲ ಅಂತಿದ್ದಾರೆ, ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಇದಾರೆ ಅಂದ್ರೆ ಮುಗ್ದೋಯ್ತಲ್ಲ ನಿಮ್ ಕೇಸ್, ನೀವು ಪ್ರೂವ್ ಮಾಡದೆ ತಪ್ಪು.
Yes, my lord. Therefore, I filed this application for
You have filed an application.
Yes, my lord, we have filed the application.
Hmm.
On the court, my lord, they record the reason, in page number, my lord,
See, you are the owner,
I am the tenant, my lord,
you are the tenant.
the tenant. I have paid 3 lakhs, the lease amount.
No, yes, what is the prayer in the suit?
Prayer for the recovery of the money, my lord, for the payment of 3 lakhs amount under the lease agreement.
Hmm.
Issues was framed, the first issue is the plaintiff has to prove the landlord and tenant.
Hmm.
But in the.
Now, you are in the possession of the property.
Yes, my lord, as per the photos, kindly see the photos, my lord.
Hmm.
In the inside of the photos, page number 63, M1, M2, M3.
What is
If
the
the
defense of
commission-
the defendant?
Dependent totally, the signature has denied, agreement has denied and position is denied. Totally denied in order to prolong the
ಆಯ್ತು,
payment
ನೀವು
of the
ಅಲ್ಲಿ
amount.
ಮನೇಲಿ ಇದ್ದು ನಿಮಗೆ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ
ಎಲ್ಲ ಇದೆ, ನಾವು ಎಲ್ಲ.
ಕಮಿಷನರ್ ಬೇಕು, ಅಷ್ಟಿದ್ರೆ ಸಾಕಲ್ಲ. Why do you-
My lord, the court feels that, my lord, she has entered deny the execution.
Hmm.
The position denied.
Hmm.
In the cross examination, entered from the initial of the notice. All the contentions, my lord, as denied by the
No, you have paid that amount through that agreement.
agreement, my lord.
Hmm.
That agreement, she has denied the execution of the agreement also.
ಮತ್ತೆ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಕೇಳೋದ್ ಬಿಟ್ಟು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಟು ಸರ್ವೆ ದ ಹೌಸ್. ವೈ, ವಾಟ್ ಇಸ್ ದ ಪರ್ಪಸ್, ಮಿಸ್ಟರ್?
Malad, she is,
Agreement established ಮಾಡ್ಬೇಕು ತಾನೆ
if the
first.
commissioner comes to the house, Malad, she is in possession of the property.
ನೀವು
Can't
position ಅಲ್ಲಿ
become an
ಇದ್ರೆ
end.
ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. They are denying that they have executed that lease agreement.
Malad, even position was denied. Therefore, I have.
ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ದುಡ್ಡು. ದುಡ್ಡಿಗೆ ಅವ್ರ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರೂವ್ ಆದ್ರೆ ದೇ ಆರ್ ಎಂಟೈಟಲ್ ಟು ರೀಪೇ ದಟ್ ಅಮೌಂಟ್.
Yes.
ಅದನ್ನ ಪ್ರೂವ್ ಮಾಡೋದ್ ಬಿಟ್ಟು ಫಸ್ಟ್ ನೀವು ವೈ ಡು ವಾಂಟ್ ಟು ಪ್ರೂವ್ ದಟ್ ಇನ್ ದ ಪೊಸಿಷನ್?
Malad, even signatures has been denied. We are in possession of the property.
ಆಯ್ತ್ರಿ, ಸಿಗ್ನೇಚರ್ ಡಿನೇ ಮಾಡಿದಾಗ್ಲೇ
This is
ತಾನೇ
the-
ಕೋರ್ಟ್ ಕಮಿಷನರ್
this is-
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ನ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು.
Yes, Malad, this is the way, Malad, for, if the commissioner comes to the house and to the prove the position of the property, Malad, the
Yes.
matter become an end, Malad.
ವಾಟ್ ಇಸ್ ದಟ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್
Next date, Malad, today is the next date, Malad,
ಫಾರ್ ವಾಟ್ ಟುಡೇ?
for the argument on the main.
ಏನಾಯ್ತು ಇವತ್ತು ಮ್ಯಾಟರ್?
ಇವತ್ತು this the writ petition post ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ?
It was urgent, Malad. Next,
Then?
a date collect ಮಾಡಿಲ್ಲ.
You collect the date, yes, and you take hand summons,
Yes,
issue notice. In addition, petitioner is permitted to serve on hand summons to the respondent number 1 and yes. Submission is accepted after subjection is over. Yes.
Serial number 40, Rajesh G.
Yes.
In this case, myself is the counsel for the petitioner number 1 and 3.
Now the observation. Now you have made them as
Made them as parties, your lordship.
Where is that?
In page number 6, your lordship.
Yes. Yes. Yes,
Wife and 2 children, your lordship.
yes.
The brief facts of the case is the plaintiff has initiated a money suit on the said defendants, your lordship, on the all the 3 petitioners. These are the legal heirs of one advocate, Jane Gurapareddy, your lordship. There was a transaction between plaintiff and he was a very close friend of the plaintiff. But he used to lend money and it was returned back through by way of checks and it was returned back, your lordship. That's the thing. And while initiating the money suit, he has placed reliance on 3 original documents, your lordship.
You have to take out that this thing, Mr. You have to take out your band. You are appearing for 14%.
But no, I am appearing for petitioner number 1 and 3, your lordship. As an
What about
advocate.
that other?
One more counsel is engaged in
Where is
magistrate
he?
court.
Where is he?
He is engaged in magistrate court.
Then you have to be now representing all.
On behalf of petitioner number 1 and 3, your lordship.
Yes.
And he has placed reliance on 3 original documents, your lordship,
Yes.
which are annexed as Annexure B, C, and D, your
Where is
lordship.
the plaint?
A plain furnished model. Since this is the case challenging the order passed on IA, your lordship, for stamp duty. Stamp duty IA, your lordship.
What is that IA? What is that order, Mr.?
IA is annexed as Annexure E, your lordship, in page number 52.
What is the application?
This is the application filed by the defendants to impound, to direct the plaintiff to file the necessary stamp duty and penalty on the said documents, your lordship, which are mentioned. Acknowledgement letter from so and so, 11/7/2018, on demand promissory note and consideration receipt. In this regard, even the plaintiff has,
You have the plaint copy, Mr.
right now I don't have.
Where is that? You have to produce the plaint copy, Mr. You produce that plaint copy. Yes. Monday.
No, Monday.
Yes. At the request, leave this matter on Monday.
Serial number 44, Venkata Chalapati SK.
Yes.
Lord, challenged the orders passed by the trial court. That is annexure A. The petitioner is the defendant before the trial court. The plaintiff has filed the suit for declaration, declaring that he has an offshare in the suitable property. That is, he is contending that in the year 1991, there was a partition deed.
Suit for?
Suit for declaration,
Yes.
declaring that he become the absolute owner of the off of the scheduled property.
Then what is that order you are challenging?
My lord, I have filed an application to recall and reopen the stage of cross-examination of PW1.
Why?
So because some incriminating evidence has been left out to cross-examine the PW1. So because the partition deed was affected in the year
No,
1991.
when you have completed that evidence of PW1?
My lord, I have completed on 11/1/24, my lord.
11-1.
24.
After 1 year, you have realized that you are not.
The advocate has been changed from
That is not the reason, Mr. All cases, that is the only this thing.
1991, there was a partition deed.
Yes.
Was challenging that partition deed. That is
What
why
is that? Now you want to add that. Suit for declaration.
Please, ma'am.
What is your defense?
My defense is I am in possession of the entire scheduled property on the basis of the partition deed executed in the year
Yes.
1991.
Yes, you have examined that PW1, cross-examine in that aspect. Now, what is that additional you want to cross-examine?
Some part of that partition deed has been left out. That is why I recall the
The
PW.
filed by the dependent is hereby dismissed with a cost.
Please.
Yes, what is the reason?
Well, reason is from
Relief of
page
recall
number
and reopening filed
15.
without filed in a specific provision. The absence of specific defendant cannot be seized.
151 ಹಾಕಿದ್ದಾರೆ.
151 ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು.
Recall and reopen ಎರಡಕ್ಕೂ 151 ಹಾಕಿದ್ದಾರೆ. That's why.
151 is the correct provision, not order 18, rule 17. But court has wrongly understood. Yes. Now, what is the stage, mister?
Stage is for arguments.
Next date?
12th.
Huh?
12th.
Yes, how issue notice. Stay of further proceedings in OS number?
Vice number 1 of 2015.
2015 pending in the file of first additional civil judge JMFC, Polar.
KG.
Till next date of hearing. The petitioner is also permitted to serve a copy and the counsel appearing for the respondent before the trial court. Yes.
Office objection.
Submission is accepted of subjection court. Yes.
Cell number 63, Pradeep S.
Petitioner, please, Lords. Lords, petitioner is before the honorable court.
Petitioner is not a party in OS to
Yes,
be clarified. Why?
My case is that after the father had sold the property in 1997, after conversion of the property, subdividing it into sites, several people buying and selling, and I having become the owner. In 2019, the children file a suit amongst themselves, fraudulently go before the Lok Adalat, say everybody has a share and.
You are challenging that Lok Adalat.
I'm challenging the similar matter, my lords, has heard. The connected matter insofar as several other sites.
Yes.
Kindly see annexure Q, my lords, at page 164. This honorable court has directed parties to maintain status quo insofar as the suit scheduled properties are concerned. (165) is the
165
order.
Yes.
Father buys it in 1968, converts it in 92, forms sites, sells it in 1997. Me amongst other people purchase it. 2019, this collusive suit is filed.
Submission is accepted. Office objection is overruled. Issue notice. Parties are directed to maintain status quo in respect of writ petition properties. Yes.
Connected matter is also 65, my lords.
Serial number.
Serial number 60. Idu 63. 65 ಇದೆ so.
No, connected andre in that.
Andre other purchasers, one other purchaser.
No, in that interim order is already granted.
Illa. The new suit, new writ petition.
65 also same. Same order.
One more matter was supposed to get listed.
You file a memo. Yes, you file a memo. We'll see.
Memo ಹಾಕಿದ್ದೀನಿ so ಅದನ್ನು.
Yes, ಬರ್ಲಿ.
We'll
Yes.
file.
Cell number 64, Tarun Surana.
This is a proceedings.
What is that maintainability?
But it has been returned from the civil court as well as the commercial court. Now, I filed a suit before the city civil court for injunction against trademark infringement. Now, city court returns the plaint stating that the value of the asset involved is about 3 lakhs. Then the plaint is returned. I present it before the commercial courts. Then the commercial courts returns the plaint again, stating that the plaintiff has not justified why the value of the asset is above 3 lakhs. This is a peculiar situation, my lord. May I just point out?
This is an order passed by the commercial court.
There are 2 orders, my lord.
No, now that one of the order is that commercial court. Then you have to file a commercial appeal.
But under section 13, my lord, is when a decree is passed, I can file an appeal, my lord. Now, there is no decree passed in this proceedings.
Commercial
is only written.
court order. Commercial court. Section 13.
13, my lord. Appeals from decrees of commercial court and commercial divisions.
Yes, any person aggrieved by the judgment and order of the commercial court below the level of district judge may appeal to that commercial appellate court within the period of 60 days. Any person aggrieved by that order, commercial court, commercial appellate court within the period of so and so. Any person aggrieved by the judgment and degree of the commercial court, so and so. Provided that appeal shall rise from such order specified to the commercial division, commercial court that specially. Order 43 ಒಳಗಡೆ ಇದ್ರೆ ಮಾತ್ರ ಬರುತ್ತೆ. Yes, what is that? Where is that order?
Order, my lord, is at annexure A.
Return of plaint.
Please, my lord.
Return of plaint under which provision?
Now, order 7 rule 10, my lord.
Order?
7 rule 10. Now, please see page 32.
CPC, order 40. 43. Return of the plaint.
Please, my lord.
Return of the plaint is order
Order 7 rule 10.
7 rule 10. Any order under order 10 rule 7, return of the plaint to be presented to that proper court fee, so and so to that appeal. Appeal is provided.
Please, my lord, may I point out section 8 of the Commercial Court Act? Section 8, my lord. May I read out section 8?
No, section 13C.
13C, my lord. 13 is there. May I also read section 8?
Section 8 for what?
Of the Commercial Court Act itself. Bar against revision application or petition against any interlocutory order.
No, that is revision against that interlocutory order is barred.
Please, my lord.
If any order passed which is provided appeal under 43, you can file a commercial appeal. You read
The
that.
commercial appeal is when a decree is passed in section 30.
You read this.
Please, my lord.
See, provided that appeal shall lie from such an order passed by the commercial division, commercial court that are specifically enumerated under order 43 of the CPC.
43.
You see that order 43. Any order passed under that order 7 rule 10 is appealable.
But in a similar situation in Eagle Sight Media versus BTV, it was entertained, my lord, in a similar matter.
No, this is what that appeal is maintainable. You have to answer this.
No, there are two orders, which is one passed by the civil court, one passed by the commercial court.
Ultimately,
I
if
have
it is in a
sought for-
commercial, see, preference has to be given to that commercial court order because
It is like a
the Act, Commercial Court Act says it has to be heard by the specialized bench which is constituted by the Chief Justice for that purpose.
But I am only
Therefore,
before the
preference
court.
has to be given.
I am only before
Appeal
the
has to be
court.
filed before this court only. It has to go before the division bench.
But I am only before the court that the suit may be restored. There are two suits. One filed before the civil court, which was returned, and that was
see,
presented before the. My
order
relief is
passed-
alternative relief, not that one of the suits may be restored.
No, for that order has to be
Yes, sir.
decided whether that order is right or wrong.
Not in any event, even the civil court order may be overruled, my lord.
Yes, yes. You can argue leisure. Yes, lease this matter next week. Yes.
Yes.
Serial number 65 Adjournment, serial number 66 Sachin BS.
Lords, I appear for the, what's the
First
maintain,
matter. Yes. What is that maintainability?
my lords, paintability, my lords, they are saying that the annexure A, my lords, is to be challenged in an RSA under section 100, my lords. My lords may see annexure A, page number 19, the order, my lords. Lords, I am the obstructor in the execution petition. My IA, my lords, is dismissed. I file an RA. In the RA, my lord, the respondent file a memo stating that this court has no jurisdiction to try the matter. The court, my lords, has dismissed my
What order you are challenging here?
My lords, RA, my lords, page number 19 and 20.
Page number
19. Annexure A, page number 19.
19.
19. Order on memo, my lords.
Yes.
Lords, the order, my lords, is at page number 20, at the bottom. Memo filed by respondent is hereby allowed. Consequently, appeal is hereby dismissed. Lords, the appeal itself, the order itself states that the court has no jurisdiction to try the matter, hence the appeal is dismissed. Lords, on the ground of pecuniary jurisdiction, my lords, it has been dismissed. Article 227, my lords, is always applicable because the ground, my lords, I have not the.
No, if there is an appeal remedy available,
My lords, appeal.
we need not exercise
Please,
that.
my lords, section 100 may be looked into, my lords, which clearly states any decree may be challenged before the High Court, my lords. Section 100 of the.
What is the degree?
My lords, there is no decree in here.
No, you have seen that definition of degree.
Please, my lords, any adjudication between the parties. Lords, here it is dismissed on the ground of want of jurisdiction. There is no decree, my lords, in this regular appeal also.
Appeal from the senior judge status so and so.
My lords may see section
Yes, we'll
100.
Here on the Monday, yes.
Monday.
Yes. I thought other matters.
My lords, Monday, my lords, I request my lords
Yes.
preliminary hearing.
Bharat, yes.
My lords, it won't read.
67. Yes. Filed in a memo seeking leave of this court to withdraw, the dismissed as withdrawn. Yes.
Lordship, kindly. Serial number 8. Serial number.
Any date you want, you take that except.
Your Lordship, serial number 99.
Any date you want on the interim order is also will extend it wherever you just mention.
Serial.
Except tomorrow we give that. Yes.
Serial number.
ನಾಳೆ ಇದೆ ಒಂದ್ ನಿಮಿಷ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳ್ತೀನಿ ಅರ್ಜೆನ್ಸಿ ಎಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ ಫಸ್ಟ್ ನಿಮ್ಗೆ ಹೇಳ್ಬಿಡ್ತೀನಿ ಇಷ್ಟು ಜನ ಆಮೇಲೆ ನೀವೇನ್ ಬೇಕೋ ಮಾಡಿ ಎನ್ನೆಗೆ ಡೇಟ್ ನಿಂತಿರೋದು 26 ಇವತ್ತು ನಾನು ಕೊಡ್ಬೇಕಾದ್ರು 27th ಮಾರ್ಚ್ ಇಂದ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋರು ವಾರಲ್ಲಿ ಇರೋರು ಬೆಳಿಗ್ಗೆ ನಿಮ್ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ಗೆ ಮೂವ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ನಾನು ಸೀರಿಯಲ್ ವೈಸ್ ಹೋಗ್ತೀನಿ ಡೇಟ್ ನಾನು ಕೊಡೋದು 27th ಇಂದ ಅದೊಂದಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ತಗೊಳ್ಳಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿರ್ತೀನಿ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ
68 petitioner.
ಹೇಳಿ
27th happening.
27
Please. Thank you.
69
27.
ಒಂದೇ ಡೇಟ್ ತಗೋಬೇಡಿ ಮೇಡಮ್ ಇಲ್ಲ ಅವತ್ತು ಇದಾಗುತ್ತೆ ಮತ್ತೆ ಫ್ರೈಡೆ ತಗೋ RFA 70
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್ ಮಂಡೇ
ಅಡ್ಜ 71 ನಾಳೆ ಅಂತಾರೆ
ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲ ಆಗುತ್ತೆ ಕೇಳ್ಬೇಡಿ ಆಗುತ್ತೆ
70 ಯಾವುದು 28 ಫ್ರೈಡೆ RFA ಬರುತ್ತೆ ಅವತ್ತು ಅಪ್ಲೈಸ್ ಮಾಡಲ್ಲ
ಆಮೇಲೆ ಹೇಳಿ ಸರ್ ಮುಂದಿನ ಮಂಡೇ ಕೊಡಿ
ಮಂಡೇ ಕೊಡ್ಲಾ ಮಂಡೇ ರಜಾ ಸೊ 1-4 ಔಟ್ 71
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ಬಿಡ್ತಾರೆ ಕೊಟ್ಬಿಡಿ
VC ಅವರು ಒಂದು 5 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಸರ್
ಅಲ್ಲಿ ಕೈ ತೋರ್ಸಿ 74
ಆಗುತ್ತೆ
ಮತ್ತೆ ರಿಪೀಟ್ ಮಾಡ್ಬಿಡಿ ಪಾಪ ಎಷ್ಟು ಜನ ವೇಟ್ ಮಾಡ್ತಾರೆ ಡೇಟ್ ಏನು ಮತ್ತೆ ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಮುಗಿದೋಯ್ತು 75
ಓಕೆ
78 79
ಇಲ್ಲ ಅರ್ಜೆಂಟ್
ಆಯ್ತು 80 ಆಗೋಯ್ತು ಒಂದ್ಸಲ ಹೇಳಿದ್ರೆ ನೋಟ್ ಆಯ್ತು 80 81 ಫಸ್ಟ್ ಏಪ್ರಿಲ್ 82
ಕೊಡಿ ಯಾವತ್ತು
ಸರ್ ಏಪ್ರಿಲ್ ಸೆಕೆಂಡ್ ಏಪ್ರಿಲ್ 83
ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಡೇಟ್ ಬೇಡ
86
ಏಪ್ರಿಲ್ ಎನಿ ಡೇಟ್ ಸರ್
86 ಸರ್ 13th ಆಗ್ಬೋದು 14th ಆಗ್ಬೋದು ಸರ್
ಸೆಕೆಂಡ್ ಏಪ್ರಿಲ್
ಸರ್ 86 24
87 89
ಅಲ್ಲ 88 ಸರ್
ಬೆಳಿಗ್ಗೆ ಫಸ್ಟ್ ಅವರ್ ಅಂತ ತಗೊಂಡಿದ್ದೀನಿ
ಯಾವತ್ತು ತಗೊಂಡಿದ್ದಾರೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೊರಟು ಹೋಗಿದ್ದಾರೆ
ಡೇಟ್ ಹಾಕಿ ಸರ್
ಡೇಟ್
ಅಲ್ಲ ಟ್ಯೂಸ್ಡೇ
ಫಸ್ಟ್ ಅವರ್ ಅಲ್ಲಿ ಆಗಿ ಸೈನ್ ಆಗಿ ರೆಕಾರ್ಡ್ ಹೊರಟು 89
ಏಪ್ರಿಲ್ ಹಾಕಿ ಸರ್
ಏನ್ ಸರ್ 89
89
ಕೇಳಿಸಲ್ಲ ಸರ್
90 91 ಸೆಕೆಂಡ್ ಏಪ್ರಿಲ್ 92 94.
93 ಬೆಳಗ್ಗೆ ಆಗಿದೆ.
95.
27.
ನಾವು ಒಂದೇ ಡೇಟ್ ತಗೊಂಡ್ಬಿಡಿ ಸರ್, ಅವತ್ತು ಹಾಗೆ ವೇಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ. 96.
94 ಯಾವ ಡೇಟ್?
27.
ಮಂಡೆ ಹಾಕಿ, ಇಲ್ಲಾಂದ್ರೆ ಡೇಟ್ ಬೇಡ. ಮೂವ್ ಮಾಡ್ತೀವಿ.
ಯಾರೋ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
97.
ಇದೆ ಸರ್, ಇನ್ನೂ ಬಂದಿಲ್ಲ. 94 ಸರ್, ಹೇಳಿ ಡೇಟ್ ಯಾವ್ದು?
ಡೇಟ್ ಬೇಡ.
ನಿಮ್ದಲ್ಲ ನಿಮ್ದು.
ಸಾರಿ ಸರ್.
ಮಂತ್ ಎಂಡ್ ಅಲ್ಲಿ 27. ಓಕೆ,
ಮಂಡೇ ಕುಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಬೇಡ.
97.
ಮಂಡೇ ಕುಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಬೇಡ.
ಮಂಡೇ ಅಂದ್ರೆ 1st April ನೀವು ಕೇಳೋದು.
ಇಲ್ಲ ನಾಡಿದ್ದು ಮಂಡೇ.
ಇಲ್ಲ,
ಹಾಗಾದ್ರೆ ಡೇಟ್ ಬೇಡ.
ಓಕೆ ಓಕೆ.
ಜಸ್ಟ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ ಮೂವ್ ಮಾಡಿ.
ಆಯ್ತು. 99.
ಪೆಟಿಷನರಿಗೆ
ಹೇಳಿ
28ಗೆ ಹಾಕ್ಬಿಡಿ. 28
27 ಮೇಡಮ್.
27th ಆಗಲ್ಲ, ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇರುತ್ತೆ, ಮತ್ತೆ ಲಿಸ್ಟ್ ಆಗಲ್ಲ. 28ಗೆ ಹಾಕಿ.
100 27th ಗೆ ಕೊಡಿ ಸರ್.
101. 27 ಆಯ್ತು. 102.
27ಗೆ ಹಾಕ್ಬಿಡಿ ಸರ್.
103. 24ಗೆ. 24. 104. 24. 5. 106. 107.
ಸರ್ 24
24.
108.
14 ಕೊಡಿ ಸರ್.
110.
109
109 ಆಗ್ಲೇ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಿದೆ ಬೆಳಗ್ಗೆ.
ಡೇಟ್ ಇಲ್ಲ, ಸಾಹೇಬ ಕೊಟ್ಟರು. 110. 111. 12. 13. 13.
113 ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಬೇಕು ಸರ್. ಆಗತ್ತೆ.
14.
14
114.
14 240
24. 15.
ಅದು ಅಷ್ಟೇ.
24. 116.
ಸರ್ 116 ಅಲ್ಲಿ GMCPC ಸ್ವಲ್ಪ ಕಡಿಮೆ ಯಾವತ್ತು ಇರ್ತಾವ ತಾಕೊಡಿ ಶಾರ್ಟ್ ಡೇಟ್.
ಶಾರ್ಟ್ ಡೇಟ್ ನಾನು ಶುರು ಮಾಡೋದೇ 27ರಿಂದ, ಅವತ್ತಂತೂ ಹೆವಿ ಇದೆ. ನೆಕ್ಸ್ಟ್ 1, 2, 3 3ನೇ ತಾರೀಕು. 117.
3 ವರ್ಷ.
ಸರ್ 117 24 24
118. 119. 120. 121.
ಕೋಡ್ ಆಫೀಸರ್ ಸರ್, ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 94 ಒಂದು ಯಾರ್ ಡೇಟ್?
ಹೇಳಪ್ಪ ಇವ್ರು ಇವ್ರದ್ದು ಅಟೆಂಡ್ ಮಾಡ್ತೀವಿ ಹೇಳಿ.
78 ಅರ್ಜನ್.
ಕೋಡ್ ಆಫೀಸರ್ ಸರ್ 94 ಒಂದು.
94 ಮೇಡಮ್. 27
ಅರ್ಜನ್ ಆಗಿದೆ. ಡೇಟ್
Okay,
ಬೇಕು ಅಂದ್ರೆ
sir.
27.
ಕೋರ್ಟ್ ಆಫೀಸ್
27 ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 99 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
99 ಮೇಡಮ್ ಅರ್ಜನ್ ಅಷ್ಟೇ, ಡೇಟ್ ಇಲ್ಲ.
ಸರ್
ಸರ್ ಡೇಟ್
94
ಕೊಡಿ
ಒಂದು
ಸರ್.
ಡೇಟ್ ಹಾಕ್ಬಿಡಿ ಸರ್.
ಅದು ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ, ಒಂದ್ ಡೇಟ್ ಕೊಡಿ.
ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ.
ಇಲ್ಲಪ್ಪ, ನಾನು ಇವತ್ತು ಕೊಡ್ಬೇಕಾಗಿರೋದೇ 27ಇಂದ. ಬೇಡ ಅಂದ್ರೆ ಅರ್ಜನ್ ಮಾಡ್ತೀನಿ.
27ಗೆ ಕೊಟ್ಬಿಡಿ ಸರ್. 94
99
94 ಸರ್ 94.
99.
ಎಸ್ ಮೇಡಮ್. 94 27.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 99
ಅದು 27 ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
28 ಹಾಕ್ಬಿಡಿ. 27 ರೀಚ್ ಆಗಲ್ಲ.
28 ಫ್ರೈಡೆ ಬರುತ್ತೆ ಮೇಡಮ್. 14 ಹಾಕದಾ?
14 ಸರ್ 24 ಹಾಕ್ಬಿಡಿ.
24
ಹಾ
ಓಕೆ 24.
ಅವ್ರದ್ದು ಇಂತ ಅಂತ ಇದ್ದೀರಾ, ಅವ್ರ ಬೆಳಗ್ಗೆ ಬಂದು ಮೂವ್ ಮಾಡ್ತಾರೆ. ಆಯ್ತು. 22. 27 3 ಇದೆ. ಬೇಡವಾ? ಮುಂದಕ್ಕೆ ಹೋಗ್ಲಿ ಇನ್ನ. ನೀವ್ಯಾರು ಬಿಡಪ್ಪ, ಅವ್ರು ತಗೊಂಡು ಹೋಗಿದ. ನೀವು ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲ, ನೀವು ಯಾರು ಕೊಡಕ್ ಬರಲ್ಲ. ನನಗಿರೋ ಪ್ರಾವಿಷನ್ ನಾನು ಹೇಳ್ಬೋದು. ಎಂಟ್ರಿ ಮಾಡ್ರ ಬಗ್ಗೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ತಲೆ ಕೆಡ್ಸ್ಕೊಬೇಡಿ. ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ, ಬ್ರೇಕಪ್ ಇದ್ರೆ ಬರಲ್ಲ. ಕೇಳಿ ಹಾಕಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 90
27 3 ಅರ್ಜೆಂಟ್ ಡೇಟ್ ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ ಅವ್ರು. ಯಾವ ಡೇಟ್ ನೀವ್ಯಾರು? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದೆ. ಯಾವ ಡೇಟು? ಆಯ್ತು, 2 ಏಪ್ರಿಲ್.
ಸರಿ, thanks.
ಆಮೇಲೆ RFA ಸದ್ಯಕ್ಕೆ ಯಾವ್ದು ಪೋಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್, ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದೇ ಕೋರ್ಟೆ ಇದೇ ಇದೀವಿ 2 ತಿಂಗಳಿಂದ, ನಮ್ಗೆ CPCನೇ ತಪ್ಪಿಸ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಇನ್ನು RFA 1 ದಿವಸ ಅಂತ ಹೇಳಿದ್ರು, ಈಗ ಆ ದಿವಸನೂ CPC ಕವರ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ವಿ. ಇಲ್ಲ ಸರ್, ಈಗಿಲ್ಲ, ನೋಡೋಣ. ಈ CPC ಎಲ್ಲ ಬರ್ಡನ್ ಕಡಿಮೆ ಆದ್ಮೇಲೆ ಸಾಹೇಬ್ರು ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತಾರೆ, ಅವಾಗ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ, ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತೆ. ನೀವು ಮೆಮೊ ಕೊಟ್ಟಿದ್ರೆ ಸೀನಿಯಾರಿಟಿ ಕೌಂಟ್ ಆಗುತ್ತೆ. VCL ಯಾರು? ಮೆಮೊ ಕೊಟ್ಟಿರಿ, ಸೀನಿಯಾರಿಟಿ ಕೌಂಟ್ ಆಗ್ತಾ ಇರ್ತದೆ. VCL ಯಾರು?
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 90.
ಸೀರಿಯಲ್ ನಂಬರ್
90.
90. ಹೇಳಮ್ಮ, ಯಾರಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ನನಗೆ ಸರಿಯಾಗಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 90 ಸರ್.
ಏನು
90.
90. ಅಡ್ಜನ್ ಆಗಿದೆ. ಡೇಟ್ ಏನಾದ್ರು ಬೇಕಾ?
ಎಸ್ ಸರ್.
ಡೇಟ್ ಕೇಳಿ. 27 ಮಾರ್ಚಿಂದ ಯಾವ ಡೇಟ್ ಬೇಕು ತಗೊಳ್ಳಿ, ಫ್ರೈಡೆ ಬಿಟ್ಟು.
ಎನಿ ಡೇಟ್ ಸರ್.
ನೀವ್ಯಾರು?
ಏಪ್ರಿಲ್ ಕೊಡಿ ಸರ್.
ಆಯ್ತು, ನೀವು?
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಆಯ್ತು, 2 ಏಪ್ರಿಲ್.
2 ಏಪ್ರಿಲ್.
ಆಯ್ತನಪ್ಪ, ಎಲ್ಲಿಂದ? ರಿಂದ 68. 1 ನಿಮಿಷ VC